Okay, great. Good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Tuesday, February 2nd, 2021. We have 10 bills on the docket today, and we'll start off with Senator Huff with Senate Bill 27. We'll then move on to Senate Bill 15. Third will be Senate Bill 221. Fourth will be 292 with Senator Beidel. Fifth will be Senate Bill 327. Sixth is Senate Bill 335. Seventh is 134. Eighth is 162. Ninth is 311. And then 10th with Senator West, it's Senate Bill 189. So with that, Senator Huff with Senate Bill 27, you are up.
Thank you very much, Mr. Chairman and members of the committee. Senate Bill 27 is a very simple bill. It just states that self-protection is a good and substantial reason to obtain a wear-carry permit. This bill leaves unchanged all the training and background requirements, fingerprinting, and other legal requirements to wear and carry for wear-carry permit. It brings Maryland in line with 42 other states, plus the District of Columbia, that are all shall issue states. 14 states are actually currently constitutional carry. That just means that law-abiding citizens can carry without even having to go through the permit and background training. This bill doesn't require that. It doesn't change the regime. It just changes the reason to allow self-protection. Currently, our state carry permit requires a, quote, good and substantial reason. We have unfortunately turned over the responsibility on what that definition is to the Maryland State Police, who are, unlike us, unelected officials, and they, through regulation rather than law, define what is the Second Amendment for our Maryland residents. The United States Court of Appeals for the District of Columbia struck down DC's good reason, their similar statute requirement for carry permits in the Wren decision in 2017. DC versus Heller held that citizens have the right to possess operative handguns for self-defense. Heller also made clear that the right belongs to law-abiding citizens. I believe that allowing law-abiding citizens to protect themselves, their families, and their property will increase safety in Maryland. There is little evidence to the contrary. In fact, Pennsylvania issues, as of 2017, had issued 1.27 million permits, and their firearm death rate was 11.7 per 100,000, and that's via the CDC, and that includes all firearm deaths. Virginia, which has 429,000 permits, had a same rate, 11.7 firearm deaths per 100,000. Whereas Maryland, where we issue a fraction of that, somewhere around 12 to 14,000 permits, our rate for firearm deaths was well over 12 per 100,000. And finally, I will just say that this bill conforms with what the founding fathers envisioned when they added the Second Amendment to our U.S. Constitution, which states the right to keep and bear arms, and quote, the important part of that is bear arms shall not be infringed. For these reasons, I urge a favorable vote on Senate Bill 27.
Excellent. Thank you very much, Senator Huff. And we'll move to your primary witness, which is Mr. Pennick. Mr. Pennick, you're up next. You have 5 minutes. Good to see you.
Thank you, Mr. Chairman, members of the committee. It's a pleasure to be here today. You have my written testimony, and to that written testimony, I've attached the June 4th, 2020 study conducted by Johns Hopkins University about Baltimore. Let me first echo everything what Senator Huff just said. And in the written testimony, you'll see study after study that indicates that firearms owners who have permits are the most law-abiding people on the face of the planet. That the expansion of carry rights in the last 30 years to include all 42 states and the constitutional carry in 14 states has not resulted in any increase in the incidence of violence with guns. So the underlying rationale for Maryland's highly restrictive system is simply not there. And in contrast, people with guns save lives. People with permits have saved lives repeatedly. But more importantly, let's just turn quickly to Baltimore. You now have, and this is documented by the Baltimore study, people carrying firearms because they understand that the police will not protect them. Law-abiding individuals are resorting to carrying the firearms out of sheer necessity, because they understand that they cannot rely on the police to protect them from violent crime. That is in itself is a stark testimony to the need to exercise fundamental rights in the city of Baltimore. Heller and McDonald both held that self-defense is a fundamental constitutional right. This is not an abstract right. It's very real in the streets of Baltimore. And yet this state, through its restrictive carry permit system, has effectively disenfranchised those citizens from being able to protect themselves. That's an outrage. So what we have here is you're criminalizing people who are forced to protect themselves, and in a situation where they have the very real and legitimate perception that if they do not carry firearms for that purpose, they may be killed on the violent streets of Baltimore. That's absolutely intolerable. You simply can't go on and continue to criminalize people who are otherwise law-abiding and make them criminals by virtue of the fact that they're trying to protect themselves and exercise the fundamental right of self-defense that Heller says exists. Now, sooner or later, Maryland's system will fall because it is in direct conflict with the Wren decision and the process of 42 other states. So we can't have the constitutional right meaning one thing in Maryland and another thing in the District of Columbia, especially where the District of Columbia copied Maryland's restrictive system, only to get struck down by the Federal Court of Appeals. So at some point, we will have a Supreme Court decision that will rectify that, and Maryland shall issue, in interest of full disclosure, is actually a party to one such suit now pending in federal district court. The rationale for that suit is to present this issue to the Supreme Court. There's already one case before the Supreme Court now, and out of the state of New York, that presents this conflict to the Supreme Court. So it was nearly resolved last year in a case called Correll, but the court and the New York State Rifle and Pistol Association refused to reach the issue what the standard of review is. If this court reaches the issue of the standard of review in any Second Amendment case, and I don't care if it's the Kerry case or some other case, then you will find that the court will probably, more likely than not, say it's carry restrictions like other restrictions are governed by text, history, and tradition. And there is simply no way that standard would allow Maryland's statute to survive. But in the meantime, I would urge you to act to protect otherwise law-abiding individuals in Baltimore who are forced to carry for their own self-protection. That the state allows this to continue and criminalize those who do so means that they're subjected to the lottery system of the state attorney's office, who by and large doesn't prosecute unless they feel like it. Simple illegal carry. But no one knows ahead of time. So it is a crapshoot, if you will, about whether or not you're going to be charged, and if you are charged, whether or not you're going to be convicted. Those statistics are set forth in the Hopkins study. I'm not making this up. So you have a state attorney's office who isn't enforcing the law that you wrote, and is not, to the extent it does so on a pretty much arbitrary basis.
Time.
So
Right.
with that, I would conclude my remarks.
Thank you, Mr. Pennick. And with that, we'll move on to Mr. Jocelyn. You are up next.
Good afternoon, Mr. Chairman, members of the committee. John Jocelyn speaking for 2A Maryland. Over the years, various bills have been proposed to define the nebulous term good and substantial. All have failed. I would note that there are 22 distinct licenses listed on the DLLR website. All of these licenses have very specific requirements and credentials you must have in order to get a license. This is very clear, it's easy to understand. However, when it comes to a carry permit, no such standards exist. We continue to struggle with the definition of a term that is yet to be defined. The Maryland State Police have tried to determine this. They have used various interpretations over the 5 decades this permit law has been in place. And as it varies, as they try to come up with what the intent was, we end up with a bit of a dichotomy as to what is and what isn't a good and substantial reason. We believe that the people of Maryland deserve better. We believe the Maryland State Police deserve better. They are not a legislative body. They should not have to make this decision. We believe that the only way that the law can apply to all is that when critical terms that have not been defined are finally defined. We believe that this is the time for the Maryland General Assembly to step up and place its faith in the people as the people of Maryland have placed their faith in them. We ask for a favorable report.
So thank you, Mr. Jocelyn. Next, we'll move on to Mr. Boston. You are up next.
Good afternoon, Mr. Chairman, members of the committee. I'm Frank Boston III. I'm here on behalf of the NRA, and support this bill, and thanks Senator Huff for putting it in. Before I read my testimony, because of time, I do want to make this point. If we had laws like this passed, I would not have lost a friend on Saturday. I had a friend, 58 years old, from Pikesville, who was out servicing ATMs at 11 a.m. in Baltimore City, comes out of the actual store, and he got shot, killed, and pronounced dead on the scene. Maybe had he had the right to carry firearms, maybe he would still be allowed today because he could protect himself. Senate Bill 27 would improve Maryland's permit regime by curtailing the state police's current unfettered discretion over issuance. The legislation would alter the public safety code to make clear that personal protection and self-defense are good and substantial reasons to carry a handgun. This change would create a fair and more predictable permitting process and would ensure that more law-abiding Marylanders could exercise the right to carry in defense of themselves, their families, and their communities. Maryland is an outlier on the right to carry. At present, 40 states and the District of Columbia have shall issue laws requiring that carry permits be issued to qualified applicants. Moreover, 16 states allow law-abiding residents to exercise the right to carry without a permit. As of June 30th, 2020, Maryland only had 27,760 active handgun wear and carry permits. Among states that are that have a permitting scheme, Maryland ranked 5th lowest in the number of permits granted as a percentage of the adult population. The Second Amendment protects the right to bear a firearm for self-defense outside of their home. In District of Columbia versus Heller, 2008, the Supreme Court made clear that the inherent right of self-defense has been central to the Second Amendment right. With that, Mr. Chairman, members of the committee, we ask for a favorable report on this bill. It is time.
All right, thank you very much, Mr. Boston. Looking around the committee for questions, and I just have one for either Senator Carter has a question.
Thank you, Mr. Chair. My question is short for Mr. Boston. I just was curious about the 58-year-old. I read about that in the paper, and what was so I trust he wasn't a business owner, although he was servicing the ATMs. So he wasn't, what was his role? What was his job? And why was he ineligible for a wear and carry permit?
Mr. Boston, you're still muted. Let me go ahead and
Yeah, can you hear me now?
We can.
Yeah, I don't know whether he was or wasn't eligible. I don't know that. I'll never get the chance to talk to him. Maybe I'll find out from family members. But I do know this is the perfect, type of situation. It's a perfect, sadly, a perfect example of, this is a businessman going to service an ATM machine. Had he been armed, maybe he could have protected himself. I don't know the facts of the intrinsic facts because it just happened on Saturday, but I do know he has kids, he's a family man, and he's not coming home to his family. This is just a good example of many people who are business people or just regular citizens who have a right and need to protect themselves.
Thank you.
Yeah.
Thank you, Senator Carter. Thank you, Mr. Boston. My new cousin, my niece married into your family, so we're family members now. But
Yes, we are family.
there you go. Well, good to see you.
Good to see you.
Senator Bailey, you're up next.
Thank you very much, Mr. Chairman. Mr. Pennick, I think this question might be more appropriate for you, but I was going to give you a couple scenarios. If you were a businessman in Maryland and you were going to transport money from your business to the bank, would this qualify as a good and substantial reason for you to get a handgun permit to protect your money?
The way the state police are currently interpreting the statute is that they will accord a permit to a business per owner only for the purposes of being the owner of the business. It's an unrestricted permit. His employees are restricted to the extent that they qualify, are restricted to the course of employment. So you would have to jump through all the hoops. And bear in mind, it takes over like 90 days to get a permit in Maryland. So it's hardly something one can get rapidly.
So if you were the owner of the business, it would be a good and substantial reason to be able to protect your money?
Yes.
Yes, okay. But if you were a military veteran, somebody that was trained, somebody that was experienced, and you put an application in simply to be able to carry a handgun that you wanted to just to be able to protect your family, being that you were home, you were here with your family, and you wanted to make sure that if anything happened, you'd be able to protect them. Would that be a good and substantial reason currently for you to get a handgun?
Most certainly not. The state police requires special circumstances for self-protection above and beyond the standard harm associated with being a citizen in Maryland. So you have to show actual proof of threats, documented proof of threats, and it has to be more than one. So the criminals kind of get freebies before you can actually get a permit in Maryland.
Thank you.
All right, thank you, Senator Bailey. Further questions from the committee? I just had one for either Mr. Pennick or Senator Huff. It was that, so in the, Senator Huff, in your opening remarks, or I think in Mr. Pennick, you may have mentioned this, that there may be another case moving forward. So in the Fourth Circuit, you had the Gallagher case back in 2013, Fourth Circuit decision, Supreme Court denied cert. And then you had the Palazzi decision, also Maryland case, denied cert. I think, and then obviously you have the Wren and Heller, obviously DC. So you've got a circuit court split on this issue, even regionally. But did one of you mention that there's another case either through the Fourth Circuit or Second working its way up
yes,
to the Supreme Court?
Mr. Chairman, there is a case pending for cert right now, and its citation is actually in my written testimony, in the docket number. So that comes out of the state of New York. It has a similar good cause requirement that's indistinguishable from Maryland's. So that's currently before the Supreme Court now. There's a case filed that MSI is a party to in federal district court, which is designed to work its way up quickly through the lower courts and to present the same issue with respect to Maryland to the Supreme Court. So one of these days, perhaps soon, with the change in membership of the Supreme Court, we hope the court will grant cert in one of these cases.
That was my second part of the question. It's a little bit of conjecture there, but just what is the composition of the Supreme Court, the new composition of the Supreme Court? What do you think that portends? But I think I got where you're going on that. Okay, great, interesting. We shall see. We shall not issue yet, but anyway, stupid joke. All right, with that, that'll conclude the hearing. Seeing no further questions for Senate Bill 27. Thank you, Senator Huff. All right, next we have Senate Bill 15 with Senator Bailey. Senator Bailey, you're up next.
Thank you very much, Mr. Chairman, members of the committee. Today, I'm here to introduce to you Senate Bill 15. This was a bill that you heard about last year. This has to deal with the notice of expiration and renewal notice when we're talking about actually a handgun permit. And so what this does is this says 60 days before the expiration of a permit is going to expire, the holder would receive a paper application. And so this issue came to my attention because of the fact that I had some constituents, as I'm sure we all have, who held handgun permits. This one constituent in particular received no notification of his permit until he realized that he was actually carrying a gun in violation of the law. Now, anyone whose permit expires must go through the entire application process again, just as if they were applying for a new permit, right? The fees apply just like it was a brand new permit. And so these permits do not all expire at the same time. Some permits, depending whether it's a new permit or a permit for a renewal, some expire 2 to 3 years, right? They're two different time frames. So what I wanted to explain to everyone is now the state police's system is completely automated. So for people that just applied for a handgun permit, they will be notified electronically, right? So what this has to do with is this has to do with the people that would be expiring this year and next year, people who applied using a paper application. But that paper application actually was an MSP form 29-01. Actually, on that application form, they had to provide since June of 2017, they actually had to provide their email address. So somewhere, those email addresses for the majority of these people exist. The state currently provides a renewal notice for every other license that I'm pretty much familiar with. If your driver's license expires, you can still go to MVA and get a driver's license. You don't have to take the driving test over again. You don't have to pay all the new fees, right? Same with your car registration. You don't have to get another, if your car registration expires, you don't have to go and get your car re-inspected. You don't have to start over from scratch. You just pay the renewal and your car gets re-registered. Just like a trailer registration, just like a boat registration. Just like we just talked about, where people had to provide a good and substantial reason, these people simply missed the deadline to renew. And that is what we were talking about. Now, as a former police officer, I'm going to tell you that this database, when we deal with this, exists. I can pull somebody over on the side of the road when I was a policeman, and I could call into the gun center and I would be able to find out if that person electronically had a gun permit and what the expiration date on that permit was. So that is what I'm trying to say, is there's only about 17,500 people who have already demonstrated a good and substantial reason for having a handgun permit to protect themselves. And the fact that we are not sending them a renewal notice like we do with everything else, right? This is not to be criminals. Now, I have requested an amendment to this bill because after last year, I thought how crazy this was, that the price that was associated with the physical note of this bill was so high. I said, well, we'll just send them a postcard. We'll reduce this down. Well, the one thing I found out about the postcard is postcard definitely provides some issues when we're talking about privacy concerns. So it can't be a postcard. So we have addressed this in an amendment so that it would be a mailing. But we also have addressed it that it doesn't have to be a mailing if they have an email address. We just want these people to be notified. I think this is very much a common sense. It's a small ask. I would say that the physical note associated with this, when you look at it, it is extremely high. But over the weekend, and as long as 10 minutes ago, I was just dealing with Secretary Jones on the phone. Of course, he's the Colonel of State Police, and we are addressing and working together to reduce this physical note and doing what they can do to try to address this issue. Obviously, I appreciate the work that our Maryland State Police does. I appreciate the together attitude that they have right now, and I hope that continues. I would ask for a favorable report on this bill. Thank you.
Thank you, Senator Bailey. And first, we have Mr. Pennick. He's the primary witness. So, Mr. Pennick, you have 5 minutes.
So thank you, Mr. Chairman. The I won't take 5 minutes. This is a very simple bill. It's a simple notice requirement. I have in my hand the form that I filled out in 2018. It is the form that Senator Bailey is referring to. It's SM Maryland State Police Form 29-01. I had to provide my email address on that form. So I know for certainty that the Maryland State Police have email addresses for every single person that has a permit covered by this bill. And it's a very simple matter to send an email. They intend to do this very email process, I am told, from the Maryland State Police, from their automated database. So this is a short-lived, basically fill-in type of requirement to notify existing permit holders so they don't lose their existing rights. And it makes a big difference because the renewal permit period for a original permit is 2 years. For renewal of an existing permit is 3 years. So it makes a big difference on how long your existing permit is. So if you have to start over from scratch, your permit will only be good for 2 years. You have to submit fingerprints again, where renewals of existing permits, you don't have to submit fingerprints again. So this is a massive change and the ability to actually get the renewal, that you have to jump through all these additional hoops with respect to these permits if you have to start over from scratch. It's easy to forget your renewal date. It simply is. I nearly forgot mine last year, and I happened to look down at my permit just to be sure, and I realized that I was fast approaching the expiration date. People have a lot on their minds, and this date is not high among that list. So allowing people to get notices from the state police that you're about to expire, that is something they intend to do in the future in any event, is something that ought to be accorded to the existing people who are already submitted paper reports and would otherwise not receive this kind of notice. So I would urge a favorable report for these reasons. Thank you, Mr. Chairman.
All right. Thank you, Mr. Pennick. And next we have Ms. Novotny. You are up next.
Hi, Senator, members of the committee. Thank you all for hearing this today. So I urge a favorable report on this bill. As everyone has said, it just makes common sense. And it's a short-term bill that has an end date that picks up where some other means of notifying people where that picks up. So I think it just makes a lot of sense. And like we get letters of our emissions inspection. If your driver's license expire and everything else, we get expiration notices. So it just makes sense to take care of these people and prevent a headache in the future. So thanks.
Thanks, Ms. Novotny. Senator Bailey, let's work on the fiscal note. Obviously, anything over 100,000 has to get reviewed this year, but we'll work on it. All right. Senator Sidnor has a question.
Thank you very much. And for Senator Bailey, this bill, it sounds familiar to me, but I noticed within the fiscal note that it said that it had not been introduced before. But I think in your testimony, you were referencing something about last year. Did we hear this bill last year, and what happened? You're on mute. I'm sorry.
Yes, sir. We did hear this bill last year, and we did not. It did not get out of the committee. So, and I appreciate that. And we did work on the note this morning, Mr. Chairman, to try to reduce it, and we're going to continue to work this week.
Excellent. All right. Good deal. All right. Well, then with that, seeing no further questions, that'll end the hearing for Senate Bill 15, and then we'll move on to Senate Bill 221. Senator Bailey, you're up again.
Thank you, Mr. Chairman. Now we're going to talk about Senate Bill 221, handgun qualification license, firearm safety training. This bill repeals the requirement that a firearms safety training course for a handgun qualification license includes a firearm orientation component that demonstrates the person's safe operation and handling of a firearm. The state police has interpreted the provision of the law that this bill repeals to require an applicant to fire a single round with a handgun before the HQL can be issued. This single round requirement does not demonstrate proficiency nor accuracy, and it requires an individual to travel to gun ranges to discharge a handgun. This same demonstration can be performed with dummy ammunition, where the person would show safe carry, safe loading, and safe firing of a handgun without having to travel to a range. The most significant barrier posed by this requirement is the difficulty it causes prospective HQL holders living in areas that have either few or no gun ranges for the prospective holder to carry out this live fire requirement. In these jurisdictions, it is harder, particularly for residents who have lower incomes and those who rely on mass transit to fulfill these requirements and obtain the HQL. I respectively request a favorable report on Senate Bill 221. Thank you very much for your consideration. I would say that we did file this bill last year. I would also say that as a firearms instructor for years with the police, that just firing one round does not prove anything. It does not teach these people anything whatsoever. This just stands in the way and is an obstruction for people to be able to protect themselves. Thank you.
Thank you, Senator Bailey. And next we'll have Mr. Pennick. You're up first.
Thank you, Mr. Chairman. I'm a HQL instructor. I teach the course. I cannot complete that course in the city of Baltimore because my students cannot satisfy the state police requirement. I want to stress that the state police requirement is not a statutory requirement. Back when 2013, the Firearm Safety Act of 2013 was enacted into law, the original bill was amended on the floor of the House to remove the live fire requirement, precisely because it created such a barrier to the acquisition of the HQL required by the statute. The state police then, by regulation, to which we strongly objected at the time, reinstituted the live fire requirement. Throughout the entire urban area of Maryland, including the city of Baltimore, most of Baltimore County, most of Howard County, almost all of Montgomery County, and all of PG County, there is no way you can legally fire a live round of ammunition except at an established range. There is no established range in Baltimore accessible to the public. That means no one in the city of Baltimore can acquire a handgun qualification license, which means that they may not legally acquire a handgun for self-protection in the home, which was the very holding of Heller that they have every constitutional right to do so. Now, MSI, in the spirit of full disclosure, have challenged the HQL, but in that litigation, the Attorney General has not contested there is a constitutional right to acquire a handgun for self-protection in the home. And yet the state police regulation, not this body, but the state police regulation, has made that virtually impossible for the poor residents who lack the means to travel to a range. Now, this doesn't affect the affluent. I mean, I give private courses and I charge handily for them, but that cost includes having to go to a range in which I can safely instruct live fire. I can't have it in my backyard, not in most of the urban Maryland. So who does that hurt? It hurts every one of your constituents who don't have the means to drive or travel out to a range. There's only one such range, by the way, in Montgomery County. That's Gilbert's. There are none in PG County. The ones in Baltimore County, there are a few of them, and they're well outside the city limits, well outside the ability to access by public transportation. So this regulation that the state police have imposed upon the population of Maryland effectively disenfranchises millions of individuals who may otherwise want to acquire a handgun qualification license. I would strongly urge a favorable report on this. Thank you, Mr. Chairman.
All right. Thank you, Mr. Pennick. And next we'll have Ms. Novotny. You're up again. There you are. I think you're unmuted.
Hi, thank you guys again for hearing this bill. So I also request a favorable report. So as referenced, this live fire requirement was removed by this legislative body. And it should be very disturbing to everybody that the Maryland State Police has taken it upon themselves to institute a requirement like this that directly opposes, choices that were made, with purpose. This was not an accidental oversight. It was clearly determined that, no, this is not required. And as has been referenced in other testimony, there are so many places in this state that are inaccessible. Add in, the past year of this pandemic and, the restrictions in getting to ranges. Now we're in the winter time. So some places that, you would maybe have access to an outdoor range. It's just not good weather right now. We've got how many inches of snow out there right now. So indoor ranges are restricting, the number of people. You have to get, an appointment. And I know the range near me, it sometimes takes up to 2 to 3 weeks just to get an appointment for 1 hour range time. And that's not even trying to get into a class. The demand right now is so high for these classes, as I'm sure everybody has seen, all the reports and news stories of, record gun sales. These are people that are also, trying to get their HQLs. And this just makes it incredibly difficult. If we got rid of this one-shot requirement, we could hold these classes and teach people basic gun safety, which is the intent of FSA 2013 and the HQL. This could be taught in libraries, people's homes, all kinds of different places where people don't have to travel to do this one-shot requirement. So request a favorable report. Thank you.
All right. Thank you, Ms. Novotny. And Senator Bailey, we had a Daniel Webster signed up. He's not here, so we're going to move on to questions. So Senator Jackson, you're up next, and then we have Senator Heddleman.
Thank you, Mr. Chairman. Just want to go back to the Mr. Pennick. You said that there was no range availability in Prince George's County.
That's correct, Senator. The two ranges are on the south edge near Waldorf. They're either just over the county line or just right next to the county line with the next county down. I think it's Calvert. So there's no way I can teach the HQL in PG County because local ordinance, which is permitted by state law, bans the discharge of firearms anywhere in PG County.
Well, let me just correct you on something. In Prince George's County, by the way, there is the Maryland Small Arms Range, which is in Upper Marlboro. So that is the place where training takes place from private security companies to civilian personnel to extra training for law enforcement and others. So
that is one range, that's true, and that range is restricted to people who have. I can't teach there, for example, because they don't open it up to other instructors. So their hours are, it's an indoor range, and their hours are highly restricted. So it's hard to get to that range.
Yeah, I just wanted to make sure that the testimony, that there is access in Prince George. So thank you.
Great. Thank you for that clarification, Senator Jackson. Now we'll move on to Senator Heddleman.
Thank you, Mr. Chairman. I actually wanted to ask something similar because I know in Baltimore County, in my district, there is the gun tree. And then in Middle River, there's a Free State gun range. And the gun tree is actually fairly close to public transportation from Baltimore City. So just wondering why those weren't options.
Well, they are options, Senator. Those are the two ranges that are, I'm familiar with both. I've been to both, that are closest to Baltimore City. And Gundry, it's very hard to get to. And for example, if you were to purchase a firearm at that federal firearms licensee, you wouldn't be able to bring it home because you can't take a firearm on public transportation in Baltimore. So the ability to actually travel to that is extremely inconvenient to people who live in Baltimore City. I live in Montgomery County and I teach this one live round in Frederick County where I'm not restricted to established ranges. And the people who live in Frederick County, Baltimore County, who have contacted me will not go all the way out to Montgomery, to Frederick County because it's too inconvenient. So it's basically a way of extracting a high tariff, if you will, that makes it very difficult to get to someplace to do one live round. Now, as a trainer, I can tell you one live round teaches nothing, absolutely nothing. So you have no benefit associated with this requirement while imposing severe barriers on people who otherwise can't get to ranges or have a hard time getting to a range. So what is the benefit and what is the cost? And the cost is a burden and an obstacle, and there's no benefit.
Should we make it more than one live range? I mean, one live round?
The state police do not require that, and this body removed the requirement of proficiency passed the 2013 Act, precisely for these reasons, by the way. So by making people jump through this hoop to get to a range to fire one live round to get the HQL accomplishes nothing.
Thank you.
All right, Senator Sidnor.
Thank you very much. So in looking at the bill, the language that this bill would remove from the statute is a firearms orientation component that demonstrates the person's safe operation and handling of a firearm. And as I'm listening to your testimony, we're talking about a live round. Is that what this language is being interpreted as?
Yes, so the state police have interpreted that to add in the regulations an additional component, a practice component to include one live round. Now, we would be open to an amendment that kept that language and prohibited the state police from requiring one live round. That is the intent of the bill. I can perfectly well demonstrate the operation of a handgun using snap caps, dummy rounds, and real firearms, of which I have a number for purposes of instruction, without firing one live round. So the purpose of removing that language is to negate the state police regulation that has interpreted that language to impose a practice component of one live round. So I'm open to any kind of language that would eliminate the one live round, the live fire requirement, and retaining the other requirement as long as it didn't include a live round requirement.
Because just on its face, the language looks like it makes some common sense to me.
Well, the language does on its face, and unfortunately,
Right.
It's been misinterpreted by the state police.
Which leads me to my next question. If it's a regulation that's been created by the state police, I'm curious, have you all had made any efforts to have that regulation changed, and what's happened?
So when they first put that regulation out for notice and comment, we filed a strong objection to that proposed regulation. We have actually filed suit in the federal district court in which the live round requirement is front and center. It on grounds that is part of a system that acts as a barrier to the right to acquire a firearm. So yes, we're challenging it in court right now. We also challenged it on state law grounds because it exceeded the state police's authority. The Court of Appeals for the Fourth Circuit, even though it held that we had standing to make the constitutional arguments, held that we didn't have standing to make the state law claims, which I think was a wrong decision, but we're stuck with it. So we may well bring another suit in state court on that point. But in the meantime, this is still the barrier. It exists. So we're going to proceed with that, challenge the live fire requirement under the Second Amendment. And
Just out of curiosity, when was that case filed?
2016.
2016. And one last question, because if I'm not mistaken with these regulations, anyone is allowed to submit a proposal for regulations to be changed. Have you tried that recently?
We have not tried to propose changes because it is clear from their defense of the litigation in the MSI case that they're very comfortable and want to keep these regulations. We objected to those regulations back when they were first imposed, and our objections were totally ignored. The state police agreed with some of our objections on other grounds and actually followed them, but they ignored our objections to the live fire requirement completely, and they have since heavily defended those regulations in federal court. So you'll forgive me if I think it's kind of a waste of our time to ask them to remove them when they're defending them heavily in court.
And for Senator Bailey, have you by any chance had any conversations with the state police? Because I think I don't know if they've offered any testimony or not on this bill. Are you still on mute?
I'll unmute. There you go, Senator Bailey.
Thank you very much, Mr. Chairman. So as far as that actual requirement, no, we did have discussions, but they did not offer the fact to remove it. And I would say that in training a lot of police officers, live fire requirement when we do that is very important. But there are things out there in today's day and age, like simunitions, that we can do in a classroom environment that would make much more sense than this. And as Mr. Pennick said, you know, the whole issue is becoming familiar with the firearm. And we can do that through many practical loading, unloading, cycling, drills, dry firing. There are definite ways as an instructor, and I've taught hunter safety for years, teaching just children. There are many ways that you teach the safe handling. And the whole impetus behind this bill was the fact that making someone drive to a range, to pull up there, to walk in, chamber one round, fire it into a target, and whether they hit the target or not doesn't matter, and turn around and then they meet the requirement is quite frankly ridiculous. And that is why it doesn't make sense. It is just it is nothing in the law that requires this one round, and it's done quite frankly as a way to prevent people who already are able to demonstrate that they have this need, right, to protect themselves or their family. And that's why we did this. I think this is common sense. I would definitely be willing to work for amendments for that with you, but I just think we should stop trying to prevent people, right, to say, well, we'll do this, but they've got to take public transportation, which they can't carry a handgun on, as we all know. So thank you.
Thank you, Mr. Chair. Thank you, Senator.
Thank you, Senator Sidnor, Senator Bailey. And with that, that will conclude the hearing for Senate Bill 221. We'll now move on. I think I see Senator Beidel is here, so we'll move on to Senate Bill 292. Senator Beidel, you're up. Good to see you.
Thank you. And thank you, Chairman Smith and Vice Chair Wallstreicher and members of the Judicial Proceedings Committee for this opportunity today. This is my first bill hearing and my first time in your committee this year, so thank you for hearing my bill. This is a cross file, Senate Bill 292. This is a cross file from the House, and it's a civil action, and I'm not an attorney, so bear with me here. It's for tortious injury to a death of a pet, compensatory damages, but it's also known as Buddy's Law. And I think you're going to hear from Buddy's owner today. Buddy was shot, and the owner spent over $25,000 in care for Buddy before he passed. And so currently the law says you can only claim up to $10,000. And this would expand the amount eligible for claim up to $25,000. It's not for attorney's fees. It's for the value of the animal and the cost of the veterinary care. And so it just simply is going to extend the amount of coverage or the amount that someone can claim from $10,000 to $25,000, but it's only for vet bills and the loss of life. So I respectfully request a favorable report on Senate Bill 292, and I thank you for this opportunity.
Excellent. Thank you, Senator Beidel, and always good to see you in JPR. Always welcome here. Your first witness and the primary witness is Mr. Sanders. So, Mr. Sanders, are you here? There you are.
Yes, I am.
All right. Excellent. Floor is yours.
Thank you so much, and I appreciate the chairman and the committee for hearing this today.
We brought this up last year, but due to COVID, it never made it out. Things getting cut short. And I just want to say, my name is Lawrence Sanders. Buddy was a family member. Buddy was fun-loving, caring pet, and he used to sleep in bed with me and always slept upside down. And I mention this because when they sleep like this, it means that they feel safe and content in their environment. On the evening of June 20th, 2018, this piece was destroyed by the neighbor next door who shot Buddy with a pump BB rifle. Buddy later had an operation to remove the copper BB that went through his spleen and his intestines. The cost for Buddy's medical care was extensive, and Buddy still died on June 30th from sepsis and the wounds he suffered from being shot. Currently, the maximum penalty in civil court is $10,000 because pets are considered property. And as you can see, this would not even come close to what we spent trying to save Buddy. This bill came up in the 2020 General Assembly, and the committee then thought, at least in the House, that $25,000 was still too little. And after looking into things more, and that things like service animals, protection animals, and also canine obviously would cost a lot more, and therefore the $25,000 still may not be enough. In addition to this cap placed on property, this law would make it so that law enforcement could actually do their job. The detective was not able to interrogate the people who we knew that shot Buddy, and as they really did not even have to answer the door, go to the station for questioning or anything else in that matter. By removing pets from property category, this would give the police and detectives more power. As a result, we have had to take this matter to civil court here in Anne Arundel County, and our date has changed many times because of COVID and is now scheduled to take place in August of 2021. I would like to ask that this law, when enacted, be signed into law no later than June 1st of 2021. And I applaud the efforts and concern for our pets, as they are simply more than that. They are family. I promised Buddy, while he was on my lap dying, that I would get justice for him, and even if it was the last thing I would do. The loss of Buddy has left permanent damage on our family. My son suffers from anxiety now and massive depression. I can't even think about him without coming to tears. And meanwhile, these people just think they've done nothing. And, you know, 15,000, 10,000, 25,000, until somebody feels pain. And unfortunately, some people, money is the only thing that they have that can cause them pain. And again, the cost of veterinarian medicine, emergency care, I mean, we went through it all, is so expensive today that I do feel that $10,000 is way too underestimated. And I thank everybody. We look forward to a favorable response from this committee.
I appreciate it, Mr. Sanders. Thank you for sharing your story, and thanks for being here and for testifying.
I do have a picture of Buddy, if anybody would like to see it. Buddy, as a fun-loving member of our family. And then this was Buddy just before, let's see where I can get this on here. Oops. I hate these things. Where's the camera? Oh, there it is. And that was Buddy right before he passed. He had a feeding tube. It was just horrible. And I think we really need to do something to bring this matter forefront, that it's not just an animal, it's people's pets, it's part of their family.
No, I appreciate that. That's one of the benefits of Zoom. We get to see a beautiful picture, and thanks for sharing that with us and for taking the time to share your insight and your story. Thank you for that. And with that, we'll move on to, we have Fernando. I think I saw you there. There you are.
Yes, Mr. Chairman, I'm here.
There you are. You're up next.
Good afternoon, Mr. Chairman, Senator Bidle, and the Senate Judicial Proceedings Committee members. My name is Fernando Guerra, and I represent the Animal Law Section of the Maryland State Bar Association. The section is in support of Senate Bill 292, which is otherwise known as Buddy's Law. Veterinary care costs are increasing exponentially, both for basic care and emergency and specialty care. This is in part because veterinarians now use a lot of the same diagnostic machinery, surgical options, and medications that we humans enjoy. In fact, the American Pet Products Association indicated that Americans spent almost $1 billion more on veterinary care in 2020 than they did in 2019. Examples like Buddy's demonstrate the real world effects of these rising costs. As you just heard, Buddy's owner was left without remedy to recover over $5,000 of medical bills that were beyond the $10,000 cap. And this, of course, doesn't take into account any of the emotional toll that this took on himself or his family, as he stated. Of course, raising the cap is no guarantee that a judgment is going to be higher. The burden still rests with the pet owner to demonstrate that the damages sought are justified by the fair market value of the pet, or that the veterinary care was reasonable and necessary. And so these requirements, in conjunction with the $25,000 cap, should ensure that any awards under Maryland Courts and Judicial Proceedings, Section 11-110, would not be excessive or unjust. The section thanks the committee for its interest in strengthening Maryland's animal laws and urges support for Senate Bill 292. Thank you.
All right, thank you very much. And next we'll have Mr. Wildberger. You're up.
Good afternoon, Mr. Chairman, Mr. Vice Chair, and committee members. David Wildberger on behalf of the Maryland Association for Justice to urge a favorable report on Senate Bill 292. The issue of whether a pet is property is an interesting one. If they are property, they're a unique type of property. They're property that can love. They're property that can be loved. They're property that become part of our family. They become our best friend. And they are, in fact, special to us in such a way that when pressed to try to save their lives, we take them to pet ERs. We spend thousands upon thousands of dollars, and justifiably so. Anyone who has taken a pet to an animal ER and had surgery knows how many thousands of dollars all of this can add up to. It is only fair that if someone causes the need for those veterinary bills, or they, God forbid, kill the pet, that they be responsible for compensatory damages, just as the bill says. And frankly, I think that's only fair. I think $10,000 is too low. We've seen that for Mr. Sanders' case, and $25,000 is much more reasonable. And I do urge you to favorably report this bill. Thank you.
Excellent. Thank you, Mr. Wildberger. Next, we'll have Mr. Tully.
Yes. Good afternoon, Mr. Chairman, Mr. Vice Chair, members of the Judicial Proceedings Committee. My name is George Tully. I'm also here, and I thank you for the opportunity to present testimony in support of this bill. The Senate bill would increase the cap on compensatory damages associated with the death or destruction of or injury to a pet. The cap, unlike many of the caps that we have on damages in Maryland, this cap doesn't include any kind of automatic increasing, the way, for example, the non-economic damages caps increase by a certain amount every year automatically. As a consequence, it is going to be required from time to time for the legislature to adjust the cap to reflect reality. And that has happened now several times in the history of this particular statute when there is a case like Mr. Sanders' case that's just unfair. There's, frankly, it's the only kind of property I'm aware of where there is a law capping how much you can recover for in terms of damages to repair the property, which is essentially what veterinary services are. If somebody destroyed your car or damaged your car, you take it to a mechanic, you get reasonable and necessary repairs, and those are submitted to the court and to a fact finder, and you recover those whatever they are. There's no cap on that. There's no cap on damage to a house. There's no cap on damage to any other kind of property. but there is a cap here. Now, as the committee knows, the Court of Appeals, or the Court of Special Appeals rather, have wrestled with what does this cap mean. They have held, as this committee is certainly aware, that it's not just that there are other damages like pain and suffering damages in inappropriate cases that can be recovered in addition to the cost of veterinary care. But veterinary care is capped by this statute. And because it's capped and because it doesn't increase, it needs to be adjusted. That adjustment is a reasonable adjustment. It reflects the exponential growth of veterinary bills. There's certainly been no evidence submitted in opposition to this bill last year or this year in the House. The veterinary bills are not appropriate in Mr. Sanders' case, and 25,000 is an appropriate number. And we ask that it be adopted and that a favorable report come out. Thank you very much for your time.
Thank you, Mr. Tully. And Senator Bidle, you had, well, actually, sorry, in the opposition panel, Mr. Enton was signed up, but I don't see him here. And so we will move on to questions from the committee. And seeing none, that will conclude the hearing for Senate Bill 292. Thank you, Senator Bidle. See you later. All right, next we'll move on to Vice Chair Wallstreicher with Senate Bill 327. Jeff, you're up.
Thank you, Mr. Chairman, members of the committee. Some things that are great on their own can be made even better in combination. Peanut butter and chocolate is my favorite example. So it is also true with the wonderful Bar Association section councils. The elder law section does great work. The Estates and Trusts Section Council does great work. What happens when you combine the brightest and most experienced members from each and bring them together in an effort to better protect vulnerable adults? What you get is the Vulnerable Adult Exploitation Joint Task Force. They formed 18 months ago in 2019 to figure out how our laws could make sure older adults aren't taken advantage of, and what should happen in our civil system if they are. The last 9 months have been spent drafting and redrafting the bill you have before you, SB 327. With an enormous amount of stakeholders, this bill has been combed over, vetted, and workshopped. Over that time, they met at least every other week, often as frequently as once a week. An enormous amount of time and experience has gone into this effort, and what you have in front of you is that work product. The bill may be long in length, but the core of it is actually quite succinct. Let me draw your attention to section 13-603, which is on page 6 of the bill, lines 16 through 21. And it says simply, a vulnerable adult who has been subjected to financial exploitation in the state, or in accordance with section 13-604 of this subtitle, a person acting on the vulnerable adult's behalf may bring a cause of action against a person who has committed financial exploitation against the vulnerable adult to recover damages and obtain other appropriate relief as set forth under this subtitle. The rest of the bill, which you'll hear more about from advocates and experts, simply lays out the purposes, definitions, and mechanisms to allow that core right of action to take place. Each of us has elderly folks in our districts, and many of us have received panicked calls from constituents who believe a vulnerable family member has been taken advantage of. You can refer them to the state's attorney's office, yes, but what about a comprehensive, thorough civil process? This bill protects those elderly and vulnerable constituents. I ask for a favorable report.
Well, thank you, Vice Chair Wallstreicher. And for your primary witness, we have Michael Davis. And Mr. Davis, you have 5 minutes and you are up.
Thank you very much, Mr. Chairman. Thank you, members of the Judicial Proceedings Committee, and thank you, Senator Wallstreicher, for putting this case before this committee and for all of your help and your wonderful words of introduction. Yes, we came together 19 months ago, and we were charged with trying to find ways to help the vulnerable adults in Maryland. The financial exploitation is hard to measure the damages that are caused each year. Some people say it's tens of millions, other hundreds of millions of dollars, But in any case, it could be considered the crime of the 21st century. And so what we want to do is find out how we could fix that. And most of the remedies in Maryland right now are traced to criminal proceedings. And they have not been very effective for a number of reasons. But to give you some idea, in 2019, the Maryland State Commission on Criminal Sentencing reported that only 15 people were sentenced for the whole year. The judiciary advised that there were 47 violations in district court with only 2 criminal dispositions and 55 violations in circuit court with only 8 guilty dispositions. And Department of Public Safety indicated that only 18 people total were intakes into parole and probation. Only 1 was actually sentenced to jail. That doesn't give you much of a result for all the efforts that have gone into this. And that's not to be unexpected. The criminal justice system is a very, very important tool in the toolbox, but there are 3 huge barriers to using the criminal justice system. One is that victims hate to involve the police in family situations. It's just not like them to want to call the police on their daughter, on their cousin, on their caretaker because of money being lost. There's a real reluctance to do that. Secondly, to go in the criminal system, any cause of action must be proven by beyond reasonable doubt, which is a very, very high standard of care or burden to prove. But it's even harder considering the environment that is coming out of a dysfunctional family. And thirdly, there are limited resources. As Senator Wallstreicher indicated, the Office of State's Attorney does take some cases, but they have limited resources. The same with the Attorney General's office, same with Adult Protective Services. These are the agencies charged with bringing these cases forward, and all of these agencies are very underfunded, and they don't really have the resources to do that. So we had to come up with an answer. How do we do that? Well, we developed the Maryland SAFE Act, and we did this by basically doing several different things. One is we statutorily codified financial exploitation. And we defined it based on real life expectations, real life terms. And I think Adam Spence will go into further detail on that, but it's a much broader definition than under the criminal statute. We also added remedies that don't currently exist. Right now, if you go to court, you might be able to get compensated, but you cannot get attorney's fees or treble damages. We've added those to the process so that we might be able to encourage more attorneys getting involved in going after these cases. Thirdly, the burden of proof is reduced to that of the tort level of proof, which is the preponderance of the evidence. And what's really important about this case or this bill, it does not rely on any state funding or state resources to work. So we urge you to support this bill so that we can get the protections the vulnerable need in Maryland. And before I close, I want to mention there were 2 amendments that were submitted. One is to remove punitive damages, and the other, and that one actually came from the Assistant Attorney General from the Department of Aging, who suggested we remove that. And the other one came from the Maryland Bankers Association, which after long discussions, we agreed with them that we would go ahead and accept their amendment. And I think those will be presented to you by Senator Wallstreicher in due course. So we urge you, please give a favorable report to this bill so that we can move forward and help the vulnerable adults in Maryland. Thank you.
Excellent. Thank you, Mr. Davis. And next, we will have Mr. Spence. Adam, you are up.
Thank you, Chairman and members of the committee. I'm here today in support of Senate Bill 327, as mentioned by my colleague, Mr. Davis. Senate Bill 327 is a massive effort by a considerable number of attorneys to end financial exploitation or address financial exploitation, which is a massive problem. As Senator Wallstreicher mentioned, Section 13603 is really the heart of the SAFE Act. It creates a cause of action, and it would basically be financial exploitation or statutory financial exploitation. What Mr. Davis mentioned is that Section 601E clarifies and in fact codifies existing Maryland law. And one of the important parts about this bill is it's not creating new statutes or new legislation in the sense of a new cause of action. What it's doing is basically giving new remedies for existing law. So in 601E, we clarify what financial exploitation is. In the criminal statute, you have deception and fraud. In Maryland law, however, financial exploitation is actually much more nuanced, and it involves when you take advantage of somebody when you're in a position of trust. When you use deception, that's a second category. But then if somebody is unable to consent and somebody runs off with their money, these are 3 areas that the courts have time and time again recognized as financial exploitation. So we do get to codify that Maryland law. And then what we do is in section 13604, key provision is we expand or actually identify the types of people that can bring this action, because oftentimes the victim may not be able to speak for themselves. So we're giving the family members and powers of attorney and caregivers the ability to bring this action. This is, again, based on existing law, very similar, section 17103 of the Power of Attorney Act in the Estates and Trust article, which lists specific people that can bring an accounting action under a power of attorney. So again, we're drawing from existing law, not creating new law. And as an aside, a lot of this law was based on model American Bar Association. It started there, and then we looked at other state law, and then we looked at Maryland law to develop this very articulate statute. So once you get into that definition of who can bring an action, that would include governmental entities, which the AG may have a friendly amendment to say we want to specify the office that can do that. We have no objection to that. But that's where the existing law ends. Right now, as Mr. Davis said, someone's exploited, they might get their money back, but they're going to pay fees, and there's no deterrent effect. It's simply no harm, no foul, here's your money back. The key provision of the SAFE Act, which is something that we're all...
You can go ahead and briefly conclude, Mr. Spencer.
Okay, the key provision is 605, which gives the right of attorney's fees and also treble damages. This again is modeled after existing statutes, the Consumer Protection Act 13-408 of the Commercial Law article, and then also the Wage Payment Collection Act, section 3507.1 of the Labor and Employment Title. So this is two public policy statutes that provide for this. And given the amount of financial exploitation, the public policy in support of this remedy and this law is tremendous. And that's in my written testimony as well. There's some studies that we've cited too.
Excellent, thank you. All right, next we'll have Mary Beth Beatty. Mary Beth, you are up. There you are.
Thank you, Chairman Smith. Vice Chairman Waldstreicher, members of the committee, thank you very much for allowing me to testify today. My name is Mary Beth Beatty, and I have an estates and trust practice in Rockville. I also am a member of the Joint Task Force, and I am testifying today in favor of the Maryland SAFE Act. As attorneys practicing estates and trusts, we are on the front lines of this issue. All of us testifying today who are attorneys and our colleagues in the bar have encountered victims of financial exploitation, often by family members or other trusted individuals. In most cases, the path to justice for these victims is not an easy one. Victims may lack funds, they may lack capacity or have diminished capacity, or some of them may just be too embarrassed or reluctant to involve law enforcement or other government agencies in their personal matters. So we believe the Maryland SAFE Act provides a clear path to justice for these victims and those working for their interests. I'll just give you a really brief example here. Not long ago, a client of mine, an elderly lady, was misled by one of her daughters and the daughter's brand new husband into transferring to them large parcels of a valuable farmland in Montgomery County for almost $500,000 less than the value of the property. After refusing to return the property when being asked by her mother, the daughter and her husband waged a campaign to separate her mother from her other daughters and also to demand more access and use of her remaining property and threatened to withhold affection and visits with grandchildren. As a result, my client suffered not only the financial abuse, but also mental and physical decline. The Maryland SAFE Act would have allowed my client, and if she was not able or even willing, her attorney in fact, to bring suit to recover the property taken from her. My client's situation falls squarely into one of the three definitions of financial exploitation, which are included in the Act. And the remedies provided by the Act would have made her whole. With this Act, cases like the one I just described will be easier to bring, easier to prove, and with the additional remedies provided to the victims, these cases may be easier to settle and also should serve as a deterrent to potential perpetrators.
Time.
I thank you for your time.
Excellent. Thank you very much. And next we'll have Mr. Polton. There you are.
Great, thank you. Good afternoon. Thank you, Mr. Chairman, members of the committee. My name is John Polton. I'm a Maryland attorney and practices estates and trust law. Thank you for giving me this opportunity to appear as a witness in support of this act. From my personal experience, I would strongly encourage the adoption of legislation to protect Maryland's elderly population from financial exploitation. About 10 years ago, Dorothy Papps, my 80-year-old second cousin, asked me to draft a will for her. She had no children and only one brother, a Catholic priest, who had died 2 years prior. She worked on an assembly line most of her life, and being a child of the Depression, had saved most of her earnings. Upon her passing, she wanted her assets to go to 3 charities in memory of her deceased brother. I drafted her will in accordance with the request, and she asked me to serve as her personal representative. On the same day she signed the will, she moved from her house in Fells Point, where she had lived her entire life, to a Catholic assisted living facility. She asked a parishioner of her brother's church to help move her to this facility. She also decided to change to a new bank on the same day, and the same person agreed to assist her with this task. At the bank, he suggested that his name be added to all of her accounts as a matter of convenience. She did not realize that she had in fact given him ownership of all the accounts, and by virtue of doing this, the recently executed will would be of little effect, and all of her assets would pass to this person instead of to the named charities in her will. Every day at the facility, she walked long hallways to the Alzheimer unit to volunteer to feed the residents who were unable to feed themselves. She was an extremely kind soul and a charitable person. She died on September 1st, 2008. In her sleep, and in fact, her body was discovered because she had not come down to feed the residents their breakfast. Shortly after her passing, I received a telephone call stating that the person who had moved her from her property was touting that he had just become rich as a result of her death. In fact, he withdrew all of her funds from her accounts on the day he learned she died. She had no connection with this person other than to help her move her property. At that time, there was no direct cause of action that I could bring, but I decided I would fight this injustice and sue the individual. After years of litigation, we reached a settlement that would make all the charities whole, but this would not repay the estate for the legal fees that were incurred. And in fact, he also reneged on the agreement, which caused further litigation to collect the debts he owed to the estate. I believe the proposed legislation will provide not only a cause of action, but also the ability to penalize individuals who take advantage of the elderly by compensating them for legal fees and possible treble damages. Thank you.
Excellent. Thank you very much, Mr. Polton. Next, we have, we'll switch over to the favorable with amendments panel. We have Mindy Lehman. Ms. Lehman. So Mindy is not here either. And then I have Mr. Enton is signed up, but I do not see Mr. Enton in the room. So with that, that'll conclude the panel testimony, and we'll switch over to questions from the members. I see Senator West and then Senator Castley. Senator West, you're up first. We can, Senator West, we could have unmute. So there you go.
Try again. Thank you. Thank you, Mr. Chairman, for calling on me. And I want to compliment the members of the organization that put this bill together. It sounds like a lot of work was involved. I like it so much, I'm going to ask to be a co-sponsor when we get to our voting session. But I do have a question, and that is on page 7 of the bill. It permits the plaintiff to require not only compensatory damages, but also punitive damages as set forth in subsection B. And then when I looked at subsection B, it says, all it says is the court may award an amount not exceeding 3 times the compensatory damages and pre-judgment interest. Let me pick on Mr. Spence, because his office is about 3 miles away from my house. So Mr. Spence, normally speaking, when punitive damages are permitted, a higher standard is set for recovering punitive damages than would be required in order to recover compensatory damages. In this case, I don't see a higher standard. It's almost as if you prove your right to compensatory damages, you're also entitled to punitive damages. Was that your intention, or do you think we should at least consider putting a higher standard there for the punitive damages?
No, and that's a good point, Senator West. And I would direct your attention actually to section 607 of the Act, which is on page 9, sub B. And what it specifically says is this subtitle is not intended to alter or amend the burdens of proof or presumptions required by law. So really, what we're trying to do is not change the law. We're effectively just codifying it to a degree and then also adding additional remedies. So we're really trying to leave the law intact, but just giving these additional avenues of remedy.
Okay, so you wouldn't be opposed to us adding some language in the section on punitive damages, which would advert to the normal standard for awarding punitive damages?
I think there was some discussion where we actually struck punitive damages, and that may have stayed in there. I think Mr. Davis may be able to address that.
Yeah, maybe Mr. Davis could address that. And also, I've gotten the notice that I'm required over in budget and tax for a bill. So I'm going to watch your response on video, but please complete the answer to the question. Thank you.
Thank you.
All right. Thank you, Senator West. Senator Castley, you're up.
Thank you, Mr. Chairman. So, look, I'm very much against any kind of manipulation of vulnerable adults, so please don't misconstrue my line of questioning here. I've done cases in this area and feel very strongly about protecting the vulnerable adult community. My concern is that I don't want to go the other extreme. You know, on the one hand, you're saying we're trying to tighten up and protect vulnerable adults, and we're going to arm some folks to come after people who we view as betraying vulnerable adults. But of course, it's also possible that when we arm those people, that they're they act in their own self-interest rather than the interest of the vulnerable adult, and we've simply transferred a problem from one group of folks to the other. So my question is, my concerns are really in that regard come to 13604 to whom are we vesting this incredible power to come after people who we feel may have abused, or not we feel, who feel they may have abused vulnerable adults, and give them the ability to recover damages, punitive damages, and attorney's fees, which, as we all know, just simply giving them those powers gives them a lot of power. Just the potential power creates power because it gives folks the ability to shake people around. And it doesn't just include lawyers who are sworn under the bar to exercise, appropriate power. This is any attorney, in fact, a guardian, a trustee, a fiduciary, someone who makes healthcare decisions for a person, a spouse, a parent, a decedent. Their presumptive heir, a person named a beneficiary to receive any property benefit or contractual right of the vulnerable adult. And after the vulnerable adult has died, their administrator or the special administrator, and even a governmental agency. So that makes me, I gotta tell you, just the breadth we're handing, it's like in the Old West where we say, let's create a posse here. And in some movies, the posse looks like a bunch of Boy Scouts, and in another Old Western, they call for the posse, and they look worse than the people they're chasing, and you're not sure which you have here. So what can you give me to make me feel comfortable that the posse that we're unleashing here won't stir up more problems? And I raise this because one of the preliminary comments to this bill was that we're not creating new causes of action, we're not creating new powers, we're just trying to, I'm not sure, beef this up a little bit. So maybe somebody can respond to that and make me feel a little more comfortable. Thank you.
Thank you, Senator Castley.
Mr. Spence would like to answer that.
Okay, great.
Very good. So absolutely. There's a couple things. One of the acts that this is modeled upon is the Power of Attorney Act. And we drew language from that because when you have a power of attorney, it's an incredible amount of power, as the Senator Kessley has noted. It's a lot of power, and you can do a lot of really bad things. And in fact, we've seen that in our practices. So what we've done is we've taken that same group of people. We haven't created anything different than what's in existing legislation. So if there was concerns about this here, those concerns have already been addressed by the adoption of the Power of Attorney Act. But I think the bigger question is, okay, well, put that aside and answer the question, as it were, which is, how do we know that this is going to be cautioned? Well, the first thing we see is 13605E, which is there's an attorney fee clause for the plaintiff who prevails, but there's also an attorney fee clause for somebody who brings it in bad faith. So if you have somebody that is the bad posse, as it were, they're going to be held accountable as well. And there's a certain natural checks and balances in litigation overall. Simply because you provide for a fee shift, as this does, doesn't mean litigation's free. Whoever walks into court on behalf of the elder or the vulnerable adult has to usually pay up front or have an arrangement with an attorney to do that. So there's almost a self-checking mechanism there. As a litigator who handles these type of cases, I've seen this, is a sibling comes to me and says, my sibling is taking money. And there's a check on that because you may be in litigation, as one senator, I guess it was Waldstreicher, said, for a year, and then they never got paid. So there's a self-check on that, I think, and I think that's really the way that's intended to work. I'm not sure if that answered your question, Senator.
Yeah, look, you know, when power like this is a lot of power. Your power to really, this is a big hammer. And when that's exercised by an assistant attorney general or by a state, you know, a local prosecutor, or even, you know, someone appointed by the court to come in and do an investigation, you feel a little bit of comfort there. And I'm just wondering why we wouldn't want to go with those kind of avenues, make someone like that the recipient of this awesome power, rather than trusting the discretion of every. That's a lot of people in here who are going to be pushing to go out. I mean, we even got folks who, you know, I could see in a state where I hold the right to sort of a future interest in the estate, so I can push this and I can use this as a cudgel to beat on the other folks in the matter to force them to go ahead and surrender the estate at this point, you know, or some a property right. It just I see where this thing could potentially be very much misused just by the threat of the litigation, because you're not coming in with a scalpel here, you're coming in with a great big hammer. And if I'm malevolent, I can misuse that power substantially to disrupt the normal lives of the rest of the family. If I'm that family troublemaker, or that one heir who's distant in the family, I could use this in a matter that's currently not quite available to me in the orphans courts, to really kick my fellow family members into submission. Does that concern us here?
Senator Casilio, I might take a shot at answering your question. You raise a really good question, one that we debated within the task force quite often during the 9 months or so we were going through the drafting process. Is how do you balance this process? We do need a bigger hammer out there. There's no doubt about it. Right now, the Consumer Protection Division, over the last 3 years or so, they have been doing some civil cases. And during that time, they've had 21 dispositions over those 3 years. That's not very much considering the breadth of the crime or the torts that are being committed right now.
Well, they're very busy with other matters. You have to excuse them.
Absolutely, and that's the whole point. We understand that.
I'm sorry, that was a low blow, but that's, hey, cheap shots are not above us. This is the Senate.
And then the offices of the state's attorney are also likewise. They really do have limited resources themselves, and we have found just over time. I'm going back 30 years and more. these offices rarely have the funds to really put in the effort to protect the vulnerable adults. Some counties from time to time, Montgomery County, Baltimore County, have had good efforts from time to time, maybe Howard once in a while, but it all depends who the state's attorney is and what efforts they want to do. And I don't think we don't want a system that's sort of dependent upon the personality and the resources of the state. And I don't know, we really want to build a large law firm within the state of Maryland to be able to manage these cases either, which is really, I think, what might need to be done to be able to get this accomplished. The other thing I'd like to mention is that we did agree to remove the punitive damages. We are not seeking punitive damages in this bill anymore. We were given the advice that probably was not a good idea, and upon reflection, we agreed with that. So right now, it is a fee shift for sure. We've asked, we've given the discretion to the court as to whether there is a fee shift on the one hand, and the court can also decide whether or not to award treble damages. But that's a court decision. It's not a given on any case. So that would, combined with the bad faith provision that Adam Spence was talking about, we think we sort of have a balanced approach here that can really go out and help vulnerable adults throughout the state of Maryland in a way that they have not had the help so far.
Thank you. I mean, I agree that removing the punitives takes us from a really super big hammer to a smaller hammer. I'll probably support the bill, but I hope that we all, I hope that it's one of those things we're going to have to see how it rolls out and how it's actually used. And I wouldn't be surprised to see this back in here in the after not many years saying, well, maybe we have to tighten this up, because we're unleashing a lot of power. That's just my one caution as a litigator. This is a lot of power we're unleashing here. So I hope we're not supercharging it too much. But thank you, ladies and gentlemen, for your work on this. That's all. Appreciate it.
Thank you, Senator Cassidy. Appreciate it. Appreciate the dialogue. Looking around the room, seeing no further questions, looks like that'll wrap up the panel and the hearing for Senate Bill 327. Thank you, Vice Chair Wallstreicher. We'll now move on to Senator Sidnor and with Senate Bill 335. So Senator Sidnor, you're up.
Thank you, Mr. Chairman, members of Judicial Proceedings Committee. I'm here to testify in favor of Senate Bill 335, which was drafted in the light of Rule 7.1 of the Federal Rules of Civil Procedure. This bill requires non-governmental corporate parties to file a disclosure statement with its first filings in a state lawsuit. The statement would identify any parent corporation of the party and any publicly held corporation owning 10% or more of its stock. Senate Bill 335 helps ensure transparency in several ways. Often in litigation, some business entities are able to shield who has an interest in the proceedings by refusing to identify its owners. Any corporate entity utilizing Maryland courts should not be able to keep those identities secret. This was an issue in a case that was in the papers over the past year, Smith versus Westminster Management. And I have one of the attorneys who was a part of that case who will be offering some testimony later. And what happened, this case was sent back to state court from federal court because the defending company did not want to disclose its members. Senate Bill 335 will also help judges better identify conflicts of interest with the parties that are before them. Finally, Senate Bill 335 will benefit Maryland's judicial system because it will make Maryland disclosure procedures consistent with federal procedures. Maryland courts in this regard should be as transparent as our federal courts. There's no just policy reason to allow corporate entities to conceal ownership interests in state courts, but require those disclosures in federal court. Transparency is essential to ensure a fair justice system. Senate Bill 335's disclosure requirements will greatly improve that transparency in Maryland courts, aligning Maryland's procedures with federal procedures, and just increases overall consistency in our judicial process, in which in this case will benefit everyone involved. I had looked over the testimony for those who are going to be testifying or have submitted written testimony in opposition to the bill, namely the Maryland State Bar Association, as well as Maryland Judiciary. I believe the items that the judiciary put forth are easily dealt with and can be dealt with regards to the State Bar Association's opposition. It seems to be more of a territorial type thing, and whether or not we as a Senate Judicial Proceedings Committee has the, or should have that authority to create rules, or whether it should lay with the courts or this type of rules. My response would be, if it's not currently a rule, I would suspect that our court system has had plenty of time to put one in place, and we certainly are not prohibited from doing so, and I think we should. In fact, I was watching 60 Minutes the other day, and they had a story on genetic genealogy. So, I mean, there's a bill that I have before this committee this upcoming Thursday. So I was watching with interest, thinking about that particular bill. But one of the things that caught my attention was a statement that was made, and it was talking about, and I'll read from the news story. It said, "But you may be surprised about another potential security risk. How much money foreign firms, particularly Chinese, are investing into US companies that collect our biodata," according to the former intelligence official, Bill Avenina. And this official, he says, "So the amount of effort that the Chinese government has put into investing in companies in the US, current estimates are 23 Chinese-based or affiliated companies are operating inside the US in consultation, collaboration, partnership, investment with US-based companies. China's reach has gotten so vast, it's drawn the attention of a little known but increasingly busy branch of the Treasury Department, the Committee on Foreign Investment in the United States. Among its duties is sniffing out suspicious business deals. Just a few months ago, a Chinese firm was set to buy a San Diego fertility clinic, in part because the fertility clinic is located near 6 US military bases. This particular committee on foreign investment, they blocked the sale before it could take place. I mentioned that, as well as, and while this was debunked, I know a number of elected officials had raised some concern about foreign investment in certain election equipment. Now, why do I mention this? Well, simply because of the way that our rules operate, people who don't mean us any good can sometimes hide behind corporate entities, or I should say business entities, where there's no transparency. This bill puts a stop in that place so that, again, what happened to Mr. Freeman, and he'll talk a little bit about this, what happened to him in federal court, and having someone moved from federal court so they could hide things, go to state court, it stops that from happening. So with that, what I'd like to do is to introduce former Judge Andre Davis, who will talk about his experience serving on the federal court and in this particular role. After him, then Mr. Freeman to talk about his experience, and batting cleanup will be Attorney Philip Robinson. So thank you very much, Mr. Chair.
Excellent. Thank you, Senator Sidnor. And so Judge Davis, you are up next.
Mr. Chairman and members of the committee, thank you very much for this opportunity. I am Andre Davis. I retired after 30 years as a state and federal judge and a 2.5-year term as the city solicitor in Baltimore. And I'm very pleased to support this effort. As the senator mentioned, transparency is the coin of the realm, not just in government, but in the judiciary as well. And on a certain level, members, this proposal is judicial housekeeping. You will rarely find a less controversial proposal. That said, it's still very important. Housekeeping can be very important. And so judges and litigants and the lawyers involved in litigation need to know as an imperative who has significant commercial interest in ongoing litigation. One additional factor that sometimes people don't pay a lot of attention to, as you all know, judges have law clerks, and the ethics rules by which judges are bound also bind their law clerks. And so this bill, Senate 335, will go a long way to helping judges in the state carry out their ethical responsibilities to ensure that they operate their chambers, whether at the trial court level or in the appellate level, operate their chambers in full accordance with the ethical mandates that Maryland law and practice imposes on judges. It won't cost anything, it's not burdensome, and it's a good way to ensure that transparency in the judiciary is actually achieved. The public has an interest in avoiding not just conflicts of interest, but the appearance of conflicts of interest as well. So thank you for the opportunity to address this issue.
Awesome. Thank you, Judge. And next we'll have Mr. Freeman. There you go.
Thank you. Thank you, Mr. Chairman, members of the committee. I'm Andrew Freeman. I'm a lawyer at the Baltimore firm of Brown, Goldstein, and Levy. And along with the Public Justice Center, I had the privilege of representing the plaintiffs in a class action, Smith versus Westminster Management that Senator Sidner mentioned. The case got some media attention because one of the owners of Westminster Management is Jared Kushner, along with his brother. But we never did learn the names of their business partners who owned these properties. So we filed suit in the Circuit Court for Baltimore City. Westminster Management, along with the other LLCs that owned these properties, did remove the case to federal court for Maryland in Baltimore. But at that point, the federal court enforced its rule and said, if you want to be here, you have to disclose not just the first level of LLCs, but they had sort of nested dolls, like Russian dolls of an LLC owned by an LLC owned by an LLC. The federal rules require that all of those be disclosed so that you'd actually know ultimately who the people are who are involved. So that, as Judge Davis said, the judge and his or her clerks can know whether they have a conflict, as well as the public can know simply who the people are behind the screen. Westminster and its partners refused to do that. The case was then returned to the Circuit Court for Baltimore City. And today, over 3 years later, we still don't know who those partners are. We still don't know if there was a conflict for any of the judges who've ruled on the case. This bill would prevent that. This bill, again, so we have limited liability companies, limited liability partnerships intended to limit liability. LLCs and LLPs are not intended to keep secret the owners of those companies in circumstances where conflicts of interest or other problems might be hidden. Thank you.
Excellent. Thank you very much, Mr. Freeman. And rounding out the panel, we'll have Mr. Robinson.
Good afternoon, Mr. Chairman, Mr. Vice Chair, members of the committee. I'm Philip Robinson. My law firm is the Consumer Law Center in Silver Spring in the Chairman's District, and I live in the Vice Chairman's District. I provided written testimony, which I won't read, but I'm here in support of Senate Bill 335. It's pretty simple. It simply is intended to have the same disclosure requirements that exist in every federal court across the country in multiple states, and those are identified in the written testimony, the same disclosure in Maryland state courts. And we're in an era of transparency, and you have before you this session many bills dealing with transparency in the criminal law context, and this is one that deals with it in the civil context. But the same core issues are at play. The public and the bench has a right to know who's before it and has full information so that there can be an appearance of impartiality, and there's no appearance of conflict, and there's no appearance of a potential conflict. So that, as Judge Davis pointed out, the judge knows and the law clerks know, and there can be fair and just justice in Maryland state courts. The Rule 7.1 of the federal rules sets the floor. A close read of that rule will show you that each district court, and I believe the appellate courts, can add other requirements, and in fact, they have done so, most of them. In my written testimony, I outline what the U.S. District Court of Maryland has done. What Senate Bill 335 attempts to do is to bridge what most of the federal courts around the country have done in terms of the disclosure requirements. In response to some of the feedback from the written opposition, a couple things we would note, as Senator Sidner pointed out. It probably should have been written differently, but the bill is not intended to incorporate the rules of federal civil procedure. The Maryland rules will govern proceedings in Maryland courts, but we are borrowing from the federal rules of civil procedure this proposed legislation. And so, there's a canon of statutory construction in borrowing the statute. And then when the original rule was written in the federal rules, I don't believe the federal courts were as electronic as they are now. So there's another provision that the Maryland judiciary pointed out, that there's no need to have two copies. And that's true for Maryland, since almost every county is electronic now. So there's no reason for them to file electronically twice. Once it's filed, it'll be there. I would ask and urge the committee to support the legislation. There is a written testimony from 4 nonprofit organizations who appear before the committee, and they say quite succinctly on the last sentence of their testimony, this disclosure is required to ensure transparency in Maryland court proceedings and facilitate judges adjudicating claims before them, determining whether recusal is appropriate due to a conflict or an appearance of a conflict. That's what the public wants. That's what we need. This is simple. It won't cost anything. And we encourage a favorable with those amendments that the judiciary has asked for. Happy to answer any questions.
Fantastic. Thank you, Mr. Robinson. Looking around the committee for questions. Senator Castley, here we go.
Was there any effort to put this before the Maryland Rules Committee to amend the rule?
No, sir.
Is there a reason why you chose just to proceed in this fashion other than the Rules Committee?
No, this is just something that certainly was within my purview, and I decided to take it on and introduce it. Again, my thinking is, and honestly, I've never put anything before the Rules Committee. I wouldn't know how to go about doing that. But as a legislator, I know how to put in a bill. So that's what I did. I mean, if the Rules Committee wanted to introduce something like this, my thinking is they probably would have done so by now, but they haven't. So
yeah, I mean, I sit on the committee, and I mean, they changed the rules. We meet monthly and do numerous rule changes. I mean, only because there's certain practical aspects of this, which would be, I mean, so for example, would it apply in district court as well as circuit? And would you have to make all these disclosures for, every little district court case on a, debt collection on $5,000 or $10,000, and would that really be necessary? And then even the circuit, I mean, the federal courts have a fairly substantial threshold to even having the court have jurisdiction. So you avoid all the smaller cases that this would be a little more, like why are we collecting this all in this little case? Everybody knows who these companies are, and why are we putting them through the, this extra step? So, okay, I appreciate that.
No, but to your point, even if it was something small, I mean, think about it, the ethics disclosures that we have to file for things over $20. I mean, that's tiny, but we still have to do it. So if you're talking about transparency and ensuring that there are no conflicts. Large or small, a conflict will be a conflict.
Yeah. Okay, thank you.
I'm sorry.
Senator, oh, sorry, go ahead. Senator Sidnor, go ahead.
I'm sorry. I saw that Mr. Robinson had raised his hand, so I.
Yes, yeah, absolutely. Yeah, wanted to see if Mr. Robinson, you got something that's responsive to Senator Cassidy's.
I think so. I would just point out Senator Cassidy's right that on a diversity of citizenship case, the threshold to getting into federal court may be substantially more, but you can have a $500,000 or $500 federal claim case be in federal court. And in every federal court, every corporation files these disclosures and there's no burden. They've been doing it since the 80s. And the last thing I wanted to share is I just randomly, while we were waiting, went through the Courts and Judicial Proceedings article, which includes provisions that this committee has considered and adopted in the past. There are hundreds of procedural statutes that the committee has passed governing proceedings in Maryland courts. And so you can go see those for yourselves, but there's really nothing unusual about passing a statute that has a procedural aspect to it. And as Senator Sidner said, there's no reason the Rules Committee couldn't have considered this before, but they haven't. And there's no reason not to consider it now. And then there's no real opposition from the judiciary or the MSBA to the purpose behind the legislation and the specific opposition we addressed.
Thank you.
Excellent. Thank you, Senator Cassidy. Looking around the room for additional questions. Seeing none, that will conclude the hearing and the testimony for Senate Bill 335. We'll now move on to Senator Heddleman, Senate Bill 134. Senator Heddleman, you are up.
Thank you very much, Mr. Chairman, members of the committee. I'm Shelley Heddleman, Senator from District 11, and I am here before you today to discuss Senate Bill 134. In many ways, the COVID protocols under which we're operating this session will not provide due consideration for a bill like Senate Bill 134. And if ever there was a time to read the written testimony that's been submitted, this is it. In the nearly 200 pages of testimony, you will hear heartbreaking stories of individuals who were sexually abused as children. They were groped, fondled, and raped. Many of them were young children when this happened, and they were hurt by people they trusted, by coaches, teachers, religious leaders. They were abused by people most of us trust, the people we consider upstanding members of our community, people we trust and in many cases revere. Some of them told people at the time and were shamed, told they must be mistaken, told they were misunderstood, or just flat out disbelieved. In many instances, the institutions that employed the abusers were made aware of the abuse and did nothing. Many knowingly denied what they heard, minimized the damage that their employees were doing, and refused to take action or move the perpetrator to another school, parish, or organization, enabling them to abuse again. Many other survivors told no one. They blamed themselves, were terrified, because they were threatened that if they told, they or their family and loved ones would be hurt. They were children and were being hurt by adults. It is 100% believable and reasonable that they didn't tell anyone. Child sexual abuse is a worldwide public health problem. It's a hidden problem that's estimated to be kept hidden 90% of the time from the authorities. What we've learned about trauma, and you'll hear more about this soon, is that it can actually change the way the brain develops. Over the past few years, we've all heard about adverse childhood experiences, ACEs, and the dramatic effects that they can have on the body and brain development. These result in chronic health and mental health problems. They severely stress social and emotional development, cognitive development, and people who've been abused have a higher likelihood of developing mental health and physical disorders and have higher rates of suicide. The cost of child sexual abuse is not borne by the individual alone. According to the CDC, the total lifetime economic burden of child sexual abuse in the US in 2015 was estimated to be at least $9.3 billion. And more than $280,000 per victim. Although this is likely an underestimate of the true impact of the problem since child sexual abuse is underreported. And the Maryland State Council on Child Abuse and Neglect, says that the annual public cost due to child maltreatment in Maryland, including sexual abuse, is $1.5 billion, between $200,000 and $800,000 per victim. There's no doubt that our social service systems, including law enforcement, substance use, and mental health service expenditures, are impacted due to the sequential harm of child sexual abuse that is either not reported or, when reported, appropriate action wasn't taken. Are there systems in place to address these issues? Sure, there are some, but they are not enough. This body has taken steps to put into place early warning and reporting systems, but the reality is that there are thousands of people in our community, our friends, neighbors, family members, and colleagues who deserve justice. You may say there's already a system in place to get justice, our criminal justice system, where there's no statute of limitations on felonies. But this committee knows all too well the limitations of our criminal justice system, especially on an issue such as this, when the average age of disclosure is 52 years old. This committee also knows too well the difficulties of pursuing a criminal case, and there should be high bars when the consequences can result in the loss of liberty. But the reality is that the decisions about when and whether to prosecute are left in the hands of states' attorneys. For it is the state that pursues criminal penalties, not the person who's been victimized. That's why we also have a civil justice system. Civil suits empower a victim to initiate action and to hold the perpetrator and those who've enabled the perpetrator accountable. And that's the focus of this bill. What does it do? It eliminates the statute of limitations on civil cases going forward. Our current statute of limitations ends at age 38, far too below the average age of disclosure of 52. It creates a 2-year look-back window where those who've been previously barred by the statute of limitations can file suit. It removes the statute of repose, making it clear to the courts, the public, and survivors that the Maryland General Assembly in 2017 did not intend to vest constitutionally protected property rights in child sexual predators, nor the individuals and organizations that hid predators from discovery and prosecution. It provides access to justice. It opens a door. It does not ensure anything. A plaintiff still has the difficulty of proving their case, and these cases are not easy to prove. It creates institutional accountability, for institutions live longer than individuals. It helps protect children by identifying previously unknown predators who may still be abusing. And it helps to change institutional practices to keep children safe. Central to the ability to heal is the chance to be seen and heard and to prevent others from being victimized. In 1986, when he accepted the Nobel Peace Prize, Elie Wiesel said, quote, "We must always take sides. Neutrality helps the oppressor, never the victim. Silence encourages the tormentor, never the tormented. Sometimes we must interfere," end quote. I ask this body, this committee, to take sides, to take the side of children who were sexually abused and to open the door for them. They still must prove their case, but we can provide them the opportunity to take a step towards healing by holding accountable those who took so much away from them. Thank you very much. And I have a distinguished panel who can help provide more information about the bill. Thank you.
Excellent. Thank you, Senator Hettleman. And for your primary witness, I have Kathleen Hoke. Is that right?
Yes.
Okay, Kathleen, you're up. You've got 5 minutes as the primary witness. Floor is
Thank
yours.
you. Thank you, Mr. Chair, members of the committee, Madam Sponsor. I'm Kathleen Hoke. I'm a professor at the University of Maryland Carey School of Law, as well as a lifelong Catholic and a current parishioner at the Church of Nativity in Timonium. As a Catholic, I want to express to you that I and many, many of my colleagues at Nativity fully support passage of Senate Bill 134 as is. On the legal questions, for those of you lawyers, this may make more sense, and I'm going to do my very professor best to explain it. But the question is really whether the 2-year look-back window proposed in this bill is constitutional. We need to first address whether the changes made to the bill into the law in 2017 created a statute of repose that vested constitutional rights in those who harbored child sexual predators under their supervision, and then whether removing for a temporary period of time any of those protections is constitutional. I don't believe Section 5-117D should be considered a statute of repose, and I do believe the look-back window is constitutional. First, statutes of repose are extraordinary, and they're only put in place where there is protection of the public interest. In Maryland law, we see a statute of repose for improvements to real property, as well as the professionals involved in that, like architects. Here we know that one of the biggest economic drivers for our economy is construction. And so the General Assembly imposed that statute of repose to protect our economic interests. I will say that statute of repose isn't even absolute. It contains many exceptions, one including for asbestos-related claims, recognizing that even there, public interest and public health should weigh in the balance. The other statute of repose that we have in Maryland is found in Section 5-108 of the Courts and Judicial Proceedings article, and that relates to medical malpractice. Obviously, here the legislature protects healthcare professionals to encourage them to practice medicine in Maryland, inuring to our benefit and to the benefit of the public health in Maryland. So we have two statutes of repose in Maryland, both consistent with other statutes like that across the country, and both based on solid public interest reasons. Nothing about Section 5-117D added in 2017 is based in the public interest. Rather, the section broadly protects all entities, regardless of whether they contribute to the economy, to the public health, to the public interest in any way. So Section 5-117D just simply doesn't fit as a statute of repose. And that's probably why no other state has an explicit provision providing a statute of repose for those who harbored or ignored child sexual predators under their supervision. And frankly, nothing in the legislative record from 2017 would indicate that the General Assembly intended to provide this exceptional protection to organizations that fail to protect children from the most horrific kind of harms. So I don't think 5-117D is a statute of repose, but what if it is? Is the look back window still constitutional? I think here the answer also is the look back window would still retain constitutionality. There is a possibility that Maryland courts would uphold the look back window, even if they found 5-117D to be a statute of repose. There is absolutely no case law, directly or frankly indirectly, on point that would help us answer that question. So we're piecing together from really, frankly, cases that are as close as they can get, but not highly relevant. I think because 5-117D lacks all those indicia of when we would create a vested property right subject to constitutional protection, I think that the court could find that this statute did not grant that property interest in defendants who failed to protect children from sexual predators. I think also the court could find that even if a right was created, the deliberative process that you're engaging in this session to pass, hopefully, SB 134M as it is sufficient, a sufficient basis to remove temporarily any such property interest created in 2017. I know you have a letter from the Attorney General's office in your packet that disagrees with me, uses all of the same case law and statutes that I use, but comes to a different result. And I know former Senator Zirkin's gonna agree with that Attorney General opinion. What does that tell you? That reasonable, rational, well-prepared lawyers can disagree on things. And we don't know how the Maryland Court of Appeals is gonna come out on this. The good news is SB 134 has a severability clause. So if the look back provision was to be struck down as unconstitutional, the rest of the bill that you pass would be able to go forward. So you don't have to untangle this difficult issue of whether 5-117D is a statute of repose, nor whether it vested property rights that are protected by the Constitution such that the look back window would not survive.
Time.
You can and should pass that question on to the courts. Thank you.
Thank you very much, Ms. Hoke. And next we have Ms. Robb, Catherine Robb. There you are.
Thank you, Chairman Smith and members. My name is Catherine Robb. I'm the Executive Director of Child U.S. Advocacy, and I am a survivor of child sexual abuse. We work on SOL reform all over the country. There is a national trend by lawmakers responding to the epidemic of child sexual abuse. Since 2002, 24 states have passed revival legislation. 19 of those were windows, 5 were revivals. In 2021 alone, 19 states have introduced SOL reform. 10 of those are windows. The national trend is clear. The courts are still working and the sky has not fallen. Society looks to legislative leaders like you to respond to newly understood harms. When we see a harm or a danger, we look to our lawmakers. You keep us safe. You keep kids safe. Window legislation serves three purposes. It identifies previously unknown predators. It shifts the cost away from victims and the state of Maryland, and it educates the public. Clearly, there's an epidemic of child sexual abuse. We know the monsters. They look like the good guys: Sandusky, Nassar, Epstein, the Pennsylvania grand jury report, the list goes on. We also know the effects on victims through the science of traumatology. We understand how the young brain responds to stress. Beyond the neurobiological effects, which can overlap with psychological and medical issues, we know that victims suffer from post-traumatic stress syndrome, from depression, behavioral issues, anxiety, sleep, eating disorders, substance abuse, relationship and employability struggles, and suicidal ideations, costing on average about $830,000 per victim. Some of that lands on the state. The financial burden to the state of Maryland should also be noted. Sexual abuse burdens all sectors of society: educational, medical, social services, law enforcement, workforce, and the penal system. Those opposing this bill will likely call, email, and maybe even threaten to withhold their support of you politically. But the choice is simple. You can stand with sexual predators and institutions that conceal them, or you can stand on the side of justice and with children. Good leaders must take a risk for the greater good. And when they do this, good leaders become great leaders. Thank you.
Excellent. Thank you, Ms. Robb. Thank you for your time and your testimony, and for taking the time to share your story and your background with us. Next, we have Mr. Lorenz. David?
Yeah, okay. I'm David Lorenz, the Maryland Director of SNAP, Survivors Network and for those abused by priests. You have a handout entitled Financial Consequences of Diocesan Bankruptcies. I can answer questions to that, but today I would like to focus your attention on the survivors of child sexual abuse because their voices and stories deserve to be heard. Please don't silence our voices on procedural grounds. I'm a survivor of sexual abuse, and I suffered at the hands of the high school guidance counselor, Father Earl Bierman, when I was 16. It was devastating. I felt alone, ashamed, guilty, and frightened. I told no one what happened, and over the years, I worked through the abuse and managed to get my life back together. I went to college, married, had 4 kids, and a successful career. But all the time, feelings of guilt and shame stalked me. I had bouts of insomnia and tirades of unexplained anger. Finally, when I was 32, circumstances conspired that forced me to reveal the abuse to my wife, my mother, my siblings. And in time, I found that Earl Bierman was a serial predator who had over 50 reports of abuse prior to him being assigned to my high school. He was a sick and twisted individual who was enabled by the institution that moved him from place to place, leaving a wake of abused kids in his path. But what the bishop did in reassigning him 50 times was criminal. I've been seeking justice for victims since 2007. The first time that I testified to extend the SOL, there were over 100 survivors packed into the House Judiciary Committee hearing room. It took hours for all the testimony to be heard, and it was gut-wrenching and emotional as each victim told the story of their abuse, how they had approached the church or other institutions only to be rebuffed and ignored and often told they were lying. So they turned to you, the state legislators, for help, only to be turned away. Each of these victims was traumatized while testifying and were re-traumatized when the Maryland General Assembly decided that the concerns of institutions outweigh concern for victims. Most became horribly depressed. Some returned to addictive behaviors, ended up in prison, or were hospitalized for addictions. 2 years ago, a new judiciary chairman and revelations of McCarrick gave us new hope to remove the SOL. We packed the hearing room and provided graphic testimony. Think how hard it would be to testify about your most humiliating and guilt-ridden experience. These are brave and courageous people. We passed the House and hoped for victory, only to find out that the Roman Catholic Church had snuck in a last-minute amendment in 2017 that changed the child sexual abuse to fall under the statute of repose rather than the statute of limitations. To the church, we were not human beings, but product liabilities that they disposed of handily with a high-priced legal firm. Despite that, victims still return to the Last year, the bill passed the House unanimously, only to be thwarted by the COVID shutdown. Because this altered session was silenced, our voices, survivors' public testimony rests with me. I want to say their names. Becky, Buddy, Carolyn, Gloria, Jean, Jenna, Kurt, Mary, Sarah, Teresa, Elaine, Frank, Mike, Sarah, David, Bob, and Fran. At one point in their lives, each one of these children thought they were the only one. Here are 17 statements from them. 1, Father Maskell then put a gun to my temple and pulled the trigger, then said if my dad found out I was whoring around, he would leave the bullets in the gun. 2, I could speak to God directly by putting my mouth on his penis. The pediatrician that abused me and the one I reported it to at a young age are still well-respected members of the Annapolis community. When a child is abused, whether once or repeatedly, it is impossible for it to know.
You know, I apologize for having to cut you off, but just in fairness to everyone on the panel and for the folks that have come to testify today, I'm going to have to ask you to briefly conclude so that we can move on. But I appreciate your testimony.
I implore you to read the written testimony that I started to read, and in reading, know the emotional toll it takes to have to tell their stories again. And I urge you to find favorable at Senate Bill 134.
Thank you very much, Mr. Lorenz. And as the sponsor of the bill, Senator Hedelman said at the top, like obviously this new format doesn't lend itself to facilitating a full-throated discussion and expression of all that you've been through and that the folks have come here today. So I apologize for the format. We're doing the best we can, and I appreciate you taking the time to sign up and testify. So appreciate it greatly.
Thank you for the time.
Thank you. Next, we'll move on to Reverend Little. You're up, Mr. Little.
Good afternoon, Mr. Chairman and members of the committee. It's good to see you. I'm very glad to have the opportunity today to stand in support of Senate Bill 134, sponsored by Senator Hedelman. You have heard wonderful arguments, legal and personal testimony. I'm here as a faith leader and as the leader of the NAACP legislative effort. We stand in support of this bill. We've supported this legislation, similar legislation on the House side. I got involved in this legislation because the wealthy, the powerful institutions, they have their money, they have their reputations, they have their networks. The vulnerable, the victimized, sometimes all they have is the law. And we're asking that this panel would pass this bill out of committee and put it before the full Senate, because those who are victimized as children need the opportunity to find redress in civil court. Why civil court? Well, first of all, victims don't have the ability to file a case in criminal court. Second of all, long after individual criminal actors are gone, the institutions still continue to perpetuate the cover-up, the obstruction of justice, the intimidation of witnesses. If we want to see this behavior change, if we want to stand up for the vulnerable, then we have to give them the tools, give them the capacity to stop those who have victimized them. To me, it's shameful that any institution would make the argument that they're too big to fail. There is no institution, no government that should be held above the law or protected when their actions bring calamity on their own head. And so we'd urge this committee, each of you senators, to put first and foremost in your mind those who have been victimized. This is not about the institutions. This is about the victims who have so often been hushed, so often scurried away, so often told to go away. Don't tell the victims to go away today. Show us that you hear them. Show us that you believe in justice.
Time.
Thank you.
Thank you, Reverend Little. Always good to see you. Next, we will have Mr. McAvoy. You're up next.
Here we go. I'm still muted.
Thank you for bringing this bill. I think that it's an important bill as we see that a number of organizations, both religious and secular, pointing at Montgomery County, PG County recently with their after school care and so forth, need to answer for these heinous acts. Mine is favorable with amendment. I believe that if we look at line 9D, that part is being taken out, may be filed at any time. I don't think that we should have it may be filed at any time. The existing 9, 10, 11, 12 on page 3 suffice, cutting for 20 years there after being a minor. Thank you for your time, committee.
Thank you, Mr. McAvoy. And finally, we have Senator Zirkin, a distinguished guest here and former chairman of the committee, wearing his Ravens purple. Senator Zirkin, you're up. Good to see you.
Good to see you all. Mr. Chairman, Mr. Vice Chairman, and all the distinguished members, it's great to be back with all of you. I'm here on behalf of the Maryland Catholic Conference in opposition to this bill. You have other letters from the insurance industry and some others, but I really would just want to talk about the law. Let me just first say I have obvious enormous respect for my former district mate and my senator, who I admire very greatly. And I have tremendous respect for C.T. Wilson, who's brought this bravely, and all of the survivors. And over our last 2 decades, we have done so much together, making Maryland a leader in trying to deal with these types of issues, including lots of criminal laws, Megan's laws, Jessica's law, being the first to do sextortion and child porn. I mean, just a ton of laws to try to get our hands around all kinds of issues in this area. And we've changed this statute twice, both in 2000, I believe, in 3, and then back in 2017. I don't want to talk about the statute of repose, although I'm sure we'll get some questions about that, because this is a bill that has problems on its policy, not in its focus on trying to get justice for victims. That's not the issue with this bill. The bill has problems primarily because of the retroactivity, but also with the moving forward. So let me just give you a couple, and then I'm sure there'll be some questions on this. First of all, just to be clear, this is a bill that permits lawsuits from the 1940s, the 1950s, the 1960s. Defendants do not have to be alive. In fact, in some of the states that were mentioned, the majority of cases are being brought against institutions where the perpetrator has been dead for decades. And actually, in the context of this bill, the victim doesn't have to be alive either. You can bring you can open up estates for litigation purposes. And so this bill actually would allow deceased victims to bring cases with their heirs against deceased defendants and the institutions. The public and private dichotomy is interesting. I heard what Reverend Little said, who it's good to see and admire greatly as well. But there's a huge difference between, in this bill, what happens with, for example, private schools versus public schools. Whereas historically, private schools had sovereign immunity. So depending on when you sued from, public schools did, you would be able to recover nothing if the abuse occurred against a public institution. Whereas against a private institution, it's bombs away. There is no caps, no sovereign immunities. No
Time.
Chair?
Please conclude. Yeah.
Thank you. So just a couple more. Government immunity as well. As you all know, there's a local Tort Claims Act, State Tort Claims Act, notice provisions that all impact what you would do against a public institution and make it impossible to go against the public, the governmental entities, versus the private entities, creating a complete difference in the law, which is what 2017 was trying to do, which was to equalize those things together. There's a lot more slippery slope, impacts on businesses acquiring one another, and how that would impact in terms of commerce. And, as was brought up, there is the statute of repose. I'm not sure, and the legal grounds are pretty clear that this is an unconstitutional bill. But more importantly, and lastly, Mr. Chairman, I would say that institutions have been trying for, many, as you know, many private schools in your area have been trying to be transparent, have been doing investigations and lookbacks, going back many, many decades to try to be transparent and to try to uncover what had happened. That comes to a screeching halt with a bill like this, because quite frankly, what happens is they would be, giving themselves a multi-million-dollar lawsuit by doing any kind of a look at what happened historically, leading to, that type of an investigation would be leading to multi-million-dollar lawsuits and bankruptcies for our schools. I mean, this bill actually does the reverse of what it's trying to do, which is why for many years we always rejected this look back provision. So with that, I'm sure there's a lot to uncover here, but it's good to be back and to see all of you guys. But I would ask you to give 134 an unfavorable report.
All right, thank you very much. Now I'll open it up for the panel for questions. Senator Huff, you're first, followed by Senator West. So Senator Huff, you're up. There you go.
Okay, thank you very much, Mr. Chair, and I hope you'll hang with me. We've been dealing with this bill in one way or another for 20 years, so I have actually questions for 3 different people on here. If I could start with the sponsor, just a question on the drafting, and actually I should say before we start on this too, we obviously do want to hold these people responsible. We did actually just pass a bill, it was my bill 2 weeks ago, that would hold organizations that prevented the reporting of sexual abuse criminally liable. So obviously the individuals are criminally liable for their whole lives, but this would make the organizations criminally liable too. So we did pass that on the criminal. But obviously we've been doing this for 20 years, trying to figure out the civil liability and the due process rights and everything like that. So I guess the first question for the sponsors, I can't figure out why the definition of sexual abuse we got rid of it in 5701 and put it in this bill because it's missing some things. So it's just like a drafting error, or curious why, or did you mean to leave some things out?
No, we didn't mean to leave some things out. I think it clarifies things. I'd actually probably toss this to one of the attorneys, but I think it just makes more clear what we're talking about when we're talking about sexual abuse.
Okay, because it's like
clarity issue.
Because sexual trafficking is one that's already in 5701 that's not in this bill, and there's some other things in there that if we go down this road. But I guess I'm trying to figure out, and I don't know if you probably weren't on the judiciary in the House when we were doing all this. So the idea was this was a well-crafted compromise that was going to be the end of this issue because it's been around here for 20 years. So the sponsor at the time, C.T. Wilson, everyone signed off on this compromise that this was going to be the end of it. But it was very well constructed, and I don't understand. So for example, it required a gross negligence standard. So we didn't just say, well, look, if you're going to go back 40, 50 years, there might not be anybody alive that was even working there at the place. The person that may have committed or allegedly committed the crime could be dead. Anyone who worked there, supervisor, could be dead. So they required gross negligence. It required some sort of control over the employee. And why was it that well-constructed compromise that we put together, that language was just completely obliterated? I mean, don't you feel that there should be some fairness in there, that there should be some level of control that the person had over, that they were actually an employee there when you're going back 40, 50 years? Why do we get rid of gross negligence and the control over the employee?
Well, that was a standard that was changed at that time. And as to your underlying point, I think, which is why are we revisiting this, since we thought that, or some people may have thought that it was a settled matter after 2017. I would say that that's part of our job as legislators, is to look at what we have done in the past and to see whether the laws that we've instituted at the time are addressing the issues that are out there. And here we are 2 years later, and 4 years later, and I would say that no, what we did in 2017 wasn't enough. And there are other issues that have come up. We know from the science of trauma that has changed substantially over the past 5 years. We know from the experience of other states that have done this, that the sky is still blue and the earth is still standing. That when we have these look back windows and when we remove statutes of limitations, that people are held accountable. Institutions don't go away. They are still there.
Okay.
They're still operating and they're being held accountable now.
So I guess
I would like to,
I'm sorry, go ahead.
if you're able, Catherine can kind of give some of that perspective about your questions about gross negligence.
I have a follow-up question for her. Just one last question for you. I mean, one of the things that we did in the original bill, though, is we put parity between the government. If you look at the bill, that your language wipes it out completely. And did you mean to do that where you wiped out the parity between the government and the private sector? So if some child goes to a private school and something happens to them, let's say they're molested, under your bill, they can come back and sue and there's no problem. But if we pass your bill as is, they're back under the old local tort claims, capped, notice provision, everything for government. So if they go to a public school, there's no parity. Did you mean to do that?
There should be parity, and that, I mean, but I think that there are other aspects of the law that put those caps on there, right? The Tort Claims Act.
Yeah, but we got rid of that. So in 2017, we fixed the law in that we equalized it. So that if you look at the 2017 law, it talks about bringing suits against government entities. Because the way with government, if you don't provide, I believe, in a year within the incident,
right,
and then they're capped. So if we went forward on this, would you be okay with equalizing the public sector and the private sector?
I would.
Okay. So I have a question for the professor.
Ms. Robb, is that right?
Yes.
Got it.
No, Miss Hoke is the professor. Miss Robb is with.
I'm sorry. Yeah. Yes.
Kathleen and Catherine.
Kathleen. I'm sorry.
Yes.
It's hard to read everybody's names sometimes on these Zooms too.
It's okay. Kathleen and Catherine are awfully similar.
Kathleen, and I didn't want to take away your proper title. So I was just curious. I mean, to be honest, on your argument on the statute of repose, I mean, I found your argument just personally somewhat immaterial in construction, but I mean, whatever we used it for, it's up to whatever the legislatures used it for is what we used it for. But I was curious your statement that nothing on the record in 2017 says that we meant to insert a statute of repose. Why do you say that?
So I actually didn't use the word statute of repose intentionally, and I said nothing in the legislative history in 2017 demonstrated that the General Assembly intended to provide permanent protection for those who harbor child sexual predators under their supervision. And I think there's a difference because I dare say that, frankly, until I started working on this matter, I didn't really know what a statute of repose was. So I don't think that using that language in the statute gave fair notice to really anyone, even many members of the committee. There is recorded contemporaneous after the passage of the bill and the realization that there may be this problem with the statute of repose, that even then Senator Zirkin expressed his distress over the fact that there may have been a statute of repose added to the bill. And certainly Delegate Wilson, who agreed to some extent to the compromise, expressed that he felt hoodwinked by the fact that the statute of repose language that he simply did not understand to be what it may be, that it was included in there. He felt hoodwinked by that. So I don't see anything in what I can find as the legislative history that shows deliberation at all on this question of providing the extraordinary measure of a statute of repose for those who harbored child sexual predators.
Well, I can tell you something interesting. It's actually of the bill we passed, and we passed it first in 2017. It was actually in line 5 of what JPR passed out. So it was right there. And then Delegate Wilson, I went back because he's had this contention that he was somehow hoodwinked or didn't understand the bill. I actually went back and I found what he actually said on the record. So he went to the House Judiciary Committee and he sat there at the Catholic Conference and he said, I've given my word as part of an agreement that when this bill becomes law, I will not come back to the well. I won't petition for anything. I won't try to improve the bill. The agreement as it is, I take it. The agreement is take it as it is, and that is what I plan on doing. And he said, I'm very grateful to the church. So it was clear, that was what he said on the record in judiciary. It was clear to all of us. The understanding was the statute of repose meant this added finality to this, that they would not come back. And in fact, we've had other legislation that even without a statute of repose, that to come back and add liability. In fact, the trial lawyers were here on Senator West's bill earlier saying even without the statute proposed to go back and add liability would violate Comcast versus Duo. But certainly with a statute proposed, it's a vested right. So how can you say that that's not plainly unconstitutional?
So twofold, I want to express again that I don't think the word repose in the statute frankly gave notice. I'm not saying it was unfair. I'm just saying it didn't in actuality give notice to many of your colleagues at the time what the implications of that language were. And certainly that is the case for Delegate Wilson. So I don't think he's going back on his word to the extent that he would support this bill and had the bill in on the other side last year. I don't think he's going back on his word at all. I think he is truly a man of his word, but did not understand, as many folks didn't, the implications of the statute.
I think he's a very smart individual. I think he's very smart. So I have a question for Senator Zirkin.
Okay.
Can I respond to one point here, Senator?
Yes, absolutely.
So the whole conversation about the statute of repose, I don't think people at the time realized what the finality of what one interpretation of it meant. And I would say, I mean, there was an article back in the Washington Post, March 31st, 2019, and where the chairman of the committee at the time was quoted as saying that they introduced amendments in 2017 that included the statute of repose. And he said it wasn't anyone's intent to grant permanent immunity. There wasn't discussion about what that meant. And the fiscal note that did talk about it came out after the vote. So fast forward to 2019, I remember being in the House and my former colleague, Delegate Dumais, standing on the floor talking about it. That was 2 years after when the full implications of what that meant were brought to light.
Well, I can just say I was a member of the committee. I sat in the room when we passed it and did it. And the plain reading of it, even if you ignore the statute of repose language, it says that you cannot come back. It says plain and clear in the law that you cannot come back. So to say that people aren't reading laws, I mean, we clearly understood. We clearly understood that this was finality and the end to the issue. The House sponsor understood. Everyone understood that we were constructing something that was an end to it that, I quote, won't come back to the well. Now to Senator Zirkin, if I could ask a quick question.
Or once. Hold on 1 second here. So, sorry, Ms. Hoke, were you finished? You were finished, right?
Well, there was a second part of the question of why do I think that it would be, okay to have the look back window. And very briefly, I mean, again, I have submitted written comments as well, but there are certainly times when the state is allowed to invade a property interest. And I dare say this is a compelling circumstance that the Maryland Court of Appeals hasn't answered and could potentially answer in a way that reflects this balancing of, a temporary open window for 2 years not being a significant incursion on the property interest.
Senator Zirkin.
Yes.
Yeah, just a quick follow-up. I mean, I'm sure there'll be lots of discussion or talk about the statute of repose, but I was interested in something you said in the lines that we're not even talking about people who are live, that suits can be brought up on behalf of the states.
Yeah, that's one of the things that caused us not to address, retroactive lookbacks. First of all, statute of limitations, just to make sure everybody understands, statute of limitations, as I'm sure you know, are for finality, right? So the idea is that businesses or insurance or whatever, school, whoever has some finality so they can plan for their finances, right? Because they know that at some point in time, that a case is over. Statute of repose, really, just to be very clear on that, statute of repose was put into the bill. These were amendments that were added. I'm sorry, I'm just going to do a little bit of a revision. There's a little bit of revisionist history going on. There was a deal. Most of it was being done, quite frankly, by Chairman Valerio at the time and Delegate Wilson and the Catholic Church and President Miller's staff. And they were working on negotiations on this thing. And the bill that came out in 27 was, that was the entire session they had worked up those negotiations. And the idea was that we were going to extend the statute moving forward pretty dramatically, but that we were not going to do this retroactive provision that had been done in some other states. And the rationale for that, getting back to Senator Huff's question, is it just has so many just crazy consequences in terms of suits that can be brought. And you have seen that experience in other states where in New York, for example, more than half of these hundreds and hundreds of suits that were brought against individuals and the institutions where the individual perpetrator had been deceased for decades. And so what you end up doing is you're not going after the deceased individual, but what you are doing is holding responsible institutions like a private school. And there are many examples of those who have gone bankrupt from things that happened back in the 1940s and 50s, where you have nobody here, nobody associated with the school that even knows who you're talking about. But because it happened and it's a school that's been around for a long time, you have these ancient lawsuits being brought. And the answer to your question, Senator Huff, is yes. Under this bill, with a retroactive provision, you do not need a live plaintiff either. What you can have in the scenario is an estate for litigation purposes. And I bring them in my, I'm a plaintiff's lawyer, so be that as it may, you can bring cases on behalf of the estates. You can open estates for litigation purposes. And so this bill does not prohibit that. So you could, with the appropriate evidence, somebody wrote a diary, somebody talked to somebody who talked to somebody. I mean, there's all kinds of things I could construct for you where you would have essentially a deceased plaintiff through their estate and their heirs bringing cases against deceased defendants. That's as broad as this bill is with a retroactive provision. There are two basic sets of this bill. You have the retroactivity, which is what we're talking about, and then there's the look forward. And they're two completely different conversations. The repose is about retroactivity for certain. I mean, I don't think there's any, the Attorney General's office and letter makes that abundantly clear. And it doesn't really matter with respect to my, to Professor, like, it doesn't matter if delegates didn't, or senators, or all of us for that matter, didn't know what we were, that's not a conversation that will be part of anything that happens in the Court of Appeals. Somebody can't come back in and say, hey, delegate or senator, did you know what you were doing? No? Okay, then we're not gonna uphold the constitutionality of the law. So it's just not a legal, conversation. Repose has to do with retroactivity. So there's two separate conversations, but this look back provision has led to so many different types of cases. And I really think I just want to focus one more comment, that the idea that somehow you look back and treat a case against a public school, and they're barred from recovery. They have what's called sovereign immunity beyond a certain point. So if you were a public school student who had something horrible happen to you, you cannot sue the public school past a certain point because of sovereign immunity. And then only up to just a few years ago, when all of us changed the law, you'd be capped at 100,000. So, but the very same thing, if it happened to a private school kid, you'd have unlimited recovery. So this essentially allows, massive recovery in a case for a private school student and zero for a public school student, which of course makes no sense whatsoever.
I just have one final question, Mr. Chair, and thank you for indulging me. Senator Zirkin, are you familiar, or your research shown what are the effects in other states that have done this? I mean, what's been the outcome, especially in this time of, and let me preference this question by saying, and I voted for the 2017, we treat this, we do, some people said we shouldn't treat this differently. We do. This is the only thing that I'm aware of. I think there may be, Senator West might know, maybe there's some other aberration in the law, but this is one where we allow 20 years out of when you reach the age of majority. I don't think we do that on anything else. So we have made a special carve out for this looking forward. But the concern of the committees always was looking back, the ability of people to defend themselves from cases that are 50 or 60 years ago. So what has been the practical effect on, I'm thinking now, especially in COVID, we're talking about churches that are providing services, education, what has been the outcome in these states that have done this?
It's obviously a broad question. I mean, some of them have been bankruptcies. You've had private schools that have, gone into bankruptcy. You've had some dioceses that have gone into bankruptcies. I mean, there are, and I'll provide you the the information on those things. And look, I don't think in my 21 years in the General Assembly, I was ever accused of being soft on crime. And I certainly wasn't ever accused of not understanding the plaintiff's side of view on these issues. This bill just puts it out of balance. It's just an out of balance thing to do. And I believe these people should spend the rest of their God-given lives in jail. And quite frankly, I have no soft spot for any person who did anything at any time, which is why we have no statute of limitations whatsoever for the crime. But the experience of other states, Senator Huff, has been you have just thousands of lawsuits, and they are really hard. If you might imagine, as you can imagine, it's hard enough to defend a case that happened 3 years ago versus a case that happened 53 years ago. And it just is, even as a plaintiff's lawyer, and I always used to make a comment, you know, that when people would put in bills to help plaintiff's lawyers like myself, it always warmed my heart a little bit. But like, I gotta say, like, this bill is so out of balance between the plaintiff and the defendant. It's just impossible for these institutions to defend. I mean, think about, I'll give you another example. Think about a business. Forget about the institutions we've been talking about. Think about, I'm a dental practice, right? And back in 1995, the dentist down the street passed away, and I purchased his practice in 1995 after I get all of his assets and all of his liabilities. Now, 30 years later, the General Assembly allows a look-back provision, and I've acquired all of this guy's assets and his liabilities. And God forbid that guy, I never even met him before, and he did something horrible back in the 80s or back in the 70s, but I purchased his dental practice. I'm now on the hook for all the things that he did and this retroactive lawsuit. I mean, that's the type of thing that happens. And I don't even know this guy, never met him before. I just purchased his practice. And so now, for the simple fact of my buying this guy's dental practice, I'm now subjected to a multi-million-dollar lawsuit for the things that guy did. I never even met him before. Certainly didn't hire him. I just have his dental practice now that I've acquired, or whatever small business you have. These are the types of things that have happened and that are being pursued in some of these states that have done that, which is why we said very clearly in the 2017 law, we are not allowing retroactivity. It's just too draconian of a measure in the civil law practice. It's just too imbalanced. Moving forward, you know, I mean, we would take a look at it, and we extended it, you know, based on the agreement that Delegate Wilson and others made. Had they wanted to go another couple of years or 10 years, or whatever, we were okay with whatever they came, you know, they worked out their agreement to move forward. But this retroactivity just creates incredible imbalance in the civil law, which has, in answer to your question, Senator Huff, led to bankruptcies, led to, you know, private schools, not public schools, because as I said, they have sovereign immunity historically. So they're not on the hook for a dime, but private schools are, millions of dollars. And that's what you've seen, because you can't sue the public school system moving back before sovereign immunity, unless you want to undo sovereign immunity historically, which would make for a fascinating Court of Appeals case. But I mean, that's the big issue with this.
Thank you, Mr. Chair. I'm done asking my questions.
Thank you, Senator Huff. Thank you, Senator Zirkin. Senator Hedelman, you've got something to say. Go ahead.
I would just like, Mr. Chairman, if Ms. Robb could respond to that as well, since she does have the perspective of having been personally involved and has a national perspective to shed some light on the bankruptcies, what the truth and fiction of what's out there in the country.
Absolutely.
Sure. Thank you. Thank you, everyone. I just want to respond to a couple of things that I've heard today. And just recently, Senator Zirkin, you said several times that, you know, this is so out of balance. And what I would say to you, and I would say to everyone on this committee, what is out of balance is that 10% of children are being sexually abused in this country. That is a more alarming figure, if you can believe it or not. It is a more alarming figure than the amount of children that are being impacted by COVID. Okay, 1 in 5 girls and 1 in 13 boys are being sexually abused, and those are the numbers based on victims that come forward, right? And the other thing that you said earlier, Senator Zirkin, is you talked about that this was a problem of policy. Well, I think that it's up to this legislative body to change policy, because we're talking about the sexual abuse and rape of children. I cannot think of a more important public policy to make sure that institutions and predators are held accountable. That being said, the other thing I want to respond to is this old stale claims. I think you said 1940s and 50s, just a couple of things about that. One is plaintiffs have to prove their case. They have to survive a 12B motion to dismiss. They have to come forward with the evidence. And quite frankly, most attorneys won't take those cases, right? So there are already systems within, whether it's our civil rules of our rules of civil procedure, or even our evidentiary rules, that offer protections already. So, we're talking about identifying hidden predators. That's what window legislation does. It exposes hidden predators, it educates the public, and it shifts the cost of this abuse. And my understanding, and I've done some deep research on this, and we can certainly, Senator Zirkin, we can compare notes. I'd be happy to share mine if you'd be happy to share yours. That I don't know of a private school that has voluntarily filed a Chapter 11 and gone through with it, bankruptcy. I've done a pretty deep dive, but you've said that these institutions, these schools will file private schools will file bankruptcy. I don't see them in the filings as I search the federal docket. I don't see it now. I don't see it even 10 years ago. So if you can point me in the right direction, I'd like to see that data. But I can tell this committee, I don't think that data exists. I don't think that these private schools are filing bankruptcy. While I'm on the topic of bankruptcy, if you will give me just a couple more moments here, is that bankruptcy, Chapter 11 filing of bankruptcy is a voluntary process. It's a reorganization, and it gives the organization a new day, whereas victims end up as this cold number on a spreadsheet, right? There's no discovery. Any bad practices or any bad actors, they don't get exposed. Chapter 11 voluntary bankruptcy benefits organizations. And so again, let's come back to public policy. We're talking about children here, right? And this is a national movement. States are doing this all over the country because they realize that this is not something normal. This is an extraordinary problem that we have to respond to. Thank you.
Well, thank you very much. All right, Senator West, you are up next.
Thank you, Mr. Chairman. So we've talked a fair amount about the need for finality, but I want to talk a little bit with Mr. Zirkin about the statute of limitations, because there are public policy goals to be achieved by the statute of limitations, which are not just finality. More importantly, I believe the reason why we have statutes of limitation is because of the interests of fairness and the interests of justice. So let me give you a hypothetical situation and ask you to discuss it with me. You were there 2 years ago, chair of the committee, when this bill came before the committee last, and I suspect you remember as vividly as I do Delegate Wilson's presentation that day. And it was a rather dramatic presentation, especially when in some secret signal, the entire gallery rose simultaneously and stared at the members of the committee. Do you remember that?
I have a recollection of what happened, yeah.
So let's talk about my hypothetical. So you have a boy who's born in 1936. In 1946, when he's 10 years old, on his 10th birthday, he allegedly suffers abuse at the hand of someone in his elementary school. In 1984, he turns 38 years old. So between 1946 and 1984, under Maryland's current statute, the one we passed 4 years ago, he would have a right to bring a lawsuit against the perpetrator and against the institution whom the perpetrator worked for, who allegedly facilitated the abuse. But he didn't. So now it's 37 years later. He's 85 years old. At this point, his abuser is dead. All the other school teachers in the school who might have known anything about the abuse, they're all dead. All the other school employees, including the administrative staff, the headmaster, et cetera, who might have had some knowledge of what happened, they're all dead. The person who was abused, his parents are dead. There's literally no one left alive who knows anything about the circumstances of the alleged abuse except the person who was abused. Furthermore, there are no documents that can be found that might cast any light on the situation. Over the course of the last, how many years? 50 years, 60 years? They've all been discarded. So my impression would be that at the time, Ms. Robb talked about how we offer protection to the defendant. I don't think the defendant in that case has any defense at all that they can offer in a courtroom. There's no live human being that can testify about anything that's relevant to the abuse. There are no documents that can be introduced that are relevant to the abuse. If I'm a defense lawyer hired by that institution, my guess is, my advice to my client's going to be, I can't put on a defense for you other than trying to question the recollection of the abuser. And instead, unlike what Ms. Robb said, the only evidence is going to be the abuser who's put on the stand and at the age of 85 sobs about what he was subjected to when he was 10 years old and how his life has been made miserable. And he will be asking the jury for tens of millions of dollars in compensation. Now, am I wrong in that assumption, Mr. Zirkin?
No, I think that's a real hypothetical. You said it more articulately than I did, but that is what the retroactive provision of this law does. And although I agree with like everything that Ms. Robb said in terms of dealing with the people who did this, I could not agree any more, which is why I put in so much legislation on this issue, including from the Baltimore Child Abuse Center on the, that you guys just extended the statute with Senator Huff. But your hypothetical, Senator West, is exactly what can happen with a retroactive provision. And to what Ms. Robb said about it somehow being kicked out of court, look, I'm a plaintiff's lawyer. That suit, obviously there's more details to be had. That suit that Senator West just talked about does not get kicked out of court on summary judgment. It is a civil case is, as you all know, by preponderance of the evidence, more likely than not that it happened. And testimony by a witness is more than enough to get yourself to a jury. That is not getting kicked out on summary judgment, and that gets to a jury. And if I'm the defense attorney, and I am not one and never have been one, I am a plaintiff's attorney, but if I was a defense attorney, I would scream, settle that case. One little caveat, because you said elementary school, you did say headmaster, so I assume you're talking about a private school, but not to belabor the point.
But it doesn't have to be. It could be a public school.
Well, against a public school, the public school student would never be allowed to bring that case, because back in the years that you were talking about, they had sovereign immunity. So you could not, if you were the public school child, and it was the same exact set of circumstances, public school child does not get to bring that case, not allowed to. Sovereign immunity back then. Private school student, all those years later, can bring that multi-million-dollar lawsuit. That's the unfortunate dichotomy. That was the imbalance I was talking about in the law. That's why we didn't do this for so many years. Not because anybody wanted to be soft on sexual, offenders. Like, to the contrary, we wanted to throw them in jail for the rest of their lives and create registries and all these things that we did. Nobody in this General Assembly was ever soft on this issue. Just this look back, your hypothetical is exactly what can happen and what has happened. This is not like a made up hypothetical. These suits have happened to schools just like the ones in your district.
And then my final question to you is going back to my original concept of the interests of justice as the rationale for statute of limitation. The longer people wait to file lawsuits, the more memories fade, witnesses die, documents get lost. You can go through the whole train of things that happen when you delay filing a lawsuit. Are you aware, Mr. Zerk, the general statute of limitations in Maryland, of absent some special provision, is 3 years. 3 years. In this case, the statute of limitations is 20 years after a person's 18th birthday. That assumes the abuse occurred on the 18th birthday. If it occurred 10 years earlier, the statute of limitations is 30 years. Are you aware of any other statute in Maryland which provides for statute of limitations even a fraction of 30 years?
Other than the criminal statutes, obviously.
Well, yeah, criminal. I'm talking about the civil statutes.
Civil statute, I'm not aware of them, but I mean, I typically do automobile stuff and things of that nature, which are 3 years, or defamation is 1 year. But no, this, I mean, look, and just so you know, and just to be upfront about that, the numbers that are there right now was worked out in a compromise between the House sponsor of the bill and the opponents of this bill and folks from the Senate President's office. I don't think there's any, I would not claim that moving forward that somehow 38, there was some scientific reason to that. That was just what they worked out in their negotiations and decided that was the master agreement.
Understood.
But no, I mean, those are the longest statutes civilly that I'm aware of. There may be some that I'm not aware of, but I certainly have never done a case that had a long statute like that.
Great. Thank you very much for your testimony. Looks like Senator Hedelman wants to chime in here.
Senator Hedelman.
Thank you, Mr. Chairman. I would just like to respond to my colleague a couple of things. Yes, we can have a discussion about the concept of statute of limitations, but I would like and implore you to keep in mind that, one, we're talking about child sexual abuse, and two, we are talking about a circumstance where the plaintiff has to prove just as well as the defendant does that this happened however many years later. So all the arguments that you're making about the difficulty apply to the plaintiff too. I'd like to keep that in mind. And third is the average, I want to remind people, the average age of disclosure is 52 years old. So that's important. If you're, between the ages of 38 and 52, like, you're out of luck here. And if Ms. Robb could respond to that as well, Mr. Chairman.
She responded to your question or?
To Senator West. And I think the hypothetical too, and kind of what these cases look like with regard to the 85-year-old example.
I appreciate the colloquy, but I do want to make sure that if the senator that directs the question to a witness or that's the direct response, that's the call and response. But Senator Hedelman, you're the sponsor. There we go.
Thank you, Chairman. I just want to respond to Senator West's position about the purpose of statute of limitations and not having any other types of actions that are short. And I understand that most are 3 years in most jurisdictions, but I want to say this to the committee, that the statute of limitations, yeah, it has a purpose, and I understand due process, and I think due process is important. But our laws are based on really fundamental notions of justice, reason, common sense, sound public policy. That's what all of our laws are based on. So if not to have sort of an exception for the rape of children, I don't know what other type of claim we could have an exception for. And, that's not to say that statute of limitations aren't important, but all of our laws, anyone who's an attorney on this understands this, that most laws, statute and case law, have exceptions and exceptions to the exceptions sometimes. And I also want to respond to the comment about the hypothetical about someone coming forward when everyone's dead and all of that stuff. First of all, institutions that are going to be held responsible, they typically, the perpetrator has multiple victims. I can share with this committee lots of data on the average amount of victims. So you're saying, okay, so this person's dead, this person's dead, this person's dead. Well, when we're talking about negligence of an institution, there are multiple, generally multiple victims who may be alive. And there's also victims that are much younger because perpetrators continue to abuse. So I just wanted to make those 2 points. Thank you, Chairman.
Appreciate it, Ms. Robb. Thank you very much. So looking around the room, I see Senator Carter has a question and then Senator Castley. So Senator Carter, then Castley.
Thank you, Chairman Smith. Nice to see you again, former Chairman Zirkin. My question is directed to you. They're simple and straightforward. One is you've talked about the issue of sovereign immunity. Just can you let us know, when did sovereign immunity kick in? What year would be that time bar?
Sure.
And that's my first question. The other question is similar. You sat in this body, as have I, for many years. And I've always felt that I don't like to compare trauma or compare, atrocities. I know that for many years, I've felt that we should move legislation around the permanent brain damage of children related to lead paint poisoning and market share liability. I also feel that for permanent brain damage through catastrophic injury, that's also something that, impacts and destroys an entire life. I have had hesitation around carving out the exception, a total and complete exception, no statute of limitations whatsoever for this particular injury, because I don't see it as the only trauma, and I'm concerned that there are other very serious things as well. But getting to my question, beyond my reflection on this extremely difficult issue that's been around for a long time, I've heard testimony today from someone, and I remember 2 years ago when I was here and we dealt with this bill, I remember looking up in all states, all 50 states report on the issue. And from my recollection, there were a small minority of states that had no statute of limitations whatsoever. And many of those had a connection, like there had to be a correlation, like there had to have been a criminal action as well, or there were conditions. And so what I would like to know is if you could provide the actual data, like where there is zero statute of limitations or any statute in this whole country as liberal as what we're being asked to do, where are they, and sort of what has been the impact, in more specifics than what we've heard today.
Okay, good questions. Let me start with your first one about sovereign immunity, because you wanted the amount on that, because again, that's the public-private dichotomy. So there's three separate things. You got the state of Maryland, you got local government, and then you have the school board. And those are three different statutes that deal with that. So sovereign immunity under the Maryland Tort Claims Act, there were no suits against the state prior to 1981. They had complete sovereign immunity. And then the incidents, I believe, went up to, it was 100,000 against them until 89, got raised to 200,000 from 99, and then 99 to 2015, when we raised it up, if you remember, to 400,000. So that's the state Tort Claims Act, I believe. And the local tort claim, I may be messing this up a little bit. The local Tort Claims Act, they had sovereign immunity all the way until 1987. So, and then they had caps. I can't remember exactly the dates from when we raised the caps on that. And local boards there were no suits allowed against local boards of education until 1971, when there was a damage cap starting in 1971 of $100,000 against the public school system. And then that got raised just recently. I think somebody on this committee put that bill, I can't remember, but it got raised up to the same thing for the Local Tort Claims Act of 400,000. That was just a couple of years ago, into I think 2016, we raised that up. The other issue here, of course, against local and state court, which hasn't been talked about, which is really complex legal stuff, is there are notice provisions, and nothing in this bill does away with the notice against local and state tort claims act. So just because you file a retroactive claim, you still had to provide notice under the local or state tort claims act, unless you just decide retroactively to get rid of the notice provision also. So the basic of it, I mean, those are the dates, and I'll send this over to you, Senator Carter, and everybody else, as to the sovereign immunity and when it was and where it was. But the basics are that for many of these cases that will be filed, you would not be permitted to file a suit against the public entity, just against the private entity. So for example, social services that are private, you could file away on them if they did something bad historically. But for the public ones, for the public entities, for the Department of Social Services, you would be completely barred from filing a lawsuit against them based on sovereign immunity and the tort claims notice provisions. And I don't know, I mean, you could try this out, but I don't think you can do that retroactive. You can't get rid of, I guess you could try, but nothing in this bill gets rid of the sovereign immunity retroactively. So you're essentially going at the private entities and not their public counterparts. That's the whole point of this sovereign, which is really kind of ridiculous if you think about it. I mean, what's good for the goose should always be good for the gander, whether it's the government being sued or a private entity being sued. As for the other things that you were talking about, Senator Carter, this is the only one. And the decision was made to move this statute up, I think back in '03. I think that's when it was. I was just my third or fourth year in the General Assembly, and not again until 2017. And so we have moved the statute up. I'll get you what the other states are doing. But I mean, for example, we do have unlimited liability for some parts in this state, right? If a defendant, as to the defendant themselves, we have unlimited liability for 3 years after their conviction and no statute of limitation for their crime. So if the person did it 50 years ago, they can be prosecuted today, and then you have another 3 years to sue that person. I mean, look, let's be honest here. That person probably doesn't have a big pocket of money, but we do have unlimited liability as to the defendant themselves. If you wanted to do that and sue the person who actually did this up until the day they die, I mean, I certainly wouldn't have any problem with that. I don't want, I don't talk out of turn, but but you don't have this type of a situation, particularly a look back for police brutality cases, which can be obviously can be traumatic, for domestic violence, for murder, for, I mean, any other tort except for this one. And there's a lot of traumatic ones. A lot of horrible people do a lot of horrible things, but we don't allow us to sue. We don't allow people to sue for 50 years ago for those things. But I'll tell you, in some of the states, Senator Carter, just last thing, some of the other states have moved beyond what they did here. This wasn't the stop. There have been bills introduced now in a number of states to retroactively allow lawsuits for things like products liability. Now, they haven't passed yet, but when you open up this Pandora's box of allowing, again, the Pandora's box is you want to stick it to these sex offenders up one side and down the other. But the retroactive provision, allowing statutes of limitations, which have been in place for many decades, to simply be swept away, it doesn't stop with this. Products liability, domestic violence, I can make an argument to you for many, many traumatic torts. We've made it a significant crime to commit domestic violence in front of your child. That can be incredibly traumatic for a child, for the people that perpetrate that crime. We don't allow unlimited statutes of limitations for that or for lookbacks. Drunk driving accidents that, where somebody's, on their 17th drunk driving accident and you kill your parents in a drunk driving accident. Somebody misses their statute. We don't allow that person to look back 40 years to do that. So there's nothing else besides this that we have this for. I hope that answers your question.
Thank you.
Thank you, Senator Carter. Thank you, Senator Zirkin. This is good prep for joint and several liability. We've got a couple of bills coming up next week, so this is good prep for that. So brush up on your your market share liability and joint share liability. Okay, Senator Sidnor, you have a question. You're next.
All right, thank you very much. Question for, and this could be for anyone who may know. But I'm curious, since the change in the law since in the 2017 session, how many suits have been filed? Does anyone know how many times this particular law has been used?
If folks can, if you want to answer, you can raise your hand. I can look around the room if anyone has an answer. Mr. Lorenz, you got it, and Mr. Zirkin. Lorenz, you're up.
No, and the reason that I'm asking is,
Sorry, the question fully
is just trying to be clear. I mean, if we're looking for a change, I'm assuming, I mean, was there some people who had the opportunity to do so within the past few years that have not done so, or I'm just trying to understand what's going on?
Mr. Lorenz, you're up.
I guess I'm trying to understand what the full question is. You asking?
So the law was changed in 2017. It's now 2021, and we're changing the law. So I'm wondering, has anybody used the law that was created in the General Assembly in 2017? And if so, do we have a number of how many people have used it?
I'm not aware of anyone, but I don't think it would be used. It would take time for that. The way that was phased in, it would take time anyway, because it was already up to 25. The age was 25. It was moved to 38. Anybody who was, and it wasn't retroactive, so people would have to be abused at childhood sexual abuse has to be occur prior to age 18, because you're not a child after that, right? So anybody who was abused had to be less than 18 in 2017. So they haven't crossed the 25-year-old boundary yet anyway. But I don't know of anybody who's done it, right? I hope I'm making sense on that math. I don't know that I made that clear. If in 2017, you were a child who was abused, you would only, at the greatest age you would be is 21 anyway, right now.
I guess he's asking if, since we passed the bill or the law in 2017, has anyone availed themselves of the new law, or is there a category of individual that has not been able to pursue justice because the 2017 law has left them out? Are you aware of any of those cases? I think that's what you're asking.
I am not aware of anybody who availed themselves of it, but I also don't think there would be circumstances that would allow someone to avail themselves of
it. Would you mind elaborating on that?
On that part?
On the latter part.
So yeah, okay. So in prior to 2017, you could file a suit until you were age 25. Okay, so you've got that. In 2017, after 25, if you could prove gross negligence, you could file a suit until age 38. But this is all about child sexual abuse. So you had to be less than, and it wasn't retroactive. There was no retroactivity in there. So in 2017, you had to be a child being abused before that would take effect. So therefore, from 2017, the oldest you could be is 21 or 22. And so therefore, you haven't even crossed the line to 25. And therefore, it just, that circumstance hasn't happened yet.
I thought that the past, at the time, it gave you 20 years beyond the time of your becoming an adult.
It is, but it was already 7 years beyond becoming an adult.
So now you could be 38 years old.
Correct.
But again,
it wasn't retroactive. So if you were 26 at the time, or let's say you were 25 at the time, let's say you were 25 when that bill passed. You've now become 33, but since the bill wasn't retroactive, you're shut out anyway, because where you were at in 2017, the law in 2017 applies to you, which was you're still cut off at 25.
So to the second part of my question, which was about the people who aren't being served, I mean, do you have an idea of how many folk need this particular change that's being looked for?
Well, I can speak to the number of people who, we had dozens of people ready to testify. They submitted written testimony who are not covered, who need a retroactive bill because they could not come forward before they were 38 or 25 for that matter. They could not come forward. They have tried, they've tried negotiations. That usually breaks down. And so there are dozens. And I can also say, I moderate a support group for survivors of sexual abuse. I can tell you for every one person who's willing to testify, there's at least 100 people who can't testify, who are incapable of even considering sitting in a public forum and telling you about the sexual abuse that they suffered. It's impossible for them to do that. They just couldn't do that in this setting. So when you have a dozen people, I can guarantee you there's 100, there's 100, every one of them represents 100 people.
Okay. Thank you, Mr. Chair.
All right, thank you, Senator Sonor. All right, still going around the room for additional questions. Senator Castle's question.
Thank you, Mr. Chairman. I guess I'll start off with Senator Hellerman on questions. So on the civil side, the current law provides for 20 years after the date of majority, right? Which would take us to age 38, correct?
Correct.
In criminal prosecutions, as already been pointed out, there is no statute of limitations in Maryland, correct?
Mm-hmm.
I'm sorry?
Right.
Yeah. Do you know why? I mean, what's the difference? Why would this state have a difference between the statute of limitations in a civil versus a criminal case? Do you understand what the purpose of that, or what would be the genesis of that, the logic of that?
I can surmise, but why don't you tell me what your thoughts are about that?
Well, I mean, you've got two different standards of proof.
Mm-hmm.
We had discussed when this body addressed this bill back in 2017, the two different burdens of proof were critical, and yet the preponderance of the evidence standard for the civil case versus beyond a reasonable doubt in the criminal case, and so you know, we relied upon that. Does that, when you're looking at this bill, does it have any importance to you in how we look at the two between the civil and the criminal statute of limitations?
So I think there are different purposes, right? There are different purposes for our criminal law, our criminal justice system and our civil system. And I tried to get at this in my opening statement. And they're both important. And I think it's very noteworthy that Maryland doesn't have a statute of limitations on felonies. And I think that's important. But again, as I said earlier, that is the state going after the person for wrongdoing. And the civil system is an opportunity for the victim to prove their case, to go to court and hold both the perpetrator and those who are responsible for enabling certain actions accountable. And they're very different systems. And I understand the reasons for statute of limitations. Again, I would say that this is different and an important way of addressing this really significant issue in our society.
But the challenge I have is that, and I'm just trying to think through this because, I mean, look, I think all the members of this committee share an absolute abhorrence for child sex abuse. And we've done nothing to further the interests of sexual abusers at all. I think every bill that's come forward, we have moved forward aggressively on anything dealing with child sex abuse on the criminal side, the civil side. So we have a pretty strong record. But my problem is on this difference that in the civil, you know, when you talk preponderance of the evidence, that means that if you and I have a case and I have bad evidence, but you have worse evidence, then I win, or vice versa. But in beyond a reasonable doubt, there's this neutral objective standard that says, you know, a reasonable person has to be able to look at the evidence and say, that's not good enough. Your guilt's established beyond a reasonable doubt. And so when we go into the realm of just simply weighing who had worse evidence, and that's the challenge, because in these civil cases, we look at the differences in what statute limitations are. We talked about that. I mean, generally 3 years, but we go to 1 year in cases where the evidence, like assault, where the evidence is fleeting, it's gonna disappear. If where are the bruises, where's the marks, where's the witnesses on assault, versus some contract actions can easily be brought after 20 years because it's all there in paper. What do it's pretty clear whether you signed this mortgage and whether you paid on the mortgage. There's really credibility is not an issue. So I'm really concerned that we're not picking up on this fundamental difference between the two standards of beyond a reasonable doubt versus the civil, because this is something that this committee really upon heavily the last time that we looked at this statute, that making us feel more comfortable, which is why when we said there would be no limitations if you had a criminal conviction, because if you had a criminal conviction, the person was found guilty beyond a reasonable doubt, and so we would feel fine with just imposing civil liability on that, right? So there is that question, and so what I'd like to get into with a second is, and maybe I should address these more to the professor, Kathleen Hoke. Maybe I can discuss it with you, ma'am, because you're more of a neutral person there, and I can discuss that with you. Can you unmute the professor? I think I have you right, don't I? I'm sorry. There's all these little pictures here, and I can't see very well, so I'm not. Please, if I mistake you, I apologize. Right?
Yes.
You there?
I'm here.
Go for it.
I'm not sure. Okay, yeah. Now you're unmuted. So when I look at the purposes of the statute of limitations, and I go back, I did some research on this because I understand this is not. I mean, somebody pointed out that it was brought up that, hey, we just don't go on laws. Some laws are just sort of arbitrary. I mean, can you park here or park there? What's the speed limit? We can change all those things, but some laws have a really deeper purpose. And so I was trying to understand that. So I went back and did some serious reading on statutes of limitation and trying to understand the theory and the concept, because like everybody else, I don't want to allow victims to go without a remedy or abusers to go without the consequences unless there's a good reason, right? So I think you and I are on the same page on that one. But I looked at people like the U.S. Supreme Court. I don't know, going back and they say that statute of limitations is designed to promote justice by preventing surprises through the revival of claims after evidence has been lost, memories have faded, and witnesses have disappeared. And that's U.S. Supreme Court. That's a 1944 case. It's cited in California in 1980s cases. But don't you have a concern? Isn't there a concern that this would in fact allow? I mean, how do we address the Supreme Court's concerns in that case with what we're proposing here?
So I think extending the statute of limitations or removing the statute of limitations is a policy decision. And of course, you're balancing all of the things that you referenced. I do want to push back a tiny bit. I mean, no one disagrees with the fundamental reasons that we have statutes of limitation in the first place. Of course, those are the reasons. But what is the harm in lifting the statute of limitations here? And I think it is quite modest. Catherine Robb spoke to the fact that there are not bankruptcies, there are not organizations and entities drowning in the litigation in the states where they have had these look back provisions. Again, we're talking about a 2-year window during which folks can file these claims. And more importantly, our
the 2-year window says I can look back 40 years or 80 years.
Correct.
So it's not looking back 2 years. It's whether and how many thousands of cases can you get in that go back 80 years. So the 2 year, whether it's only 2 years is irrelevant, right? I mean, all that says is how quick can people file cases? And now we just go into electronic filing. I can file 1,000 cases in a week if I'm really busy at it because it's electronic filing. So it's not whether it's a 2 years, it's an 80 year, it's a 100 year. So let's be.
So it is a 2-year window in which a plaintiff would have to have sufficient evidence in order to bring the case in. Again, Catherine spoke to in the other states where they have done this, there has not been a flood of litigation. It's not opening the gates to thousands of claims.
Okay, well, we have the letter in the file, the letter we all got from Carrie Silverman that points out that, in California, when they put just a 2-year look back, Governor Brown, whatever one they have out there, they change a lot, had to veto the next proposed 2-year look back because it was bankrupting the state. So let's not say these don't have real implications. I mean, the financial, but I'm not so much interested in protecting people's pocketbooks as their lives. So, and society. So what, again, I'm not hearing that you're addressing, I mean, for example, here's another, it says, fundamental purposes, and this is again, Supreme Court, the fundamental purposes of such statutes is to protect potential defendants by affording them an opportunity to gather evidence while the facts are still fresh. So how can we possibly gather facts that are still fresh when I tell you for the first time 38 years after an event that this thing happened 38 years? How do we do that? I mean, and this is something we wrestled with the last time this came before us. It was like, gosh, 20 years seems like a long time. But how do we do that 38 years after the event, provide for that?
So in addition to there being statute of limitations, there are also rules of evidence. There are rules of civil procedure. And all of these are gatekeepers such that this potential flood of litigation, folks have to be able, the plaintiff has the burden of proof. So it's not who has better evidence.
No presentation initially. They have to be able to present a case, right? It has to, a very threshold case. But let's face it, a threshold case can say, based solely upon my statements, entirely, I could get in and make an entirely a case that would survive any motion to dismiss based solely upon what I say. It could have zero supporting evidence other than what I say out of my mouth. And that would be sufficient. If you don't remember what you didn't do 38 years ago, then my case is stronger than yours. So
the plaintiff bears, it's not an inconsequential burden to have to prove every element of your cause of action. And I think, to suggest that juries and judges would take lightweight evidence and be like, well, gee golly willikers, there's no defense, so we probably should believe this person. There's much more to it than that. But more to the point, if a plaintiff is able to 20, 30, 35 years later, construct a case of solid evidence where they can meet the burden of proof in a civil claim and meet all of the elements with that evidence, then they have demonstrated that they were the victim of child sexual abuse at the hands of a predator who was protected by the defendant. And that is the exact individual who we want to recover here.
Okay, so you believe that the jury, that as long as it passes the jury, then we've reached justice. That if a jury can consider a matter 1 year that happened a year ago or 60 years ago, whatever they conclude, we can rest assured that justice was achieved. That's what you're saying.
No, I believe that there are absolute flaws in our system of both civil and criminal justice. So I won't stand here today.
Would you agree that those flaws become magnified with each succeeding year and decade and decade and decade, that the flaws become magnified?
No, I think there are flaws in our...
You think a jury is just as capable of resolving a case that's a year old versus one that's 80 years old? It makes no difference.
The plaintiff's burden of proof doesn't change. The plaintiff still bears
the availability of the evidence available to the defendant to defend their case does change, right? It diminishes every week.
The plaintiff has to demonstrate that the defendant failed to supervise in a negligent manner. They have to prove duty.
Well, they have to prove
breach of
they
duty,
also have to prove
causation,
that somebody
and damages. They have to prove that there was the failure to supervise. This isn't just proving I was harmed by a sexual predator who you
But the defendant has to defend it against those allegations too, right?
The plaintiff has to first meet a burden of proof, or the case will be dismissed. The case will be dismissed pre-trial, or the case will be dismissed at trial if the plaintiff can't bring forth sufficient evidence to demonstrate every element of that cause of action.
All right, so you have much more confidence. Let me read you this from the Supreme Court, because I think your confidence in the jury system decades out isn't shared by, here's the Supreme Court in 1980. The process of discovery and trial which results in the finding of ultimate facts for or against the plaintiff by the judge or jury is obviously more reliable if the witness or testimony in question is relatively fresh. Thus, in the judgment of most legislatures and courts, there comes a point in which the delay of a plaintiff in inserting a claim is sufficiently likely either to impair the accuracy of the fact-finding process or to upset settled expectations that a substantive claim will be barred without respect to whether it is meritorious. In other words, at some point, the litigation process no longer serves its point. It's what they're saying is that the ability of the litigation process to ascertain the truth diminishes with time, and then at some point it's a 50-50 twin cost. In fact, here's the U.S. Supreme Court in 1979. Statute of limitations protect defendants and the courts from having to deal with cases in which the search for truth may be seriously impaired by loss of evidence, whether by death or disappearance of witnesses, fading memories, disappearing documents, or otherwise. So I'm not hearing anybody in this, including yourself, address the concerns that I'm seeing from the Supreme Court itself, and the ability and the innate ability of the litigation system to credibly deal with a claim that's 60, 50, 40, honestly, even 38 years old, but we've already committed ourselves to that.
I believe that our civil justice system, with the plaintiff bearing the burden, is a sufficient gatekeep in this circumstance. I also think that evidence, counter to the letter that you may have read, the evidence that Ms. Robb has presented and her testimony certainly reveals is that there is not a floodgate of this litigation. So the fear that the sky will fall and bankruptcies will rain down on us from organizations.
But I'm looking at justice. You're talking about bankruptcy.
I'm looking at justice too. Justice for the victims of sexual assault when they were children.
But the Supreme Court itself says we cannot achieve justice without statute. The U.S. Supreme Court and
the Supreme Court's not a legislature. They're not making this policy decision.
Well, but as they point out, most legislatures agree that you can't achieve justice.
Okay.
It is in fact true that most legislatures don't have open-ended statute of limitations in these circumstances. That doesn't mean it's the wrong decision for Maryland. I think this body is the body and not the Supreme Court to decide whether lifting this statute of limitations is right for the state of Maryland.
Yeah. Okay. Let me take one couple to Senator Zirkin, if I could.
Sure. Just Senator Cassidy, just before you, the doc from Carrie Silverman, that wasn't incorporated in this year's testimony. It was from last year or the last introduction. So I'll make sure the committee gets it. I actually did think it was, I'm literally rereading it as you're going through your line of questioning. So we'll make sure that the committee gets that. But
I think what I saw, at least the email that I got, Mr. Chairman, we all got, Matt.
I'm not seeing it in the bill file, but I'll.
No, it didn't make it in the bill. It didn't make it in the file, and which is a problem I've got. That the cutoff is 48 hours out, which is like, wow, that's a trouble. But that's okay. We'll deal with that.
We'll make sure. Yeah, I just want to make sure that that's cleared up. Go ahead.
Yeah. So I mean, hitting Mr. Zirkin, and I'm really curious because we talked a little about insurance, and you and I have bantered back and forth for a number of years about insurance and the effects of litigation on insurance, often in a very adversarial fashion, but always friendly and good natured. But you know, I look at how businesses and schools and everybody carries insurance just to protect themselves. I mean, you never know who you're hiring. I may think I'm hiring a saint and a wonderful person who loves, children in the right way, and it turns out that the guy is pure evil. So I'm trying to, when I look at this, trying to understand the impacts this will have on insurance, because how can I protect if I'm the business now or the entity, and I'm just trying to protect myself as an employer who really wants to do all the right things, who only loves children, who only wants to do the right things for all of them, but I can't get, I got to hire people. I can't run the business by myself. And let's face it, these people can be, it's been testified, they can be manipulative, they can hide themselves. So I got to try to protect myself. What issues do you see? I mean, the likelihood of picking up insurance coverage at any reasonable rate, where I've got a tail that goes back in perpetuity. And any thoughts? I mean, how can I possibly insure against this stuff?
So I don't know how I mean, look, this is a 2-year look back for a very specific, horrendous crime. But as I said before, in terms of other states, once look, I'm a plaintiff's lawyer, and once you get your hands on getting rid of statutes of limitations retroactively, it doesn't stop with the bill. And once the legislature shows its determination to find horrible cases and undo decades of civil law, I don't know how you do insurance, because quite frankly, if you make a determination that you can retroactively get rid of statutes of limitation going back decades for this, there will be others that have horrible stories too, and are very well deserving of getting rid of those statutes of limitations. So I'm not an insurance expert by any stretch. I know the insurance industry, I think, put in written testimony against the legislation. You might want to ask them about that. That's not my area, but I did want to, if I could, something that Ms. Hoke said about sufficiency of evidence, and I agree with her. I mean, obviously, we all understand that a civil case needs to be, there is a, and she emphasized burden of proof, but the burden is in a civil case can be met. I mean, I do it every single day. I mean, the burden can be met with testimonial evidence by your plaintiff, right? It's you meet your sufficiency of evidence by coming in and saying, look, I was a student at ABC school back in 1942, and the teacher was such and such, and here's what happened to me. That meets your plaintiff's burden of proof to get beyond to the defendant. You have testimony, you do not need, I see you shaking your head, but I assure you in a civil case, I assure you, you don't need a witness to your cause of action. And you certainly in this case don't need a defendant. I mean, I could tell you, 8 zillion car accident cases where this one says this and this one says that, and it's up to the judge or jury to make a determination as to who is telling the truth by a preponderance of the evidence. And so when you have a case that goes back to 1945, or you have a dead, or whenever it goes back to, and you have a deceased witness, and as Senator West posited, nobody around knows anything about that defendant. Nobody around anymore has anything to do with any of the people. They don't even know who you're talking about, but you do have a victim that comes up with a credible testimony as to something that happened many, many years ago. The defendant institution has no defense for that. I mean, you can't say he didn't work there. You can't say that he didn't do it, because you don't know. You don't have records on that. And so it puts the defense at an impossible burden to defend themselves. Now, does that mean a jury writes a check for $20 million for that individual? No, of course not. It's up to the jury to decide if the person has credible testimony, if they've met their burden, and so forth. But to say that somehow that hypothetical posited, where somebody comes and says, this happened to me this many years ago, I was a student at the school, and a volleyball coach did this, and here's where it happened, and I've had all this trauma, and I never came forward. This bill specifically allows for that lawsuit. That is the whole sum of this, of the retroactivity part of this bill. It is exactly what this does. This happened many, many years ago. They didn't file their case, and so you're giving 2 years for anybody historically to file a lawsuit. And that testimonial evidence does meet the sufficiency of evidence if it's deemed to be credible by the trier of fact.
Mr. Zucker, have you ever had, as a litigator, we're both the experience I've had, where on more than a couple of occasions, I heard somebody recite their case. I felt absolutely certain that that person was telling the truth. And then I saw video evidence that showed me that the person who probably had totally brought me in, and probably the jury as well, was actually horribly untruthful. And because you saw video evidence that totally refuted everything they had just said. I don't know if you've ever had that, something along those lines that I certainly have. And that evidence was only available because there was video evidence that happened to be available that refuted the oral testimony. You've had similar experiences?
Well, let me say this. I don't want to be in a position of commenting on people's veracity at all. Like, I believe victims, and I believe that when victims come forward that they have had trauma, and I don't want to get into that discussion. I really don't want to get into that type of discussion about anybody's veracity. What I'm trying to focus on is the law and the policy of a bill that permits these things going back so long, because the institution, it's not the individual that you're suing in these comments. Like, it's not the volleyball teacher that's in a lawsuit, right? It's the private school from all those years ago. And I do believe, that's who we're talking about, is the institution's knowledge of what happened back then. The institution And so, you know, whether somebody is telling the truth, not telling the truth, that's not the point of the policy that you're talking about here with retroactivity. It is taking decades old allegations, bringing them to light many years later, and asking, you know, again, not public, but only private schools essentially, to defend themselves when they have no record and no recollection, nothing to defend themselves on. They have no idea as to what happened all those years ago. And you can only just simply say, look, we believe you. But the result of that belief, the result of a private school saying, look, we believe you, we have no evidence to say otherwise, the result of that, of course, is potentially a multi-million-dollar lawsuit against that institution, against that school, and essentially against all the kids that are going to that school right now, because it doesn't come from nowhere. There's no insurance that I know of that has a tail of 60 years. So that money doesn't come, it's not like manna from heaven, right? That money has to come from somewhere. And if you get a multi-million-dollar judgment against a school, and I can tell you, my child's school is trying, and my child's school happens to be the same one where Senator Hedelman went and sent her kids. We shared that as well. And they're trying so hard to do deep dives and be transparent. We got a letter at the beginning of the year about something that happened back in 1970, the year before I was born. That letter, I assure you, in the hands of a trial lawyer that's as good as me, and I'm not that good, that letter is an admission. That letter comes into evidence. And if people use that letter, there will be a large judgment against that school, which then comes out of the school funds, which aren't exactly like plentiful right now, right? I'll give you another example, a hospital, right? Johns Hopkins University, that, you know, if something, God forbid, happened 60 years ago with some doctor and allegations are now made, that comes out of the hospital funds, right? Those are big pockets for us trial lawyers. And if, God forbid, something happened many decades ago and the doctor is now deceased, and so you really don't have any way of defending against it, but you sure are going to get a nice judgment if you get yourself before a jury with, and it may, let's assume for the worst, it happened. But Johns Hopkins is not in any position to go and defend themselves against some allegation for some physician from 6 decades ago. You can't do that. And so what you end up doing, in answer to your original question, is you settle those cases. You have your evidence of the testimony, and you would be a fool in a court of law to bring that to a jury, in my opinion. And, you know, it's too big of a risk for these deep pockets, which include the private sectors of schools, the private sector of hospitals, the private sector of religious institutions. Those are big, deep pockets. And so allegations, let's just make them all true, every single one of them. They are impossible to defend all those years later. And those are, and I, again, just back to Ms. Hoke, I assure you that testimonial evidence is more than sufficient on this issue to get through to a jury.
Thank you. If I could, just a few more questions to wrap up with Kathleen Hoke, Mr. Chairman.
Senator, hold on, Senator Hellman, we'll come right to you, okay? As soon as Senator Kelsey finishes up.
Kathleen, you're not muted now.
Kathleen open?
She's open. She's open. She was. You just muted her.
I'm here.
Okay, now you're back.
Can you hear me now?
I can hear you fine.
Okay.
And I can hear you as well. Thank you. So I'm trying to understand your testimony that about the legislative intent and the like. Okay, and here's what I hear you saying, and you can tell me if I'm wrong and explain it. Okay, what I hear is that the legislature passed a bill, and of course I was there, and I knew that there was a statute of repose. I assumed everybody else did, but obviously none of us can guarantee. We're not mind readers. It seemed pretty obvious from the language of the bill. I couldn't imagine it being more obvious because I read the bill, but some people don't read bills. I got that. But what we all knew was, clearly everybody knew that, there was an example given a few minutes ago that I think Mr. Lorenz was taking us through on who would qualify and not. So what you're saying, as I understand it, is it was pretty obvious that the statute at that time was 3 years beyond majority, which would taken it out to 21.
Seven.
Oh, 7. I'm sorry, 7 years. Okay, so it was taken out to 25, right? 20.
Yes.
It was 25. And so we all knew that at that time, if you were 8 years out, that you missed the boat, right? And that when we extended it out to 20, the guy between 7 years and 20 years, we weren't giving them a cause of action. That was pretty obvious in the bill, right?
Yes.
I mean, no dispute, that was what was happening. But now we're saying on this whole repose issue that, yeah, but we clearly never believed that we weren't depriving somebody from 40 years ago a cause of action. I'm trying to understand how this works.
It's not that. No,
I'm sorry.
yeah, no one believed. No one
We
believed
clearly
that.
understood we were taking, that that the person who was 10 years out didn't have a cause of action. That's totally indisputable. But now we're saying, yeah, but you know what? We didn't really understand that somebody who was 40 years out that we were depriving them of a cause of action. So I'm trying to understand how this works. How can you, I mean, I know some people think we're stupid, but that really sounds like you're not giving us any credit, that we would say, oh gosh, I knew I was depriving the guys 10 years out, but hey, I never thought I was depriving the people 40 years out.
No, not at all. So there's confusion between, whether folks understood the statute of repose versus whether folks thought that what happened in 2017 was reviving causes of action for anyone. No one believed that there was retroactivity, excuse me, in what was passed in 2017. But the folks who were here before you and the hundreds of folks who stood up in that gallery to let you know they cared so much about this, they believed they lived to fight another day. They thought they would have the chance to come back to the
so when C.T. Wilson, to get back to what Senator Huff showed us, when C.T. Wilson said, we're not coming back, then that was just a blatant lie because he knew he was coming back and that's why this mattered. Is that what you're saying?
No, I'm not speaking for Delegate Wilson at all.
Okay,
I'm talking
all right.
about that.
You're just assuming that he's a liar then. You're just assuming he's a liar because he must have known that.
Please do not try to put words in my mouth.
Well, this all seems ludicrous to me. So if I seem impatient, it's because I'm totally befuddled here because it sounds like we're talking out of both sides and I'm just not getting it.
What I'm saying is the advocates, the folks you see here today and the folks who you saw in that gallery believed they had the opportunity to come back and live to fight another day for a look back window, which we knew was happening around the country at that time. I don't know what Delegate Wilson believed. I wasn't even working on the bill at that time.
So when this body, when our committee spent all that time, we worked hard to come up with that compromise bill, and we worked really tough. We just had to expect that, hey, you're only working for this year. We're coming right back next year. We're not giving up. I just, it's a trouble with this legislature that's the way we play it here. It's like, why should anybody trust anybody to do anything? I mean, just fight like heck on every bill, every day, all the time, and don't give in. But that's beside the point. Moving on to your next point, you said that and let me try to find your words here. It was basically that where we ended up with that it didn't really achieve anything. But it seems to me that I'm trying to see. So the section extraordinary only where the public. You're asking where was the public interest? That was your point. I'm sorry. Let me put it correctly. You said, what did the public get out of this? What did the public get out of the current statute that it was only somehow the perpetrators benefited or something like that? But is that the answer to that a lot of folks, schools, churches, hospitals, knowing what the law was, said, hey, you know what? The legislature's spoken. It's time for us all, in the interest of identifying past abusers, we're just going to come clean. We're going to go into our files. And yeah, that one was just a totally unsubstantiated allegation, but we're going to lay it out there because maybe some kid is feeling, no longer a kid, somebody who was a kid then, but now clearly long post adult, to identify these people and to try to give them some credibility and closure. Didn't the law that was passed in 2007 didn't have the overwhelmingly positive impact that institutions did come out, that they did identify past perpetrators they might not otherwise identify because of fear that, well, it was only an allegation. And if I identify this, you know, people will then, if somebody wants to commit fraud, they'll say, well, oh yeah, that guy, yeah, I'll jump on that bandwagon. So once you put the names out there, it just opens yourself up for potentially fraudulent claims. But so didn't we cross that? Isn't that the big threshold we crossed, was to say, we're going to go ahead and openly identify these folks and start dealing with us and move forward then? Isn't that
No, I don't believe that the consequence of the bill that passed in 2017 was that organizations and entities, businesses, corporations, in any way, shape, or form, made public information about their sheltering of child sexual predators. There's not evidence of that, and I don't believe that is what has happened here. I do think that. I mean, if you can speak to evidence of that, I'm not aware of that. I mean.
Yeah, I mean, even the one that Senator Zurkin mentioned, just even the one school that came out and said, we've had these past people.
So there's an anecdote of one letter from one school that may feel that it needs to step forward to remediate the situation that happened. I don't know what their intention is there, but there certainly hasn't been an overflowing of information from organizations and entities that we know.
We can, all right, we can provide that to you.
Please do.
Now, if I can finish up with some questions to Senator Hedelman, and I'll wrap up. I appreciate your tolerance for me here. Thank you. Still here. I can't find her. Oh, there she is over there. I was like, they keep moving. When we do this, people come in and out and they move around. And so
the Hollywood Squares version.
It's a Hollywood Squares version with the moving squares though. I just want you to know the reason I got this jacket on is my heat's still not fixed. So I'm not trying to be casual here. I have to wear my winter coat.
I don't know how hot you'd be if the heat were on. I mean, come on, you know.
All right. So there was, so you made a few statements that suggested to me that part of the motivation here was that we needed to move people, that still we have 90% of the victims are hidden, and that we have to motivate to society. I think he said we need some systems put in place to address these issues. But and maybe I'm misconstruing you, but it just seemed to me, I mean, as somebody who grew up in the 60s and had friends who were abused and knew about it, and as a kid, and knew what the situation was versus where we are now. I'm just wondering if you're overlooking these. I mean, you know, when I was a kid, I don't know about you, but you know, if a kid was sexually abused, it was not encouraged at all that child would come forward. And I just look at where we've come over the last 30, 40 years with this, where children are taught about sex. I was never taught about sex abuse in 18 years in public school. Nobody ever talked about that one time. Now they're taught about it from first grade, probably even kindergarten, all the way up through it, about reporting and don't touch. Parents, I was never taught about this even as a young parent, and that's not that many years ago. And parents all go through this, and the institutions are taught, and people have to be fingerprinted and attend courses in that. And then when you get to prosecutions, you know, when I was a kid, just a local cop came out, and he was an expert in writing speeding tickets and parking tickets. And now he was brought out to do an investigation on a child sex abuse allegation. And now every reasonably sized police department has a special child sex abuse investigator who's going to come out, who's got trained and awesome capabilities, and they're probably going to take you to a state's attorney's office who's got a child, sex abuse prosecution unit, who has specially trained people in specially trained facilities to video record it. You've got medical people to go through that, and then when you get to the courts, you've got special processes in place just to deal with allegations of abuse, so children don't have to sit in front of their accusers, so that interviews can be done in a much more friendly situation to allow the child to actually talk, which is not where it was when I was a young person, believe me. So even designing in daycare centers and schools where they design security cameras are everywhere now, and restrooms are designed to avoid abuse. And just an entire our society has just changed radically. So are you suggesting that somehow unless we really make a radical change in our statute of limitations, that we're just not going to wake up? Because I wouldn't share that perception. So I'm just curious if that's what you're saying.
First of all, I'd like to say we have made a lot of changes, and those are all for the good. That doesn't mean that child sexual abuse is not happening now. I'm sure.
No, absolutely. Yeah, I agree.
Right? And I don't think you're saying that, but I want to
No,
make
I'm
it
not saying
clear.
that.
It is happening now. And it, even with all of those improvements, and I would agree, all of those things are potentially preventive, and they are good things, but it's still happening, and it's still happening a lot. And it happened back then. And unfortunately, what we know about these institutions too, is that they don't ever come forward on their own. It's always because they're responding to a victim that has come forward and is pushing them, right? Nobody ever says, oh, once somebody is identified, there's never an immediate, we're going to hold that person accountable. There should be an investigation. There should be, checking, but we have to believe people too. And with regard to your earlier colloquy with Senator Zirkin, people don't make these allegations lightly. And I appreciate that Senator Zirkin didn't want to get into the veracity of witnesses, because imagine what it takes to come before a body like this and then multiply it going before a court of law and having to share what people have experienced. I don't think anybody would ever do that lightly. And
don't you think that we have an obligation as legislators to realize that can happen? I mean, as a litigator, I do see it happening. I mean, there are people who are motivated by money, but don't you think we have an obligation to try to create or develop systems for ascertaining the truth that don't just simply shift the harm done to an abuse victim to a potentially totally innocent defendant? I mean, that's right.
That's what our legal system and our evidentiary system is about, that Ms. Hope described earlier. So we suss out that. But I
guess we just go ahead.
No, I don't think in places where they have, even in places where they have eliminated the statute of limitation, and even places where they have look backs, the experience is not that people are coming forward who have made up their cases. And with regard to whether this was settled back when, first of all, I'm a member of this committee now, and I'm a member of the Senate, and this is my bill. And Delegate Wilson has put in years and years of hard work on this, and he is to be commended for that, his passion, his experience, and his work. But I wasn't a party to those negotiations back then, and I'm not now. And this body, and I think you were a part of it in 2016, I believe it is, with Justice Reinvestment. This is what we do. We change things, we address problems in our system, and we make incremental change. And that's what no one would ever say, oh, we solved criminal justice reform back when, right? We're still putting bills in. You are, I am, members of this committee are still chipping away at the injustices as part of, of our criminal justice system. And I would argue that's what we're doing here too. There were problems, we addressed pieces of them. I would argue there are still problems, and that's what this bill tries to do, is tries to address them.
Well, let me ask Senator Zirkin if he can comment on that, because that's very interesting to me that we can never, there is no final. There's never a final on anything. I mean, I don't know how we do business, how we run a state if there is no final, but I'll ask him if he can comment on that, please.
Okay, then we're going to go to Vice Chair Wallstreicher after Senator Zirkin completes, because we're coming to the top of the hour here, and I think we've exhausted the inquiry. So
just like old times.
Yeah.
So I agree 1,000% with my Senator Hedelman, that every bill can be put in. The difference on this one, just to be clear, and Ms. Hoke's opposition notwithstanding, the Attorney General's letter makes very clear. I mean, what happened was Delegate Wilson and that cadre of the House made a deal, made an agreement. This was not going to be incremental. And the reason that it is because they cemented their deal with a statute of repose language that's in the codified language. That's whether CT said that this is it or not is irrelevant. I agree with Senator Hedelman to whether you bring a subsequent bill in. I would argue that this is different than I mean, first of all, that's how you know that the group, at least that made it back then, was interested in calling this a day, that we weren't going to do this every year, because they put statute of repose language in, which vests a right in the defendant, right? I mean, that's what a statute of repose does. Now, whether you think they should have, whether you think it's appropriate for this issue versus property, that's for the Court of Appeals to make that decision. The Attorney General is pretty clear saying that statute of repose language that was included in the language in the House and was put into the law, this wasn't snuck in. This was the amendments that were put in. And, you know, that's, the Attorney General is pretty clear. This is unconstitutional. They made a deal, and the deal was cemented for all eternity by vesting the right in the defendant. That's not why this is that's not why this policy is problematic. What happened was, though, in 2017, it's important to understand, and Ms. Hoke, I will send you some letters, but confidentially if it's okay. Like, schools and others did rely on that language in the law. They did do deep dives because they want to be transparent with their students, with their faculty, with others about things that happened historically. And so what they did is they hired investigators to go back many, many, many decades, and they did investigations and reports based in reliance on the fact that they weren't going to have that then get thrown in their face in a lawsuit. So, and I don't want to mention on, in public what the schools are, but many of them did it, right? They did these deep dive investigations. They interviewed students. They tried to find as much as they could, and then were transparent. If you pass this bill, that deep dive by those schools ends up in a multi-million-dollar lawsuit against them. It is an admission of liability from back in the 40s and 50s, and this bill would permit all of those plaintiffs to come back and sue them for tens of millions of dollars. That is a fact, and they did that in reliance on our 2017 law, on the 27 agreement that put statute of repose in there. I know that some of you weren't, or all of you actually were here when you voted on this thing, but that language is what it is. Whether people knew what it was or didn't know what it was is completely immaterial to a conversation before the Court of Appeals. Completely irrelevant whether Delegate Wilson or I or anybody else understood fully what a statute of repose is. It is and I'm not saying one way or the other, it doesn't really matter. It is the plain meaning of statute of repose and vested right into this thing, in the defendant. And they have the right to rely on that statute of repose to do things like do deep dives and to uncover things, right? One of the letters that I got from a school talked about something that happened back in the 1950s. The teacher from that school has been dead since 1972. That letter by that school is an admission of liability. It's an admission that back in 1954, something happened, and it is a multi-million-dollar lawsuit in a piece of paper. I mean, any lawyer would take that case like that, because that is that case against that school, they may as well get out the checkbook right now, because that thing never sees a jury. And they did it to try to be transparent about things that happened back in the 50s.
So are you saying that school should not be held accountable if they have the experience of having hidden something in their files and knowingly?
That's not what I said. I did not say that they hid. I did not say that they hid anything in their files. They hired an investigator to go interview. Nobody at that school has any recollection of the individuals that they're even talking about. Like, nobody there right now knows this person from he died, the teacher or counselor died in 1972. Nobody that works there now, none of the students know who they are. That's the year after I was born. I mean, it's 49, sorry, dating myself, years ago. And the school hired an investigator to go do a deep dive and find out everything they could. They didn't say that they were involved in it. Nobody made that allegation. And this bill doesn't require you to prove that the school had that the administration of that school doesn't need to have been aware of it. The fact that that was a counselor at the school and some of the abuse may or may not have occurred on grounds is enough to file a lawsuit against that school. And you can, look, Should somebody be held accountable? Sure, that guy should have gone to jail. Did that happen? No. Do you want to put that school out of business because of what happened in 1954? That's the policy decision. Because I can assure you, they don't have $20 million lying around, right? It's not just coming from like under a mattress somewhere. So that's the policy decision. Do you put that school out of business and all those schools either back to another private school or put that school into bankruptcy because of something that happened in 1954? They admitted that they think that something did in fact happen in the 50s. Should you put that school out of business for that? I don't know. I mean, that's the policy decision. We, and not just we, but the delegate and the people that worked out that agreement made the decision that that was not going to be the policy of Maryland. And they put it in stone because they put statute of repose in there. So that was the decision that was made in 2017. And I think it's the right policy because I don't think you put that school out of business because of something horrible that happened back in the 50s. That's why we have stat. And that school uncovered it. But forget about them for a second. Find the one that didn't find anything. Somebody makes an allegation. How is that school with administration that was born after the alleged perpetrator died? How are they possibly going to defend themselves against that lawsuit? I would argue, as a plaintiff's lawyer, they're not. And they're going to settle with me on that case because there's no way you bring this type of case. If you can't defend yourself, and this person's making a credible argument about something that happened in the 50s, you can't defend yourself. So you can kiss that school goodbye in terms of serious money. Maybe there are some private schools that can handle it, but I can assure you there are many private schools that can't. And I would return, because we haven't said it in a while, so I just want to be clear. This only applies to that school. The public school down the street, our state funds, our tax dollars, Kerwin, you're not implicating any of them. Now, I know, Senator, you said at the beginning that you wouldn't mind doing that. I would suggest that that would be many, many millions, maybe hundreds of millions out of the state coffers. So Kerwin is in danger for something like that. The public entities have no liability for the same things for these privates. That's what makes this bill so kind of like, you look at it, you're like, really? So if something horrible happened in 1954 at ABC private school, we're okay putting them in the crosshairs for a multi-million-dollar judgment. But the public
treat public and private separately, and if this bill doesn't do it, then we should amend it to make it so.
Okay, I appreciate that. That would make this make more sense. But I would suggest that before that, doing away with sovereign immunity retroactively, going back and saying, look, I know that the state was not allowed to have any lawsuits brought against them all the way up into the 80s, to simply kind of in a bill say, you know what, we're going to retroactively get rid of that. That puts the state and the counties on the hook for potentially hundreds of millions of dollars, hundreds of millions. In California, when they passed a bill like that, Senator Huff was right. There were settlements and judgments to the tune of, I think, against the Catholic Church, I think it was like $2 billion. You do away retroactively with sovereign immunity, which does make more sense, right? If you're going to treat the publics and privates the same, that is hundreds of millions of taxpayer dollars for things that happened 50, 60, 70 years ago. That's why for 20 some odd years when we heard this bill, the legislature uniformly said, we're not having any retroactivity because it just didn't make sense to bankrupt private institutions for things that happened 6, 7 decades ago. They're horrible things, horrible. And I think you should put anybody in jail who knew about it. You know, you have that bill about actual knowledge, put them all in jail.
So all right. We've got 2 more questions from senators. Senator Castley, were you finished with your line of questioning? Okay, Senator Castley's finished. Senator, Vice Chair Wallstreicher, you're next, and then Senator West. So. All right, there you go.
Thank you, Mr. Chairman. And this is a difficult hearing, and it was difficult when we heard it the first time a few years ago. It continues to be difficult because of the subject matter, but also because this legal argument that we're having, which is so critical, also, I think, I'm worried, distracts us from the core of the discussion, which is the victims in this case. So I guess my question is for Mr. Lorenz, and I had to step away. If this question was asked previously, Mr. Chairman or Mr. Lorenz, please let me know. But Mr. Lorenz, you kind of started to give voice to some of the victims that had communicated with you briefly, given how long this hearing has gone. But I was hoping you could give us a little bit more of what you started, just so we can kind of center the voices of the victims within the hearing.
Thank you for giving me that opportunity. I very much appreciate it. There's a couple things that I want to point out, and I would like to read a few more of these things, but the thing that comes through time and time and time again is these survivors were often threatened either with their life or with their well-being or their family's well-being by their perpetrator. And for a child to take that and then expect them to come forward at the age of 18, 25, 38 is just unbelievably, it's unbelievable that you would expect that to happen. They're just not going to be able to come forward. So I would like to add some of these things. And thank you for giving me the opportunity. I was sexually abused by a priest by my mentor and friend at the age of 16. It was a difficult time for me and I almost drowned in my anguish. The emotion I remember the most is being terrified. I never told anyone as a child. It was implied that if I ever told anyone, God would be mad at me and I would go to hell. Keeping the abuse secret was my primary goal because my perpetrator promised to harm my parents or siblings if I mentioned any word about it. What recourse does a child have in this scenario? I suffer from debilitating depression, unable to get out of bed too many days. The best type of housing I can afford is former motel building, which is filled with drug users. In Delaware, the SOL was eliminated and justice can be served. I suffered at the hands of the same institution and the same perpetrator, but it occurred in Salisbury, 6 miles on the other side of the state line. So no justice. When it was over, I flew outside, red-faced and crying, and went to the school bathroom. My uniform was wet with an unidentifiable white substance, which I wiped off and then returned to class. I told a teacher about the abuse, and she never told my parents. My parents were devastated and tried to take action at the time, but the school only shrugged, and when my mother consulted the Anne Arundel County State's attorney, he strongly dissuaded her from contacting law enforcement. I also struggle with the fact that the person who abused me was not only someone I trusted, but also had the respect of my entire community. How does a child go up against that? And then finally, I am blamed for not speaking out earlier, for not doing what was not possible for me to do. Once again, I am told it is my fault, just as I was told when I was 5 years old. And that's the last one. And I thank you, Senator, for giving me the chance to walk through that. I would like to make one more point. You know, there was a discussion back and forth about a car accident, and one person says one thing and one person says another. The difference here is that we all know there was a car accident. In this case, we're asking children to come forward. You know, no one's disputing there was a car accident. We're disputing whose fault it was. Give these children their day in court. It's just to show it. And then one more thing, you know, the Bishops Research Council, there was a John Jay report put out by the bishops when this all broke in 2002. And the bishops did their own report, and it shows that fewer than 2 or 3%, I can't remember the exact numbers, might be 2, might be 3, of allegations against the priests were false. Fewer than that. And I think that point needs to be made. Thank you for giving me the opportunity.
Excellent. Thank you, Mr. Lorenz. Next question is Senator West. You're up.
Am I on camera and everything?
You're good.
Okay, great. It's been a long afternoon. And so my questions were just really brief for Mr. Zirkin, Senator Zirkin again. I'm thinking more about Senator Heddleman's offer that she would expand this bill to include public schools as well as private schools. And I don't think you can limit it to schools. Wouldn't you agree with me if we're going to expand this to include public entities? It would also have to include claims made about something that happened 50 or 60 years ago in state mental hospitals, state detention centers and prisons, state reform schools. We don't have those anymore, but we used to. 60 years ago, the state had reform schools, state hospitals, the list goes on. So aren't we really, and somebody earlier mentioned the concept of a Pandora's box. If we follow Senator Heddleman's lead on this, aren't we really opening up Pandora's box in terms of the liability that the state could be put to?
Would you like to answer that question, Senator West?
Oh, I'm sorry. I thought I was directing it to Senator Zirkin.
Excellent. There you go.
There we go.
There are new systems for legislation. Yeah, I mean, look, if you retroactively try to do away with sovereign immunity for the public schools, you're going to do Cheltenham and Hickey's and the Rosewoods of the world. I mean, it is unlimited liability for the state and for the county. I mean, I don't think any state, maybe I'm wrong, I don't know, I can't imagine that any state has retroactively waived sovereign immunity going backwards. But I appreciate Senator Heddleman saying that, because I don't think you can do it, but it obviously makes more sense to treat everybody the same. And this bill and the law, grew up in a way that you just can't. But yes, if you do that, if you were to try to include the publics, you're not just talking about schools, you're talking about the Department of Social Services going back to the beginning of time, right? So if somebody, and I remember Delegate Wilson's very brave testimony had a lot to do with a family and Department of Social Services. That's a public entity, right? That's a public entity that you're waiving sovereign immunity, you're going back many, many years, and you're filing suit against the local jurisdictions in the state. I mean, it is an unlimited amount of lawsuits, which is why there's a lot of my brethren in the plaintiffs bar who are kind of, interested in this type of an issue. I'm not trying to take away from the victims. I think the victims are incredibly brave and incredibly passionate and emotional, and I appreciate I've for years appreciated everything they said. But this bill, particularly with what you just said, I mean, that is potentially billions of dollars. That's not millions, that's billions. If you look back on Hickey and Cheltenham and the Department of Juvenile Services, even just 20 years ago, there were horrible things, 30, 40, 50. I mean, those places were really horrible, which is why we reformed juvenile services. You waive sovereign immunity, every one of those kids could make an allegation now for those things that happened 50, 60 years ago. It's billions of taxpayer dollars, not millions.
All right, Senator West, satisfied?
Yes, thank you.
Okay. Looking around the room and seeing no further questions, I just want to say thank you to Mr. Lorenz, Mr. Hoke, and Ms. Robb. Thank you, Senator Heddleman. Thank you, Senator Zirkin. This has been a difficult discussion, but I'm glad we were able to have it with a level of civility and inquiry. So I think we've got a lot more work to do, but I just really appreciate your time. So with that, that concludes the hearing and the testimony for Senate Bill 162. We're now going to move on to Senator Heddleman's second bill of the day, Senate Bill 134.
No.
Actually, sorry, Senate Bill 162.
Yes.
Senator Heddleman, you're up.
Thank you very much, Mr. Chairman. For the record, I'm Senator Shelley Heddleman from District 11, and I am bringing forth a bill, Senate Bill 162, which is called Civil Action Strategic Lawsuits Against Public Participation. A SLAPP suit is intended to shut down free speech by someone who's made a public statement before a public body or a citizen who's spoken out about an issue or provided a review or criticized a public powerful figure. It's intended to silence, inflict financial damage, and intimidate. This bill would assist the defendant in such a lawsuit and make it more difficult for plaintiffs to exert their power in wearing down the defendant. The bill clarifies that our SLAPP statute was which was one of the earliest in the country and most powerful, extends speech beyond those just before governmental entities to include online and blog reviews, letters to the editor, and other venues commonly used by community members to share thoughts and ideas and to assist the community in choosing goods and services in the marketplace. The bill makes a number of very important improvements to our current SLAPP statute. First, it eliminates the requirement that a plaintiff demonstrate bad faith in bringing forth the suit. This was a unique provision in our law that proved difficult and costly and required extensive discovery. The current bill requires focus on a meritless complaint. Two, it enables attorney's fees to be shifted, providing a deterrent to a deep-pocketed plaintiff. And three, it requires courts to act promptly and hold discovery until there are expeditious rulings. It's important to note that none of these changes to current law would serve as a chilling effect to legitimate lawsuits, since expedited procedures would weed out meritorious claims efficiently. The bill also includes assurances that certain commercial speech does not qualify under the SLAPP statute, enabling appropriate suits over product liability and deceptive trade to remain outside the SLAPP scope. We believe these changes to our SLAPP statute will make it among the strongest in the country, and for these reasons, I ask for your support of Senate Bill 162. And my panel will talk about some real life SLAPP situations and provide a deeper dive into some of the legal issues. Thank you. I think Mr. McLaughlin is our first witness.
Okay, there it goes. Sorry, it wasn't letting me unmute. Thank you, Senator Hedelman. And thank you, Mr. Chairman and members of the committee for the opportunity to testify. I'm Jim McLaughlin. I'm Deputy General Counsel of the Washington Post. I will talk in more detail about each of the three main provisions of the bill that Senator Hedelman flagged, but I wanted to start by stepping back and just giving this committee a sense of the big picture and why we believe this legislation is urgently needed. I've been a newsroom lawyer for 14 years, and within the past several years, there has been an undeniable trend that has been commented on by many in the industry, not just me, that there's been sort of a weaponization of libel law for purposes of silencing and punishing speech. And I actually dislike the word weaponization. I think it's overused, but there's really no other way to describe what's actually happening. There has been a massive increase in demand letters, massive increase in the number of libel lawsuits filed. And often these libel suits are by deep-pocketed, powerful individuals who have many more resources than the defendant. And I should say that the Post, which I represent in part, is fortunate in this regard. We do have the resources to defend libel claims, but I'm also here on behalf of the Maryland, Delaware, DC Press Association, whose members often do not. And that's the point of a SLAPP lawsuit. It's not to win the case, it's to deter coverage or deter a citizen from speaking publicly by making it expensive to do that. And many of these cases are brought where the plaintiff knows that he's not going to win the case at the end of the day. That's not really the point. The point is to inflict financial harm through the cost of litigation itself. And that's the harm that Senate Bill 162 is designed to prevent. And incidentally, that is real harm was recognized by the Office of Attorney General in its letter of support for the bill. To briefly go through the provisions that Senator Hedelman flagged, one of the changes is that it would replace the subjective bad faith requirement in the current Maryland statute, which is literally one of its kind among the 30 or so state anti-SLAPP laws. It's the only one currently that requires the libel defendant to show at the very outset of the case that the lawsuit was actually brought in subjective bad faith. It's not a workable standard. Knowing the state of mind of the plaintiff is not something you can get without discovery, and it's preventing the cost of discovery that is the purpose of anti-SLAPP protection in the first place. The bill would replace it with an objective standard that's much more in line with the standards used in those 30 other anti-SLAPP laws that I mentioned. Secondly, the bill would provide for mandatory fee shifting when a SLAPP motion is successful, an anti-SLAPP motion. The reason that's important is that there is every incentive currently for the so-called libel bully to threaten a suit or actually bring a suit that he knows he probably won't win at the end of the day. But the point is to incur legal expenses for the defendant. If mandatory fee shifting were implemented, as it is in 25 of the other state anti-SLAPP laws, that immediately changes that calculus, because the defendant has at least the prospect, if successful, of recovering their attorney's fees, and that greatly reduces the incentive to use libel litigation as a means of bullying smaller adversaries. Finally, the bill would require that judges rule expeditiously on anti-SLAPP motions after they are filed and a hearing is held. I won't say that much about that unless there are questions about it. But it's a moderate standard. Some other state anti-SLAPP laws require a ruling within a specified number of days, or even allow appeal from a failure to rule. This bill does not do that. It simply requires that judges rule expeditiously. And lastly, what the bill doesn't do, and I want to emphasize this, is prevent meritorious claims from proceeding. There have been plenty of successful libel cases brought in jurisdictions like California that have much tougher anti-SLAPP statutes than Maryland has, or that even would have under this bill. If a plaintiff can show that their case has a substantial basis in law and fact, they will survive an anti-SLAPP motion.
Time.
So for those reasons, Mr. Chairman and committee members, we urge a favorable report for the bill, and I'd be happy to address any questions. Thank you.
Excellent. Thank you, Mr. McLaughlin. Good to see you again. Next, we will have Mr. Jeroshal. You are up next. Saw you over here. There you are.
Thank you very much. My name is Ronald Jeroshal. I'm testifying on behalf of the Maryland Association for Justice. We have a position paper that I submitted, and attached to that is a listing of all the states around the country that, in fact, have modernized their statutes. It's very instructive, because this Senate Bill 162 modernizes the Maryland law and brings it into line with those other states. These lawsuits are intended not only to stop free speech, but it's also intended to stop expressions in the public interest, like, for example, something for public safety, or something of that kind, a real product liability lawsuit, or distributing flyers. In my campaign in 2010 for judge, we got hit with a cease and desist letter because of things we were saying about our opponent, and that's the kind of thing that Mr. McLaughlin just talked about. Cease and desist letters are very common as a way to dull and stop free speech. I'll just finish up with talking about the attorney's fees issue. The attorney's fees section is very important as a deterrent, and we would ask you to have a favorable report on this bill. And I know you have a long day, so I'll conclude. Thank you.
All right, excellent. Thank you very much. And next we have Mr. Levy. Hold on, that's it.
I have to push my own mute button, I see. So Public Citizen supports this bill because it provides strong support for speech on matters of public concern. We've seen anti-SLAPP statutes work effectively in other states to prevent the use of litigation to express speech. Litigation brought not on any serious concern that the speech is actionable, but in recognition that the very cost of defending against litigation, particularly by somebody like a consumer who has no financial stake in speaking, can take valuable contributions out of the marketplace ideas and can chill the exercise of the right to speak freely about companies and individuals after they've established a track record of going after their critics. I myself have litigated motions under several anti-SLAPP laws in various states. I've seen the good ones work effectively, and I've seen the limitations of the weak ones. A good anti-SLAPP statute discourages plaintiffs from suing over speech unless they have good reason to think they can prevail. It requires courts to take an early look at the merits of such cases, and then it creates a financial incentive for lawyers in private practice to defend cases brought over protected speech. And by creating that financial incentive for the lawyers, it enables those who've spoken fairly to stand up for their rights. Now, my written testimony mentions several examples of slaps that have happened in Maryland, but I want to talk this afternoon, or evening indeed, about an even more recent example of how a better anti-SLAPP law in Maryland could work even before the litigation began. There was a recent controversy in Baltimore about whether a certain Fells Point restaurant should have its liquor license renewed. The neighbors were up in arms about the amount of noise. Shortly before the hearing, the lawyer for the restaurant sent 15 residents a demand letter threatening to sue them for making unspecified false statements and threatening spoliation sanctions unless they preserved all the evidence. Now, needless to say, the people who got these letters were terrified. They knew that if they got sued, it could cost them tens of thousands of dollars to defend a libel suit. So most of them did not show up for the liquor license renewal hearing, and the license was approved because there wasn't substantial evidence opposing the license. Now, much of the work that a good anti-SLAPP law does is pre-litigation. Had this proposed bill been in place, the neighbor's lawyer could have explained to them, if a lawsuit is brought, it's going to be dismissed early, so long as you are honestly expressing your experience with noise. And they could also, they could have acquired a defense on a contingent fee basis. And getting such assurances can help encourage citizens to speak their minds, even when they are threatened. That's what I have to say at the outset.
Excellent. Thank you, Mr. Levy. Next, we will have Ms. Snyder. Rebecca, you are good to see you. You are up next. There you go.
Sorry, host was unmuting me. Good afternoon. It's good to see you, Chair and members of the committee. I'm Rebecca Snyder, Executive Director of the Maryland Delaware DC Press Association. And I just want to kind of knit together some of the things that Paul and Jim and the Senator mentioned. Maryland needs the reforms represented in Senate Bill 162. There has been increasing litigation, increasing threatening lawsuits to squelch public participation. And this statute is designed to protect individuals and the press, members of our association, against these encroaching ways. So Jim talked about, the removal of the bad faith language, the mandatory fee shifting. Those are very concrete ways that we can diminish and ward off some of those suits. And as Paul said, the threat of a lawsuit is extraordinarily chilling for an individual, but it's also chilling for the members of our association. SLAPPs stifle public debate, and they diminish news reporting and civic engagement. So many of our publishers are small. The economic times are such that they do not have the bandwidth to defend. Even a frivolous, easily dismissed claim can run nearly $10,000. And so when our members have to churn through that kind of money, it takes away from news reporting. It takes away from informing people about their communities. So we do feel like this is a strong step forward for all of Maryland, and we urge you to pass a favorable report. And I would just leave you with the thoughts of one of our members, Sue Lyons from the Coastal Point. She is an individual owner that has poured everything into her news publication. And she feels like if she had one SLAPP suit, that would literally lead to financial ruin. She is in, like many of our members, in her second round of PPP. She is holding it together, investing everything she has, and one suit could topple it. Her community is small. It is tight-knit. She reports on the day-to-day of her community. And she feels that it's not right that whoever has the deepest pockets gets what they want, even if it's not in the best interest of the community. So I would urge the committee to stand with Sue Lyons and the members of the Press Association and issue a favorable report. Thank you.
Excellent. Thank you, Ms. Snyder. And always good to see you. With that, we'll switch over to the opposition panel, and Senator Heddleman, you're in luck here. I don't see, I think Vince McAvoy signed up. I don't see him in the room. And then Claudia Barber, here you are. Miss Barber, you are up.
Good afternoon or good evening, everyone. I say good afternoon to Mr. Chairman and the Vice Chairman and Senator Heddleman, who sponsored this legislation. The strategic lawsuits against public participation bill looks very meaningful on its face. However, it may have grave consequences against public figures by arming citizens with the right to report anything and everything to public entities and rewarding those citizens who, with ulterior motives, report. You're rewarding them with immunity. Just last month, we saw on January 6, 2021, how people engaged in conspiracy theories wrongly claiming First Amendment protection for their insurrectionist acts of terror. The First Amendment should never again be used as a crutch to harm individuals or destroy human beings. One of the pitfalls of this legislation is that it does not protect innocent victims, such as public figures or yourselves as politicians, who may have rivals instigating stories by using public records, resources, and government agencies to create news stories to smear an opponent. It particularly impacts people of color and their communities when misinformation is spread to newspapers and destroys individuals' livelihood and their reputation. In 2016, an individual filed an ethics complaint against me, asking my employer to remove me from office because I ran in a partisan primary. But what was not told to my employer is that the office that I was running for was not a partisan office. It was important not to tell that part because it would have destroyed the plan to have me fired for an ethics violation, which was later used on campaign literature. The purpose of filing the ethics complaint was to harm my livelihood because the complainant demanded my employer terminate me. All this was done so opponents could advance in their election. After making a Freedom of Information Act request, I learned that the complainant's the pursuit of my termination was deeper than just filing an ethics complaint. So I urge everyone, before voting yes on this legislation, please reconsider the impact this legislation has on the community and individuals. Thank you.
Yeah, no problem. Right. Thank you, Ms. Barber. And with that, that concludes the testimony for Senate Bill 161. I'll switch over to questions. Senator West, you have a question. You're up.
Thank you, Mr. Chair. It's an interesting bill. I'm trying to figure out what the ramifications are. Let me just ask a question about one situation that came to mind. Rudy Giuliani has been sued by Dominion Voting Systems because he alleged over and over again, along with some of the other attorneys representing the former president, that the Dominion systems were rigged and that they, in effect, stole the election for the newly inaugurated president. So that lawsuit by Dominion against Mr. Giuliani, I think, is in the millions of dollars, as I recall. Would Mr. Giuliani, under this bill, if this bill applied, be able to get that lawsuit dismissed on the grounds that it was a slap suit?
So, well, Mr. McLaughlin, do you want to answer that, or do you have a?
Sure. No, I don't believe you would. I mean, we'll see what happens, I suppose. But that suit, from what I've seen, clearly has a substantial basis in law and fact, and therefore, I predict would easily get past an anti-SLAPP motion.
Where is the substantial basis in law and fact language in the bill?
It's in.
reading the definition in the bill of a SLAPP suit, it's brought against a person based on a statement of the person that was done in furtherance of the person's free speech rights, including an oral statement made in a public forum in connection with an issue of public interest.
The language,
Much like what Mr. Giuliani was saying about Dominion voting system.
the language that Senator West is asking about is in subsection 2 of section E. It's subsection E2 that says it's the plaintiff's burden in responding to a motion to dismiss that the alleged SLAPP suit has a substantial basis in law and fact. So to clarify Jim McLaughlin's answer, I think that the speech by Mr. Giuliani about Dominion voting systems plainly falls within the scope of the law, so that the plaintiff would then have the burden of coming forward with substantial justification in law and fact. Now, I've read that complaint because I try to follow libel litigation. There is a wealth of detail in the complaint that may well, assuming that it's supported by evidence and not simply an allegation in the complaint, show a substantial basis in law and fact for the libel claim that Dominion Voting Systems is bringing. Obviously, it's going to be if this were brought in the state court, in the Superior Court of the District of Columbia, it would be up to a Superior Court judge to decide whether that evidentiary standard was made. In Maryland, same deal. You would have a Maryland judge passing on whether the plaintiff had a sufficient basis to allow the plaintiff to go forward with the rest of the litigation. Based on what I've seen in the complaint, which has I say a great deal more detail than you usually see in defamation complaints. My prediction is like Jim's, yes, this would likely go forward. But of course, it's up to a judge to make that decision.
Sure. Thank you very much for that very helpful explanation, Mr. Levy.
Excellent. All right, Senator Castley, you're up.
Thank you, Mr. Chair. So we constantly have the debate with the chief judge about I do anyway, when she comes before the committee, about what's public policy versus your traditional courts are ruling on matters of law and things they were set up to do. And along those lines, I'm trying to decide, I'm like Senator West, trying to decipher this interesting stuff. I love the topics, so it's great. So I'm just trying to give it a due diligence here. I'm looking on page 2, and it said a lawsuit is not a SAP suit if, I'm down at line 27. The lawsuit is brought in the public interest, and it's also, we dropped the term bad faith, I see. So it's in the public interest. How difficult, how much of a subjective determination is that? Are judges going to be able to, isn't that a policy to say whether something's in the public interest? Things that I might think are in the public interest, a judge may say public's got no interest, or vice versa. How is there case law out there to say how does a judge determine that?
This is, of course, an exception to the coverage of the anti-SLAPP statute.
Yeah, it says a lawsuit.
Let me give you a couple of examples of things that might be deemed to be in the public interest and thus within this exception. Say you have a public official proceeding on behalf of a public jurisdiction over the violation of a sign ordinance. And the public official is enforcing the public's interest in not having ugly signs along the highway. Seems to me that that's probably something that would fall within the public interest exception. Or say you have a
sign manufacturer.
I'm sorry, what?
Unless you're a sign manufacturer.
Well, you may or may not prevail in the litigation, and there may or may not be a valid First Amendment defense to the validity of the sign ordinance. But the determination of whether the sign ordinance was valid or not would not be subject to anti-SLAPP remedies, because the public official is here proceeding in the general public interest and not to get money for himself. Another example is class actions that are filed not to get money for an individual, but to deal with a common problem that affects a broad segment of the public. And I think that's the other main thing at which this exception is directed.
Yeah, if I could just briefly add to that, this exception, I think it's important to keep in mind that it's not just that the lawsuit has to be in the public interest to qualify for this exception. It also has to meet each of the conditions that are then enumerated. And those conditions essentially constitute a definition of consumer protection litigation, unfair competition litigation, public interest litigation as it's traditionally understood, as opposed to a libel suit in which the proverbial libel bully is trying to enrich himself and make the other party go to the poorhouse. It's not just that a judge would be able to say, well, I think this libel suit this suit is in the public interest, so it's going to go forward. There's all that additional language that is designed to carve out really the kind of work that Public Citizen does, litigation on behalf of members of the public.
And final question to, I think Ms. Snyder, I think this goes to you. My recollection was that you testified that this is becoming, I think you said epidemic. And I'm not hearing about it. Maybe you can, who's filing these on what issues? What is this epidemic? You're still muted. If you can please unmute Rebecca Snyder. Wait a minute, you're still muted. Don't talk yet. Can you please unmute Rebecca?
Who do you want to, yeah.
Rebecca Snyder.
Hold on.
And then Rebecca, you have to unmute yourself after you're allowed to unmute.
There you go.
I'm there now.
That was my fault. I was slow on the draw there.
That's all right. So thank you for that question, Senator. And I wouldn't characterize it as epidemic, but in the testimony of the panel, you heard about the Chop Tank suit. You've heard about the Clipper Mill, 2 instances from Baltimore. We're not hearing them, so I wouldn't characterize it as a wave against press per se, but we're seeing more. I'm hearing more on an individual basis than on the press basis in recent years. There was a case in Bel Air a couple years ago that actually Delegate McComas talked directly about when we were testifying last year on this bill. So it seems money is a very effective way to squelch public discussion. I would think that Jim had mentioned earlier that he's hearing within the ranks of newsroom lawyers, attorneys, that he's seeing this kind of writ large across the country. And so maybe he can speak directly to the press. We're seeing it more in the Maryland area, developers and individuals and businesses striking back against private citizens. And this bill is not just for press, it is for everyone.
So you were referring more to when you were saying the numbers are growing, you weren't referring so much to the press being a target on that, not that they're not the target, you were referring to on the individual side.
That's what I'm hearing. And I don't tabulate and count the numbers.
Okay.
I'm hearing it much, much more. We've been working on this issue for many years. And I'm hearing more and more about it. And it's not because I'm more sensitized to it. It's because I think there's more litigation happening.
All right. Thank you. Thank you, Mr. Chairman.
All right. Let's have Mr. McLaughlin and Mr. Levy. You are already unmuted, so you're next, and then Mr. McLaughlin.
Yeah, I would just add to what Rebecca said that the press certainly is, I think, seeing more libel suits and far more threats of libel suit, which is sometimes the same thing is intended by the demand letter. The message is, if you write about us anymore, it's not going to be worth it because you're going to get a demand letter every time. And some of those are going to lead to lawsuits. But I can speak for the Post. I mean, we've been sued far more in the last 3 years or so than we had in probably the previous 10 years. And I'm hearing that from my counterparts at other national media companies too. And as I said, the Post is not the one that is helped really by anti-SLAPP laws. It's the publication that's smaller and that is, one of these lawsuits can actually sink them. And so they really will sometimes buckle to the threat of a libel suit and just stay away from a subject altogether because they just can't afford the risk.
I would have to say it's entirely, I would agree with Rebecca's comment that it's entirely anecdotal. But I can give you one anecdote from not Maryland, but the state of Virginia. There is a member of Congress from California who has taken to repeatedly suing detractors on Twitter and elsewhere. And he never sues in California where there's a strong anti-SLAPP statute. He always sues in state court in Virginia where there is no anti-SLAPP statute. And it's the anti-SLAPP statute or the lack of it that makes the difference.
All right, excellent. Looking around the room, seeing no further questions, that will conclude the testimony and the hearing for Senate Bill 162. We'll now move on to, for Senate, that was 162. We have now one more from Senator Heddleman, Senate Bill 311. Here we go. This is tough work today for you. This is a lot of big stuff you're working on here. All right, so Senate Bill 311, Senator Heddleman, floor is yours.
Thank you very much, Mr. Chairman. I'm here this evening to present testimony on Senate Bill 311, which we call the Maryland Healthcare Heroes Protection Act. If you look at the body of bills that I've introduced since joining this General Assembly, it may be surprising that I'm the sponsor of a bill to provide immunity from liability, and especially since the conversation we've had this afternoon. I thought long and hard about introducing this bill, and ultimately I decided to do it because I believe that in the midst of a global pandemic, that the conditions under which healthcare professionals and people working on the front lines in healthcare settings are working are so challenging and unique that they deserve protection. These are the same professionals that we've called heroes, that we've applauded for and lit blue lights for across this country. They are the ones whose workplaces have been transformed and who've had to work without the appropriate personal protection equipment. These are the people who have literally put their lives on the line to care for our relatives, our mothers, fathers, grandparents, friends, and children who have been with them during this very frightening time. Without families present, these are the same people who held up iPads and phones, enabled loved ones to be able to touch briefly in with them and provide the latest status updates. These are the people who literally put their own lives at risk to do their jobs. In 2002, after the September 11th attack and the prospect of a bioterrorism attack, this body recognized that in light of a state-declared catastrophic public health emergency, there were some situations, public crises I would call them, that warranted providing special protection to healthcare providers and facilities. At that time, no one could have predicted that we'd be dealing with a global pandemic like COVID-19. Over the past many months, our healthcare providers and facilities have been learning to deal with COVID on the job. In the beginning, they didn't have the right equipment and supplies and had to improvise. Guidance from the state continued to change and evolve. They didn't have all of the personnel they needed, so retirees and medical and nursing students who were close to finishing their educations were drafted to help. Doctors had a pinch hit when there weren't enough specialists in a particular area. It was all hands on deck in the middle of a hurricane. The science was evolving, and what we know now is light years beyond what we knew back in March about how to treat the coronavirus. I dare say what we know in 6 months may be light years ahead of what we know now. The sands on which the provision of healthcare have been offered are regularly shifting. So what does this bill do? It expands who is covered under the public safety article protections that already exist in statute to respond to the unique circumstances of COVID-19. It recognizes that the pandemic upset all aspects of normal healthcare delivery, so that when the state required that hospitals cease elective and non-urgent medical procedures, we took out of medical professionals' decision-making authority to make those individualized assessments about care, and those actions could possibly have repercussions to a patient. It extends for 180 days after the lifting of the state of emergency, the protections of liability, because there will still be patients being treated for COVID even after the lifting. This bill is not about letting one who has done wrong off the hook. Individuals and institutions that have done wrong should still be held accountable, and they will be under this bill. It is about recognizing that this time is so particularly unique that it deserves special attention. And who better to provide it to than the healthcare facilities and professionals who are the real heroes of this pandemic? I ask for your favorable vote on Senate Bill 311. Thank you.
Excellent. Thank you, Senator Heddleman. So first we have, for your primary witness, we'll have 5 minutes. Mr. Frazee, I think I saw you there. There you are. Good to see you.
Thank you. Good evening, Mr. Chairman and members of the committee. My name is Brian Frazee, and I am here on behalf of the Maryland Hospital Association in strong support of Senate Bill 311, the Maryland Healthcare Heroes Protection Act. Included in our written testimony is a letter signed by every Maryland hospital CEO highlighting the critical importance of this issue, which is the hospital field's top legislative priority. And we want to thank Senator Heddleman for her leadership and sponsorship of this bill. Healthcare facilities, doctors, nurses, and healthcare teams have been on the front lines of an unpredictable public health crisis for nearly a year, 334 days since Governor Hogan first declared the emergency. Since that time, the COVID-19 pandemic has placed never before seen demands on healthcare workers and the facilities in which they work. Providers have put their duty to care for Marylanders first, despite dealing with challenges related to personal protective equipment, testing capacity, staffing shortages, ambiguity in crisis standards of care, countless federal and state directives, and rapidly and still changing public health guidance. At the same time that Maryland's healthcare facilities and providers are taking on these challenges, they're also confronting a real concern around individual and organizational liability. This concern is driven by advertisements from plaintiffs' attorneys on how to bring COVID-related suits. We started to see these as early as April, just weeks into the pandemic, and we included a sampling of those recruitment efforts in our written testimony. We have started to see lawsuits in other parts of the country where, while the care teams in our hospital serve our communities with compassion day in and day out. The advertisements and this early experience in other states have caused others to act. First, those that provide reinsurance for our hospitals are working to carve out infectious disease as part of the renewal process our hospitals are in, on top of already substantial premium increases. This is a direct result of anticipated lawsuits. But state legislatures and governors have also seen this threat and have taken action. So far, 28 states and the District of Columbia have recognized the unique challenges facing their healthcare systems and enacted liability protections for healthcare workers since the start of the pandemic. And several other states are now considering similar measures, and we hope Maryland will move to modernize our statute to ensure those protections. As Senator Heddleman said, Senate Bill 311 updates existing law that provides liability protections to healthcare facilities and providers during a state-declared catastrophic health emergency. You heard that the existing statute was passed in the aftermath of September 11th, 2001, out of concern for bioterrorism threats and did not take into account what our healthcare system would face during a public health crisis like COVID-19. Our bill seeks to update current law in 3 ways. Number one, expanding the definition of a healthcare provider to include the frontline healthcare team members that have been integral in our response to this crisis. Let me know that these agents, contractors, and employees must be involved in the provision of healthcare services in order to be covered. Number two, acknowledging the impact that the pandemic has had on all aspects of healthcare delivery by protecting providers that care for patients, including those without COVID, in good faith. And finally, number three, recognizing that the healthcare system will be dealing with the lingering impacts of the pandemic by extending the protections 180 days after the governor lifts the emergency. Other states have gone further, but we have studied their new laws, and that is not what we are here to propose today. We are asking for sensible updates, and I want to emphasize that the current law already includes a good faith liability standard in these cases, and we are not seeking to change that standard in this bill. This legislation does not provide broad or blanket immunity. Rather, it preserves the existing good faith standard and updates how it is applied to account for the unique nature of a public health emergency like COVID-19. On our panel, you will hear from Dr. Van Kootz, CEO of Holy Cross Health, who will speak to the challenges of running a hospital that was one of the, hardest hit by COVID. You were then supposed to hear from Dr. Steve Evans, who serves on the governor's coronavirus recovery team and as the chief medical officer of MedStar Health, but unfortunately he was called away due to the ongoing COVID response. And finally, you'll hear from Sue Kinter, of the University of Maryland Medical System, who will speak to the legal threats hospitals are anticipating. So in conclusion, and on behalf of Maryland's hospitals and their nearly 120,000 employees, we urge the Maryland General Assembly to take action this session to update the protections to those who have been working tirelessly to care for Maryland. We look forward to a productive dialogue on this issue, and we appreciate the committee's consideration and urge a favorable report on Senate Bill 311. Thank you.
Thank you, Mr. Frazee. And with that, we will move on to Dr. Van Coots, who leads Holy Cross Hospital, where I was born. Good to see you.
Thank you very much, sir. Good to see you, Mr. Chairman, members of the committee. As I always like to say, despite what you've seen on TV, when you see it for yourself, COVID-19 is so much worse. And whether you're a patient with COVID-19 or you're a non-COVID patient in the hospital, your care has been impacted by COVID-19. It has had a devastating impact on our frontline healthcare workers, both physically and mentally, as they face this pandemic with compassion and determination. For nearly a year, Holy Cross Health has been at the forefront of this pandemic in Maryland, diagnosing the first COVID-19 patient in the state on March the 4th, and then becoming the dominant provider for critically ill COVID patients in the first wave of the pandemic. For these past 11 months, we've cared for more than 2,800 COVID inpatients and 2,500 COVID outpatients, many of whom were from minority and vulnerable populations. From the start of the crisis, Maryland hospitals have met the challenges. First, the unpredictable supply chain and the shortages of PPE and testing reagents. Then the initial lack of medications and having to adapt to evolving clinical guidelines as we learned more about the disease. We expanded our facilities, tripling our ICU capacity and doubling the number of ventilators. We complied with state requirements, such as suspending elective surgeries, in some cases resulting in the deterioration in the patient's condition over time. And now we're scaling up to provide community vaccinations, all the while still caring for critically ill patients and striving to soothe worried families and sadly, far too many grieving for the dead. We know that the current Maryland law provides liability protections for some, but not others during a declared health emergency. And additionally, as you've heard, the coverage really does need to expand to a minimum of 180 days following the period of the emergency order, as many of us will still be caring for COVID patients, with some historically staying with us for as long as 139 days. This act would simply update the liability protections for those who've been actively fighting on the front lines of this pandemic and allow them to make good faith and necessary decisions without fear of personal liability. And I reiterate again, whether you were a COVID-19 patient or a non-COVID-19 patient, your care has been adversely impacted by COVID-19. Thank you.
All right, thank you, Dr. Van Coots. We'll next move on to, so with that, Mr. Frazee, I think, so you mentioned that Dr. Evans is out, so no one to replace. We'll move on to the opposition panel.
Hey, Mr. Chairman, we have one more person on our panel.
Oh, I'm sorry, that's right, Ms. Kintner. There you are. Thank you very much. Thank you, Senator Hellman. Thank you for that. My apologies. It's been a long day.
No worries.
Good evening, Mr. Chairman and committee members. I'm Susan Kinter, and I'm testifying in support of Senate Bill 311. I would like the opportunity to address what I believe you will be hearing from those in opposition to this bill. You will be hearing from those opposed to this bill that the bill seeks blanket immunity for absolutely everything, and that the bill is taking away an injured party's day in court. This characterization is both disingenuous and inflammatory. This bill only seeks to clarify and affirm the immunities currently available to those responding to a catastrophic health emergency. It is necessary in light of Secretary Neal's unilateral attempt to remove the protection this legislature previously conferred to our healthcare heroes in Maryland Public Safety and Health General articles. This immunity is not blanket. It is not a free pass. It will apply only when a provider has been deemed to act in good faith, the standard most applicable to those responding to conditions that are unprecedented and unpredictable. The immunity does not take away a person's day in court. Any party alleging injury can still file their lawsuit. The defendant will then file the affirmative defense of immunity, one of the 20 affirmative defenses available to defendants in Maryland. A judge will then decide if this immunity is applicable. If it is not, the case will go forward without delay. This bill is necessary to affirm that providers taking care of both COVID positive and non-COVID patients will be equally protected when such care has been impacted by a catastrophic health emergency. The legislature in 2002 understood that in a catastrophic health emergency, care to all patients would be affected, not just care to a specific group of patients. Those opposed to this bill would have you believe that it is reasonable and acceptable to deny immunity to a physician's decision-making on a non-COVID patient during this pandemic, while granting immunity for that similar decision-making on a COVID positive patient. That was not the intent of the Maryland Public Safety or Health Journal article. Because this bill simply clarifies and affirms the protections available to providers since 2002, it is not taking away any vested right of a patient. And as such, the retroactive provision in the bill is not unconstitutional. I urge you to support Senate Bill 311, and thank you.
All right, excellent. Thank you very much. And with that, that concludes the testimony for the proponents. We'll now switch over to the opposition panel. And first we have Ms. Palmisano. There you are.
Good evening, Chairman Smith and committee members. I'm Dr. Anna Palmisano. I'm a microbiologist and the director of Marylanders for Patient Rights, a patient advocacy coalition which includes AARP, Disability Rights Maryland, and many others. We strongly oppose SB 311, a bill which threatens to undermine the rights and safety of Maryland hospital patients. Healthcare and other essential workers are clearly facing many challenges in the pandemic, but hospital patients are also facing extraordinary challenges. Many are not allowed the comfort and support of family members or patient advocates when they're in the hospital now. In 2019, a Hospital Patients' Bill of Rights was supported by 24 advocacy groups after being fought for 4 years with the Maryland Hospital Association. It was passed overwhelmingly by the MGA, signed into law by the governor. Yet SB 311 threatens to undermine those hospital patient rights by denying patients legal recourse for egregious medical errors, patient dumping, or discrimination against vulnerable patients and minorities. First, SB 311 will greatly expand the number of employees who will be free from civil or criminal liability for any wrongdoing against patients. With immunity, any bad actors will avoid consequences, thus allowing or even promoting the neglect or abuse of patients to be tolerated. Simply put, there will be no accountability. For example, the University of Maryland Medical Center security guards who left a vulnerable young Black woman half-clothed at a bus stop on a freezing January night in Baltimore would be possibly free from liability. Second, SB 311 will extend immunity to liability for an additional 6 months beyond the healthcare emergency. This 6-month extension is not justifiable and puts patients at additional risk. Without liability, there'd be no consequences for hospital employees who are failing to provide safe, respectful, and informed healthcare during and 6 months after a crisis. SB 311 is ill-conceived and has the potential for grievous harm against vulnerable patients, including the elderly and disabled. I strongly urge you to provide an unfavorable report. Thank you.
Excellent. Thank you very much. And next we have Mr. Tully. You're up.
Good evening, Mr. Chairman. Thank you. Mr. Vice Chairman and members of the committee, my name is George Tully. I'm Legislative Chair for the Maryland Association for Justice. And coming after me is David Wildberger and Mary Cook, also plaintiffs' lawyers, trial lawyers here in Maryland, who handle medical negligence cases on behalf of the victims of malpractice. What I'd like to do, and in the time that I have, is just highlight what it is we're talking about when we're talking about unreasonably unsafe medical care that this bill would expand immunity to cover. The immunity was initially enacted specifically in response to the hospital's request that providers need liability protection for carrying out the governor's orders and proclamations. That's what the immunity was intended for. That's why the immunity exists. It does not exist to give heroes special protection from middle-class families and working Marylanders. What the immunity exists to do, and what if it was expanded, would cover everything from C-sections to everything else you've heard from these healthcare providers who want the immunity expanded. It'll cover every aspect of care that's provided, because every aspect of care, according to them, has been affected by COVID. For some of you who have not been on this committee for very long, including the sponsor, and we have for years been highlighting the problem of malpractice in the state and nationally. It is the third leading cause of death, according to public health researchers at Hopkins, not trial lawyers. Public health researchers at Hopkins have published, and all you have to do is Google third leading cause of death, and you'll find their published findings. More than 250,000 Americans every year die because they go to the hospital for medical care and somebody makes a fatal mistake. It's not within the patient's control. It's not within the patient's ability to defend themselves, because when you go to a hospital, you're utterly at the mercy of the healthcare providers there. They do something and you die, and it's terrible. And what they do to fix it is all secret by state law. So we have no idea, and we're not allowed to know all of the quality control and morbidity and mortality reviews and all the studying that hospitals do, but they don't seem to be doing anything about it because it's much worse than it was 20. I'm happy to answer any questions and look forward to an unfavorable report from this committee. Thank you.
Thank you, Mr. Tully. Next, we'll have Mr. Wahlberger. You're up next.
David?
Trying to figure out the unmute situation. There you go.
There we go. Good evening, Mr. Chairman, Mr. Vice Chair, members of the committee. I'm David Wildberger with the Maryland Association for Justice, and I'm here to urge an unfavorable report on SB 311. I just listened to the sponsor and 4 witnesses testify in support of this bill. And you know what word you didn't hear the whole time? Retroactivity. And the reason you didn't hear that is retroactivity makes this bill unconstitutional under 180 years of Maryland law. SB 311 is unconstitutional under Articles 19 and 24 of the Maryland Constitution and more than 180 years of Court of Appeals precedent, because it retroactively impairs, interferes with, or abolishes a right vested in an accrued cause of action. There's a case right on point that evaluates all of those 180 years of cases called Dua versus Comcast 370 Maryland 604. Let's break that down a little bit. What Dua said is there is a vested right in an accrued cause of action, and the Maryland Constitution precludes the retroactive impairment of such right. Okay, so what is a vested right? A vested right is an interest which it is proper for the state to recognize and protect, and of which the individual may not be provided arbitrarily without injustice. What's an accrued cause of action? A cause of action accrues when the claimant in fact knew or reasonably should have known of the wrong. You can put this in context of the statute of limitations. Statute of limitations begins to run at accrual, and it runs for 3 years from the date of the injury, the date of the discovery of the injury. A cause of action that accrues becomes a vested right. The law is clear. Negligence gives rise to a discrete cause of action. Now, I heard a lot of this talk about good faith. Let me tell you what good faith is. To show a lack of good faith, you have to prove bad faith. Bad faith, according to the Court of Appeals, is the opposite of good faith. It requires much more than negligence. It requires dishonest purpose or intent. A wrongdoer is guilty of gross negligence only when he inflicts injury intentionally or so utterly indifferent to the rights of others that he acts as if such rights did not exist. Here's the key point. What the proponents are trying to do is abrogate a cause of action and negligence that exists. They want to do it retroactively, and they say, but you still have a cause in court. For bad faith, gross negligence, or intent, that's a whole different cause of action. This Bill SB 311 is clearly unconstitutional under Maryland law. Thank you. I urge an unfavorable report.
Thank you, Mr. Wellberger. Next, we have Ms. Koch. There you go. Mary, there you are. There you go.
Hear me? Perfect. My name is Mary Cook. I'm a member of MAJ. I am a lawyer who has been practicing for 32 years in the state of Maryland. Started my career as a prosecutor, and I spent the last portion of my career representing people who are the victims of medical malpractice. Before I get started into one of the things that really bothers me about this bill, let me just tell you a couple of things that this bill would allow to happen with no recourse. If a patient comes in and has their left leg needs to be amputated and a doctor comes in and amputates their right leg, they would have no cause of action under this bill because it would have happened during the period of COVID by a doctor who was working in a hospital during that period. And so that they would not be able to sue for that because the hospital will come in and raise the issue of good faith. No cause of action. A mom comes in and the doctors you put the electronic fetal monitor on her and nobody bothers to read the fetal monitor and the baby dies in utero. That would be covered. That would be covered because it happened during the period of COVID. That cannot be the intent of any statute to uniformly abrogate the rights of all of the citizens of the state of Maryland as relates to their medical care. But what I would say to you and what I think is really important is that we already have a standard of care in the state of Maryland. Whenever we go in to prove a medical malpractice claim, what we have to prove is that the doctor did not act reasonably under the circumstances. What does that mean? That means that every time we go into court and we bring a case that occurred during the time period of COVID, the defendants will be able to offer evidence to the jury of all of the circumstances that were occurring in the hospital at that time so that the jury can consider whether or not the COVID precautions, the manner in which the doctor acted as relates to the patient, the way the nurses acted, was all as a result of what was happening with COVID, whether under the situations presented by the unique circumstance of COVID, their actions were reasonable. That's always been present in the law. That allows the law is fluid to allow for all of these exceptions. So where does that leave us? That leaves us with the fact, exactly going back to what Mr. Wildberger said, that really what this is an opportunity to come in and to get blanket immunity for all the harm that is done to patients. That means that all behavior is left unchecked. That means the people who are injured by medical malpractice and have serious lifelong injuries will have no recourse.
Time.
And that cannot be ever what the law is intended to mean, and those should not be the protections that we afford to anyone. Thank you.
Thank you very much, Ms. Koch. And with that concludes the testimony, and we'll now open up for the panelists for questions. First, we have Senator West, and we have Senator Castley. Senator West.
Thank you, Mr. Chair. It's late. I'm going to just ask a couple of questions, and I hope they can be answered briefly. Ms. Kinter, can you address Ms. Palmisano's claims about patient rights?
Certainly. You know, what's been disturbing to me in hearing some of this testimony is that it appears as if people or those in opposition to this bill just seem to feel as if our healthcare providers want a get out of jail free pass. You know, our healthcare providers every day go to work. They went into healthcare to care for patients. And the amount of stress and the amount of circumstances that they've had to endure through this COVID process, what have they done? They are the ones holding the patient's hands. As the senator said, the sponsor, they are the ones holding the iPads. A patient's right is not taken away by this bill. A patient can sue a physician alleging medical negligence. And then what will happen, as I stated in my earlier testimony, is that the affirmative defense of immunity will be raised. To Ms. Koch's example, I do not believe a judge will find that a doctor who cut off the wrong leg was acting in good faith. I just don't believe it would happen. And to assert that it would happen, as I said before, I think is just a little bit disingenuous. We are not asking for a free pass. We are not asking just to be able to go in and render any sort of care that we could. No, a patient can file a lawsuit, and then a judge will decide based on the evidence presented whether or not this defendant acted in good faith. And as Ms. Koch and the other plaintiffs' lawyers know, when Ms. Koch talked about the standard of care, before a plaintiff can file a lawsuit, they must file a certificate from a doctor saying the standard of care was breached. In Ms. Koch's example, a physician would file a certificate saying our healthcare providers breached the standard of care before they had any understanding of what challenges our healthcare providers faced in responding to this COVID emergency. So it's just to say that the standard of care is what a reasonable person would do and that shouldn't change because COVID doesn't change. This is a worldwide pandemic. As was stated earlier, early in the course of this pandemic, no one knew what the standard of care was to treat patients. People were being treated with hydrochloroxidine, and I can't remember if that's exactly the name, and that was a treatment that was proven to be absolutely ineffective. So I don't think it's fair and reasonable to assume that the ordinary standard of care and the ordinary process can work. Patients can still file lawsuits, and they can present their evidence to a judge that a healthcare provider did not act in good faith. And when the judge agrees with that, then the plaintiff's case will proceed through the ordinary judicial process. It's that simple. Their right is not being taken away.
Let me ask you another question. The Maryland Association of Justice, in their written testimony, said that they offered the Hospital Association an amendment, which was rejected. What was that amendment and why was it rejected?
That amendment was an amendment that would say, look, we won't sue your physicians, we'll just sue your institution. And honestly, it was an amendment without substance. Brick and mortar does not render care. Brick and mortar does not go into a courtroom to defend care. Human beings do. And the certificate of merit that I mentioned earlier requires that a physician be named and be named as to how that physician or that healthcare provider breached the standard of care. So the physician still will be named. That physician will still have to go through the litigation process, still will need to be deposed, and will still need to sit at the trial table defending their care. So yes, it was offered, but honestly, it was an amendment that was not substantive.
And finally, Mr. Frazee, have you seen the Attorney General's opposition letter in this case, in this bill, and what is your response to that? I think you're unmuted.
Yes, thank you, Senator, for that question. We did see the Attorney General's opposition letter, and I think you all have heard very clearly our intent behind this bill are very narrow updates to take into account the unique challenges of responding to the pandemic. So you heard examples around redeploying of staff, the all hands on deck approach, the ever-changing guidance, the science behind COVID. And so we just met actually with the Attorney General yesterday and walked through that intention, and we're committed to working with them to address their concerns with the bill.
Thank you very much.
Excellent. Thank you. Senator Castle, you're up.
Thank you, Mr. Chairman. Just a couple of brief questions. And I just also want to thank both sides in this thing for your professionalism and thoroughness. And we're getting a lot of good stuff on this. It's very interesting. Question, Mr. Tully, real quick, question for you, if I could, sir. He's muted.
No, I'm good now. I'm not allowed to unmute myself, but I've been let out of jail.
You got him.
So I was intrigued, your testimony about the right to sue and the cause of action. Does that also apply to a right not to be sued? Or is that also a right? I mean, if to say that, well, Tully has the right to sue Castley, but then if Castley can say, well, Tully can't sue me now, I have a right. Tully and I, we did an agreement and Tully can't sue me. So that's a right too, right? I mean.
Senator, that's a great question. The retroactivity piece that makes this bill unconstitutional is something that we have studied a great deal. And I have sat through and listened to a great deal of discussion and debate about the effect of unconstitutionality or retroactivity or what have you as to statutes of repose. That is not a bill that the Maryland Association for Justice has taken a position on at this point, and it's not an issue I've studied. I know that the Attorney General can be asked and maybe has been asked to weigh in on that, and I would allow you to be advised by your lawyers in the Attorney General's office.
I'm the General Assembly. We don't have
advise
any.
you myself off the top of my head. But thank you, and I hope
well,
that was diplomatic. I really understand.
No, that's fine. But then sort of parsing this one out a little bit. Sometimes if we change the rule of evidence, changing or you know, that can mean you thought you had a cause of action, and then you were basing it upon this piece of evidence, and then we come in and pass a statute that says you can't bring that into court. You've just lost your cause of action. Did that deprive you of a vested right?
So rules of evidence tend to be described as procedural and not substantive.
Yeah,
and there's a
but it has the same effect.
I'm sorry, say again?
It has the same effect though, right?
Well, it may very well, but whether it's unconstitutional or not will turn more on that distinction between a substantive right and a procedural right. You don't have a right to a rule of evidence, and the court, for example, the court adopted Daubert, which is something the hospitals desperately wanted and said would solve all their problems last year. They got Daubert from the Court of Appeals in August, and that rule was adopted by the court and applies prospectively to every case that comes to trial. So in all the cases, although there weren't a lot of cases that came to trial because everything's shut down, but for any case that does come to trial, if the expert witnesses were all deposed under a Fry-Reed understanding, the lawyers didn't ask Daubert questions because it wasn't the law.
So the evidencing was a procedural law. You call this one what? What am I?
So this is a substantive right.
Substantive law.
A vested right in a cause of action is property under the Constitution, and property cannot be taken away without due process of law. That's 180 years of precedent.
But haven't what they've really done is not take it away, just shifted the burden of proof from being preponderance of the evidence to good faith?
So when and forgive me,
I'm sorry.
I'm a lawyer. I'm thinking about it in lawyer terms.
Not the burdens of proof, but the standard of care. Haven't they really just not taken the right away, but just shifted the standard? I said that wrong. Haven't they just shifted the standard of care from the traditional, professional standard of care that's normally in the statute to one of good faith? And so they really haven't taken the right away. They've just simply said the exercise good faith. So they haven't actually. It's more along the lines of an evidentiary rule than a substantive rule, isn't it?
No, it isn't. It's an impairment of the cause of action. Property, when you and I were in law school, maybe you got the same metaphor I got, that property can be thought of as a bundle of sticks or a package of different things that are all put together. And each one of those sticks is its own little property right, whether you have the right in the course of real estate, whether you have a right of ownership, a right of trespass, a right of use and enjoyment, a right of to sell, a right to make profit. All of those things are individual rights. This statute impairs causes of action by changing the substantive law retroactively.
I hear you. I'm still troubled between substantive law when we just simply changed the standard of care. You still have a cause of action. It's just the standard of care is different. But maybe if you come across anything, you can send it over and enlighten me. I just have one more brief question to Miss. I'm sorry. I'm looking. Oh, there you are, Miss Koch. Excuse me. You're hiding back there. You're hiding behind your name tag here. It's a little name tag, but you're hiding behind it. You said that we shouldn't change the standard of care, and we didn't need to because it's the appropriate care under the circumstances. But the challenge I have as a legislator is the circumstances are a once in 100-year event. It's a pandemic. So I'm going to go to a juror and say, under the circumstances, and they're going to say, yeah, like we do in all the 100-year event pandemics. So aren't we, what we're really just saying here is that the legislature is going to decide that rather than have every individual jury say what's appropriate, that we're going to go with the good faith. And the reason we're going to do that is because, I watched my own hospital. We don't usually take 100 patients from the Washington, D.C. area and flood my little community hospital with it, but we did. We did, because the COVID hit over there first and didn't hit us. So we had virtually no local patients, but my hospital was packed full of people from the DC area, treating them. And of course, then that puts pressures that my people had never dealt with in their life, where suddenly they're like, whoa, we weren't in for this stuff. We don't know what we're doing with this thing. We don't know how contagious it is. We're trying to staff with nurses and doctors. And I really felt bad for them, because, it's sort of like, as a lawyer, when you're used to doing things right and with a certain standard of care as a lawyer, and then all of a sudden, you got a judge saying, I want all this stuff in an hour from now, and you're like, I'm gonna freaking commit legal malpractice here. I can't do this stuff. And you're forced into you're forced just to, what are you gonna say? So you cobble together the best thing you can, and you run with it and hope like hell you don't get your butt sued. So I sort of analogize that to the medical side, where, I mean, they never would have proceeded in the fashion they would have. So why wouldn't it be appropriate for us as a General Assembly to determine what is the standard, as opposed to just throw it open to any group of 6 people that happen to be cobbled together somewhere across the state?
Okay, so there's a lot to unpack there. So if you'll
Sure,
give me
I always
a
do
minute,
that.
I'll
Sorry.
try to unpack that. So first of all, the standard of care is the standard that the plaintiff has to meet. It's the burden the plaintiff has to meet as to show a violation of the standard of care in order to prove negligence. I differentiate that from the good faith, because I think that the good faith is not a standard of care. What good faith is a affirmative defense that bars your ability to ever step into the courtroom and prove whether or not the standard of care was violated. So all under this bill, literally all that the doctor would have to believe is that that doctor or that nurse was acting in good faith, and that would be enough to overcome any case that a plaintiff had, regardless of how meritorious. And the reason that I say that the standard of care is fluid is because, first of all, I want to take, if you don't mind, what I'd like to take is what Ms. Kinter said when she talks about the COVID issue, and that issue is, in terms of patient care, is also being conflated. We're not talking about care rendered solely to COVID patients. We're talking about any care that's rendered in the hospital. And to the extent that care is affected by COVID, and again, this is not something that is unique to the University of Maryland or unique to Holy Cross Hospital. This is not unique. Everyone in the United States, everyone in the state of Maryland, everyone in Harford County and Baltimore City, we all appreciate what's going on as relates to COVID. So the jury will hear and will have reaffirmed for them what has been going on in the hospitals, and the jury will have the opportunity to determine what effect the treatment, the fact that we have this pandemic has had on the ability to treat people. And so everything that a doctor or a nurse does in a hospital will be viewed through the lens of how has COVID affected their ability to render care. And that will also go to the standard of care that we're going to have to, I think, even in our CQEs, it's going to have to be recognized that there are circumstances in which you have to operate differently. And we have that now. I mean, a rural hospital who doesn't have access to an MRI, a doctor at that rural hospital is not necessarily held to the same standard of care as a doctor who works in an academic institution, because you can't simply send someone down the hallway for an MRI if there's no MRI in your hospital and somebody has to be airlifted in order to have access to it. So these are not unique problems. We have always viewed the medical care through the lens of what is reasonable for those doctors in the circumstances in which they operate. And now that lens will be, for all people who received care during COVID, it will be an issue of, did the doctor act reasonably given the circumstances surrounding and impacting the care? And quite frankly, there's going to be situations where the care should not be really probably impacted at all. The misreading of a fetal monitoring strip by an obstetrician is not an issue of whether or not the hospital has COVID patients. It's a question of whether or not the script was misread and the baby wasn't delivered. But under the scenario presented by the hospitals, every one of these cases, if the doctor says, I acted in good faith, that never sees the inside of a courtroom. And why? And that is just a vast overarching limitation on patients' rights to access the criminal justice system. And I would say it's a little bit different than a lawyer. I'd like to think we are as important as everyone else, but you know, what we do is not quite the same. And when we do something wrong, it doesn't have necessarily the same impact on our clients as when there is malpractice and someone is seriously.
Well, it's getting late. I don't want to go. I mean, obviously the other side would claim that you're overstating your case a bit, so we can anyway. But thank you, Mr. Chairman. I appreciate it.
No, thank you, Senator Castle. This has been a fantastic dialogue, so I really appreciate it. It's been great. Senator Sidnor, you're up.
Thank you very much. I have probably 3 questions. Well, the first, I'm trying to understand the language on page 2, lines 8 through 10 in terms of the expansion class that is being sought. When you already, and I'm trying to think, and I was listening to the testimony as to who this is supposed to protect. And for the most part, the testimony that I heard when we're talking about the frontline heroes and things, those people are already protected under under Section 2 healthcare practitioner. I went and I looked at 19-114E, and it refers to the Health Occupations Code as to who those people are. So you have acupuncturists, audiologists, hearing aid dispensers, and speech language pathologists, chiropractors, dentists, licensed dietitians, nutritionists, massage therapists, nurses, nursing home administrators, occupational therapists, optometrists, pharmacists, physical therapists, physicians, physician's assistants, podiatrists, professional counselors and therapists, psychologists, social workers. I'm curious, who is number 4 meant to protect?
Who would you like to respond?
And that's to anyone in general for the proponents.
Sure, Mr. Chairman, I think Ms. Kinter was trying to chime in here.
Got it.
So specifically, there are 3 groups of individuals. Environmental services, often referred to as housekeeping people. These are the individuals who come in, they clean the beds, they clean the equipment. That's one group. Our supply chain is probably another important team member. These are the individuals who make sure that our healthcare providers have all of the PPE we need, all of the supplies, all of the ventilators, everything we need to care for these patients. They are not included in the health occupation article. And lastly, a service line we refer to as bed management. Again, these are not healthcare providers, but they're individuals who are looking at every bed we have available within our hospital, within our system, to say, goodness, if all of our ICU beds are full at our downtown campus, we need to find a bed at another system hospital or vice versa. So those are 3 examples of individuals specifically who are invaluable team members who are not covered under the health occupation article.
Okay. So under current law, I'm looking at, again, this is page 2, lines 11 through 15. Currently, the law reads, a healthcare provider is immune from civil or criminal liability if the healthcare provider acts in good faith and under a catastrophic health emergency proclamation. To my eyes, that's already pretty expansive and covers everything that I think is going on today. I'm curious, again, in looking at the need for this expansion about all of these acts or omissions and the like. What am I missing there?
Thank you, Mr. Chairman. Thank you for that question, Senator. And if I might just on the last point very quickly say that, another example of who we're trying to cover here are folks that came out of retirement to help us because of the all hands on deck approach to the pandemic. We had students that had accelerated programs so that they could help. Again, you keep hearing us say this all hands on deck approach. Our members had to do everything they could to make sure they had the workforce they needed to respond to the last surge, to the current surge, to a surge that we might have in the future. And then to your question on the acts or emissions and what we're trying to cover here, I think we've been pretty clear on what our intent is that we want to cover. And I want to share one example that was mentioned earlier that I think may have been a little lost in the conversation, which is, the governor required us to halt elective procedures last spring for nearly 2 months. And that caused delays of care for a lot of people. And that care was not COVID-related care, but it was delayed because of the COVID crisis. And then the Secretary of Health at that time then issued a follow-up directive that said that the existing immunity protections that we already have in current law do not apply to non-COVID care. And so that right there is a significant legal vulnerability from our perspective, where you have an order to stop certain procedures that are not COVID related, and then to have another executive branch official say that those are not covered under the existing law. So that's really our intention of what we're trying to make sure is covered. And I will tell you that we are more than willing to sit down with this committee and make sure that the language in the bill is clear on what we're trying to accomplish here. You've heard a lot of accusations around, other issues that have been brought up in the past, but I think our side has been very clear on what we're trying to accomplish here, given the unique circumstances of dealing with a once-in-a-century global pandemic.
And this is why I was careful not to say I have an express number of questions, because sometimes I answer, we get more questions. So with regards to the volunteers and things that are coming out of retirement, do those people not qualify under number 2? Is, I guess, the folk who would be healthcare practitioners as defined by the code?
Senator, it is our understanding that they are not covered under the current law, and that's why we're seeking clarity to make sure that they are. That's a big reason for this bill is again seeking clarity and updates to what is already in the law, based on what we're experiencing right now.
And the last question I wanted to touch on, when I was looking over the bill, I wanted someone who had an eye towards health and racial equity. And so I sent it to one of our local universities that does community health and policy. And one of the things that they had pointed out was that, and this is reading from the letter, from a health and racial equity lens, the legislation seems to allow for latitude and protections that may produce and reinforce inequities that already exist within the healthcare system. Curious, if, again, any of the proponents, if this is something that you all see that could be fixed with any types of amendments to the current draft.
All right, you're saying opponents or proponents?
Proponents.
Okay, got it. Ms. Kittner. Oops.
Mr. Frazee, did you want to respond or did you want me to?
Go ahead, Sue. I can chime in, Mr. Chairman, if that's okay after Sue.
Absolutely.
Yeah. Obviously that was not an intent of this bill. And I can tell you in our COVID response, we have been very sensitive to the disparities, both economical disparities and racial disparities. We look at it when we're looking at our allocation of scarce resource documents and how we score patients as far as their survivability, for lack of a better word. And we worked with many in the state of Maryland and received feedback that the way we are doing things by listing comorbidities to go into that score unfairly gave a disadvantage to to economically disadvantaged and racial disadvantaged individuals. And so we revamped how we did things. I can tell you we're very, very sensitive to that thought. We appreciate your feedback in that regard. And obviously I'd love to learn more from your source, how specifically you think this bill, or they think this bill would impact economically disadvantaged or racial disadvantaged individuals, because it's absolutely not our intent for that to do so.
If I could add in, I would also like to understand that, 55% of the COVID patients that we have seen in my health system are Hispanic, 39% African-American, the remainder is everyone else. We have a very diverse population that we serve. We have a very diverse medical staff as well. I mean, if you're getting to individual personal biases, that may be difficult to discuss. But in terms of the dedication to the healthcare, the health equity piece of it, that is certainly something that's factored into everything that we do, whether you're COVID or a non-COVID patient. We do not look at whether your ability to pay. We do not look at what zip code you come from, other than a statistical analysis to determine if you're from a hotspot or a non-hotspot. So I too would like to see that, because I have not seen that in the 11 months that we've been in this pandemic. Any profiling, any outward bias or anything like that factors into any level of care for a COVID or a non-COVID patient.
Yeah, and Mr. Chairman, just from the association perspective, I want to reiterate what our members have already said, and that we are 100% committed to addressing disparities. This is a top priority at the association and for all of our members. And again, we're happy to sit down and work through any language to make sure there's no unintended consequences in that space. But I can tell you that it is a priority of us. Both non-legislatively, we're doing a lot in this space, but I'll also tell you that we're supporting several pieces of legislation this session around this, and frankly, a lot of legislation that maybe in the past we would not have been as supportive around mandating certain things on our members. But we really want to be at that table on the front lines of addressing that very real issue. So it's something we take very seriously.
Excellent. Thank you for that. Senator Sidnor, good to go? Okay, great. Looking around the Zoom room for further questions, seeing none, that'll conclude the testimony and the hearing for Senate Bill 311. Thank you, Senator Hedelman. It's been quite a day for you. And thank you to our panelists. It was a very good discussion. So this has been great. So next we'll move on to our final bill of the day with Senator West, Senate Bill 189. Senator West, you are up.
Thank you, Mr. Chairman. And it's hard batting cleanup today and knowing that I'm all that stands between you and getting some food. But this bill nonetheless is an important bill for the people who are interested in it. So this is Senate Bill 189. And I'm sorry, am I unmuted?
You are, you're good to go.
Oh, okay. I see a thing in the middle of my screen saying the host is not allowing participants to unmute themselves. In connection with a construction project, there are generally numerous contracting parties. There's the owner, the contractor, the architect, the engineer, subcontractors, and other professionals. When an accident occurs resulting in significant losses, the responsible party and/or its insurance carrier is normally expected to pay for the damages. Where there are multiple defendants, there may be multiple insurers. In this situation, the insurers would usually negotiate an equitable allocation of the losses, or else a court will ultimately decide which party is liable. But there are situations in which the owner of the project or the prime contractor is so dominant that it can force the architect and the engineer associated with the project to execute contracts containing an onerous provision requiring the design professional firm to indemnify the owner or the prime contractor, as the case may be, for all of the damages and expenses associated with the loss, irrespective of the fact that the design professional firm was not the proximate cause of the loss. Of course, the design professional firm has its own insurance, but The insurance policies issuing insurance to design professionals customarily refuse to reimburse them for any indemnification payments to the owner in such situations because the losses were not proximately caused by the design professionals. So the design professionals in these situations end up shouldering the burden of paying all of the losses resulting from an accident, including all of the attorney's fees associated with the trial of the case, even though the design professionals were not the proximate cause of the loss. Fortunately, contracts containing such clauses, the indemnification clauses, are not customary, but some Maryland state procurement contracts and some other construction contracts used by very large construction companies contain such indemnification provisions. These are virtually contracts of adhesion because the design professional knows that if it wants the work, it'll have to sign an unfair contract. For example, in Maryland, if you're in the business of building highway bridges or doing highway grading, the only game in town is the state of Maryland or the counties because they're the ones that build highways. So if those organizations put these indemnification clauses in their contracts, you have no choice. If you want work, if you want to exist as a company, you have no choice but to sign the contracts containing these indemnification provisions. And if you're a small contractor, and most minority contractors and female-owned contractors are small contractors, you know that when you sign one of these contracts, you're betting the farm. Either you do the work and there's no problem with the project that is anybody's responsibility and you get paid and you live to fight another day, or you do your work fine and you're not the proximate cause of a problem. But if somebody else on the project causes the problem, you're going to get sued, you're going to have to pay for it, and you're going to bankrupt yourself in the process. So let me discuss, oh my goodness, my phone's ringing. I'm sorry. Everything goes wrong at once. Let me discuss this bill. Maryland law currently provides that a provision in an architectural or engineering contract purporting to indemnify the other party to the contract for damages arising due to the sole negligence of the other party is against public policy and is void and unenforceable. What this bill does is just adds language to the existing state statute stating that a provision in an architectural or engineering contract requiring the design professional to indemnify the other party to the contract against loss is also void and unenforceable unless the fault of the design professional is the proximate cause of the loss. In other words, under the new language added by this bill, the design professional can only be required to indemnify the other party to a contract if the fault of the design professional is the proximate cause of the loss, but not if the design professional was not the proximate cause of the loss. Finally, Senate Bill 189 adds a provision dealing with the obligation of the design professional firm to pay the attorney's fees and other defense costs of the other party of the contract. And consistent with what I just said, it provides that the design professional will not have to pay for attorney's fees and other costs until such time as a determination is made that the fault of the design professional is the proximate cause of the defense costs. At that point, the design professional will have to indemnify the other party to the contract for all reasonable attorney's fees and other defense costs. I know that bill is complicated. I'm sorry to have to bring it to you at this late hour, especially when we have empty stomachs. I urge a favorable report on Senate Bill 189. Thank you so much. And I've got three very good witnesses who I'm sure can answer questions about this complicated bill.
Excellent. Thank you, Senator West. So we have your primary witness is Mr. Frescarella. So you are up. You've got 5 minutes. Thank you for hanging in there with us.
Thank you, Chairman Smith and Vice Chair Waldstreicher. And let me make sure I'm doing this right. Members of the Judicial Proceedings Committee, my name is Tony Frescarella. I'm Executive Vice President at Century Engineering. We're headquartered in Hunt Valley, Maryland. I am appearing today as president of the American Council of Engineering Companies of Maryland in support of Senate Bill 189. So for the record, ACEC Maryland is made up of 90 multi-size consulting engineering firms located throughout Maryland. We serve both public and private sectors. Many of our firms are engaged in the design of our public water and wastewater systems, bridges, highways, building structures, and environmental projects. More than 40% of ACEC Maryland's members are certified small, minority, and woman-owned businesses. Member firms employ approximately 7,000 employees statewide. So design professionals should not be asked to indemnify or defend another party for losses that the designer did not cause, cannot insure, and were caused by factors beyond the designer's control. Unfortunately, some public authorities and private business entities are still putting indemnification clauses in their contracts that require a design professional to indemnify above and beyond what the design professional's professional liability insurance will cover. When design professionals, including small, minority, and woman-owned firms, refuse to agree to these provisions, we often are not selected for these contracts. So the fundamental purpose of this bill is fairness. Right now, design professionals are being asked to defend public and private entities against third-party claims before there is approximate determination that the design professional has committed an error. The cost of such defense can be staggering and come out of the design professional's pockets, not out of our professional liability insurance policy. The reason being the professional liability insurance will cover only legal costs to the extent caused by the negligent errors and omissions of the design professional and does not provide defense for its clients. The amendments in Senate Bill 189 will preclude the assignment of liability to design professionals for injuries or damages for which they are not the proximate cause. However, they do not inhibit the filing of claims or limit the liability of those responsible, nor would reduce the awards payable to any claimant. Design professionals are willing to assume liability that can be attributed to their fault, but have genuine concerns when contracts require indemnification or a duty to defend claims for which they are not the proximate cause of the loss, damage, or expense. So a favorable vote on Senate Bill 189 would be appreciated. And thank you for allowing me to testify today, and happy to answer a few questions.
Excellent. Thank you, Mr. Frescarella. And next we'll have Mr. Hraber. You are up, and we'll take questions at the end of the panel. There you go.
Sure. Thank you. Mr. Chairman and members of the committee, my name is Michael Harber. I'm an insurance agent in Columbia, Maryland. I've been specializing in insurance for architects and engineers for the past 20 years. I'm here in support of Senate Bill 189. The reason I support this bill is that the contractual mechanisms that this bill would eliminate are a real problem for design firms in the state, because these clauses are not covered by the insurance programs of these design firms. I review hundreds of contracts for my clients, and these 2 points, duty to defend and causation of damages, come up time and time again. My clients range from one-person sole proprietorships to multi-million-dollar firms, and this contract language has an adverse effect on all of them. This problem has the biggest effect on the small and minority-owned firms because they simply cannot afford to pay a client's defense that would potentially cost hundreds of thousands of dollars or more. Agreeing to uninsurable language in a contract presents an existential threat for these firms. Developers and municipalities, as Senator West noted, often present these contracts as RFPs. The firms have little room to negotiate. The contracts are presented as a take it or leave it basis. And so I spent some time putting together written testimony which outlines the details of the insurance problem, which is unique to architects and engineers. But I don't want to belabor the committee's time too much with that. I'm happy to answer questions about it, but it works very differently from that of a general contractor or a different type of vendor. Whereas you can get your client named as an additional insured if you're a contractor, you can't do that with general liability for an architect because the architect's professional services are excluded by the GL policy. So you can't get the additional insured, which would get you the duty to defend. And then all these policies are always predicated on negligence. And so if there's no negligence, there's no coverage. So what we're really trying to do with this bill is just to come up with an environment where the obligations of the A&Es are fair and insurable. And we think that that's in the best interests of everyone in the state. And I'd be happy to address any questions you may have about the insurance aspect of this issue. Thank you.
Excellent. Thank you, Mr. Harbour. And we'll have Ms. Matthews provide her testimony, then we'll open it up for questions.
Good afternoon, everybody. I actually work for one of those small minority women businesses that they spoke of. We are one of ACEC Maryland's member firm. I work for a company named Strong Environmental in Howard County, established in 1996. I've been there for 18 years, and over those 18 years, I've had the pleasure of witnessing my company grow from 15 to over 80 diverse employees. The majority of our work is within Maryland, and we are committed to our mission, which is advancing sustainable and resilient communities. My firm provides a variety of professional services. We are an engineering firm, and we are generally a sub-consultant on smaller contracts and sometimes we are a prime on smaller contracts and sometimes a sub-consultant on larger projects. As a small business, we are disproportionately affected by these contract provisions that require us to assume an uninsurable liability to defend unnamed parties. These contracts present an ominous choice for us. We have to either turn away work or take on uninsurable risk. And if we do that, that can mean going bankrupt. And a company of my size cannot reasonably take on an equitable level of liability, indemnity, or defense costs for things that we did not cause or are beyond our control. We have, and we will continue to provide high quality professional services, and we want to make sure Maryland and its citizens continue to enjoy this high quality of service. And if firms like mine and the other professional firms make this choice, they have to make this choice, who do business in Maryland, well, the quality of services will be impacted because the more stable firms like mine might not exist. And then these services will be only open to the less stable firms that are willing to assume this uninsurable risk. Like larger firms, we're proud of our work. We stand by our work. We're committed to our work, and we would like to stay in business as long as possible and not have to make this choice going forward. Thank you. I do support Senate Bill 189.
Excellent. Thank you very much, Ms. Matthews. And with that, that rounds out the panel. So we will now open it up for questions. Seeing no questions from the one more question. All right, Senator Sidnor, almost got away.
Thank you. Oh, two questions. One, I mean, I would love to get rid of indemnification clauses, period, for everybody. I think people should be responsible for their own work or their own negligence. But I'm curious for Mr. Rabber. Hopefully I'm pronouncing your name correct. I was just reading through your testimony, and I believe in it you had noted that if a design firm agrees to a duty to defend in an indemnification clause, any claim by an indemnity as an immediate defense would trigger the contractual liability exclusion. What I'm curious, from my understanding, a duty to defend and a duty to indemnify are two different things. So but this bill is about a duty to indemnify, right? It's both. Okay, I just reading Senator West's mouth and I'm not an insurance professional, which is why I'm asking the question. Are the firms that are trying to be that would be protected under this bill, would insurance not cover that duty to indemnify?
Go ahead, Mr. Harbor. Senator West, you're also unmuted if you want to chime in.
Senator, I'm happy to go after you.
Why don't you go first? This is an insurance question and you're the expert in insurance.
Sure, I'm happy to. Yes, so Senator Sidnor, your question about whether the indemnification would be covered by the policies is a good one, and yes, it should be. To the extent that the design firm is found to have been negligent by a court of competent jurisdiction or perhaps a settlement, was how this happens in the real world. To the extent that this negligence is established, absolutely not a coverage problem for indemnification. It's only that duty to defend. Well, there's two things. It's the duty to defend, which typically that gets covered under a contractor's GL policy by the contractor making the owner an additional insured. But that avenue just doesn't work for design professionals because the insurance industry hasn't allowed that. The carriers just don't want that risk, and so they haven't written their policies in such a way. But the indemnification after the fact, after negligence is established, is absolutely covered for the design firm's negligence, and that would include defense costs. So reasonable defense costs spent in defending that claim, to the extent that the owner can prove that the design firm was negligent, those are covered by the policy, no problem. So it's just that duty to defend. And then the issue of indemnification for non-negligence. And that's where those are the two things that this bill would do. So it basically says that you can only the design professional can only indemnify to the extent of their negligence, and they're not allowed to be required to have a duty to defend. Those are the 2 points.
Thank you.
Yes, sir.
All right, with that, looks like we are wrapped up. That concludes the testimony for Senate Bill 189. Thank you, Senator West. And with that, that's it. We're just shy of 7 hours, or just over 7 hours today. You all tomorrow morning. Have a good night.
Okay. Thank you, everyone.